And I would also like to think that it satisfies most, if not all, the concerns that have been raised. So I worded the question different based on what you said, Mr. Booth, yesterday, like there's assuming there's a duty. I will explain, why I did things as we get into more detail, but it should encompass every potential breach in the standard of care that has been presented by the plaintiffs. And I'll explain, for example, why something wouldn't have been in there. And so, again, that's going to take a lot of time to sort through. So if you guys want me to explain that today and then you have time to think it through, that's the other thing is, Mr. Guzzi, see what I'm saying. They're not that good. I mean,
well, the only reason I asked is because if you do, and we can have it printed out, then we can start going through those. Some of these are favorites for that. And I still have a couple of my office still working on a couple of custom questions to address the DNR issue. 10-23% structure. That structure, the way it's drafted, does not fit the DNR.
Okay.
As soon as we have that, I'll provide it.
That sounds good. Anything else? You're taking the cross-examination.
Correct.
Apparently, the jury's on their way down.
Well, good morning, everybody. Started a little early, so we're just going to get ready.
And welcome back. At that point, you're going to be excused for the day, and then the attorneys and I will finish up on the jury instructions and verdict form, and I'll talk with you more whenever it finishes today to let you know what the plan is. But if you remember yesterday, the defense had Dr. Schara on the witness stand. He had finished his direct examination, and so it's now the opportunity for the plaintiff to cross-examine Dr. Schara. So, Dr. Schara, if you want to come back up to the witness stand, and because it's a new day, I'm going to have you raise your right hand again, and the clerk will swear you in.
I swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God. I do. Please have a seat.
All right, Attorney Fleiter.
Good morning, Dr. Schara.
Good morning.
I want to start, Doctor, with a few things we heard from Holly McGinnis. Nurse McGinnis testified that at the time Grace was in the hospital, physicians were doing paper orders. Now, we didn't get any paper orders from the hospital. Is there some reason why we would not have received those?
Overruled. Go ahead.
Not sure what physician orders. Majority, I would say, all the orders I would place, or most physicians would place, would be in the EMR, the electronic medical record, through Meditech, which was the EMR that we were using at that time.
Okay.
The physical orders were things that likely could not be, were not like the templates or anything that was not already preloaded into that electronic medical record. You could then find in the chart.
The paper chart.
Correct. If there was something that was not in the EMR, you were unable to put it into the EMR, then you could find it in the paper chart.
Got it. Dr. Shokar, you're familiar with the concept of MAP, or mean arterial pressure.
Sure, yes.
You call that MAP or MAP?
Yeah, MAP is
MAP.
kind of the lingo.
Okay. What is considered a critically low MAP?
Anything under 60 is generally the cutoff that we use. 65 is the safe cutoff. So it's somewhere in between there. So in critical illness, we use 65 as the cutoff. In general care, we use about 60.
Okay, and I'm not a doctor. So 60 would be considered critical. Is that what you're saying?
You wouldn't want it under 60.
Okay. What about like 55?
Under 55 is you're not. So it's a measure of perfusion essentially. You know how much blood pressure you have on average. So under 55 would be deleterious to the patient.
What about 50, doctor?
50 as well would be not good.
Yeah, really not good, right? Like you could die.
As you get lower than 60, you have a higher and higher chance. Yes.
Doctor, we heard testimony from Nurse McGinnis that Precedex was at a rate of 0.9 on October 8th, and that was the highest rate of Precedex on October 8th. We also heard Holly McGinnis testify that giving Precedex on October the 8th would not have raised any red flags, and that the Precedex was acting as expected. You were here for that testimony, correct?
I believe so, yes.
You remember from your review of the records, actually, though, that Grace had an MAP of 50 on October the 8th?
I'll take your word for it.
Would it help you if I showed you the record?
Be fine.
Probably,
yeah.
right? Linda, what's the number we're putting on the Oh, yeah, sure. That'd be great. No, 3? Borrow that pen.
Thanks.
Can you please tell the jury what that document is?
This looks like an order for norepinephrine.
Norepinephrine, that helps get the blood pressure up, right?
Correct. It's an agent that can raise the blood pressure.
You see on that record, doctor, it's on, right? Oh, boy. Okay, you can see on that record, doctor, that on October 8th at 15:49, Amanda Middleton initiated norepinephrine, and at that time, the MAP was 50, correct? You see that?
That's what's listed. It says 50 if applicable.
Okay, well, they all say applicable, right? Assuming that this record means that there was an MAP of 50, you would have to agree that Grace's blood pressure was in fact critical and life-threatening on October the 8th, correct?
MAP supports the use of norepinephrine to raise it back up above 60.
At that, I understand what the norepinephrine was used for. My question to you was, on October the 8th, based on the testimony you just gave about the MAP, Grace's blood pressure was in fact at a critical level. You said critical was 60.
Right. So her blood pressure had dropped down an MAP of 5. Do you know the duration of how long it was there for? Because again, you have to take it into how long someone's low blood pressure and how long that's going to cause injury. Because you're saying life-threatening, it could lead to a life-threatening event if it was not corrected.
Well, you're saying that now, doctor, but before when we just talked about it, you didn't say anything about, oh, well, just if, you know, it's there for long enough. You said an MAP of 60 was critical.
Right, and MAP of 60 pretends to not, it essentially leads to, it's a low perfusion situation. So that's something that you'd want to correct.
Are you saying that having an MAP of 50 is an expected side effect of Precedex?
MAP of 50 confers that the blood pressure is low and it needs to be corrected.
Yeah, of course, right? Yeah.
But you're correlating that to Precedex, and that's, you know, again, I wasn't there in the events at that time, so I don't want to speak to as far as the full events for that. All I know is that her MAP, yes, was 50, and it was appropriately corrected with norepinephrine.
Okay. All right. I think we got it. Doctor, no one told you about this event when you took over care of Grace. Is that right?
It was not in my report with Dr. Baum. It was something that I discovered as I was doing a chart review on my 2 days with her. Okay,
you did discover this.
I discovered, so when you do a chart review, you start at the current date and you go backwards. So I do like to go over the full chart.
Okay, so when you were treating Grace, you in fact knew that she had this blood pressure event on the 8th? Is that what you're saying?
I knew there was an event, a lower blood pressure, I knew there was a need for medications of norepinephrine earlier in the hospitalization.
Okay, well, when you testified last week, and I'm going on memory here, but I think this is right. I'm pretty sure you testified that after the 7th, there wasn't any more problems with Precedex.
You asked me if there was overdose events, and I said on the 7th there was an oversedation concern, and then I think the Mr. Administrator said no, there was one on the 8th as well, which I disagreed with.
I think you said after the 7th there was no more problems with it. I don't think you were asked about an overdose.
You were asking a question about, as far as I understand, you were asking a question about overdoses that she had previously.
Dr. Shokar, have you heard the phrase, past performance is the best indicator of future results?
I've heard of it before.
And what that means, doctor, is, you know, we can look at things in the past and that can help us sort of analyze or predict what might happen in the future. Is that your understanding of that phrase?
Yes, and that's what we do in medicine. We look at the historical context, history, physical, those kind of things to come to what we do in the future.
Of course, yeah, and the history of the medications, I would assume, is also part of that history, right?
I would assume so, yes.
And in fact, you would agree that a patient's history with the drug can be valuable insight into how a patient will respond to that drug in the future.
The medicine.
Is that a yes?
Yes.
Who is responsible for titrating Grace's Precedex on the day she died?
The ICU nurse, Holly McGinnis.
Who was responsible for helping Grace go to the bathroom on the day she died? Was that you?
That would be her bedside staff.
Okay, would that include Holly McGinnis? Who was responsible for monitoring Grace's vital signs on the day she died? Was that you?
That's a team effort. The one that is at bedside would be the ICU staff once again, and myself when I'm there.
And that would include Holly McGinnis?
Correct.
Did you rely on Nurse McGinnis's monitoring to form your diagnoses on October the 13th?
Her feedback into what's going on at bedside through all hours of the day is valuable for me to make my assessments.
Is that a yes?
Yes.
Based on your memory of Grace's treatment in this case and your experience at St. Elizabeth, what medical provider would have spent the most time in Grace's room on the day she died?
Can you clarify that? Medical provider as in physicians or nurses?
Yeah, either.
So I was attending on, so I would be spending time with her in the capacity as a physician. Her pulmonary critical care doctor, Dr. Gandev, was there as well, providing critical support and a lot of direction to the ICU staff. Her infectious disease doctor, Dr. Zymet, was there rounding as well to give support in regards to considerations of infectious disease. And then her nursing staff was there. Holly McGinnis was there to provide the bedside care ongoing through the day and relay information.
Got it. Of those people who spent the most time in the room?
As expected, the nursing staff would have spent the most time, so Holly McGinnis.
Who was responsible for administering lorazepam to Grace on the day she died?
I'm sorry, which time? Like all the nurse, the ICU nurse usually administers the medication. That's their job.
Okay, well, what times were lorazepam, what time was it administered? Do you want me to pick up the chart?
No, I think everyone has a good understanding. There was one dose in the afternoon with the NG tube, and then there was a dose at about 5:45 p.m., and then another dose verbally ordered by myself around 6, or I think right after that.
Right, I think everybody has an understanding of that too. Who was responsible for administering the lorazepam at those times?
Yeah, as I said, the ICU nurse is the one that gives the medications.
Who's that?
That'd be Holly McGinnis.
You ordered the lorazepam on October 13th, right, at 5:49?
The verbal order I gave to Holly McGinnis listed as 5:49, I believe it is.
How long does it take lorazepam to get peak effects? About 10 to 30 minutes, right?
Yeah, it has a variable on peak effect, but generally you start seeing effects within 5 minutes.
Effects, I get that, but the peak effect is between 10 and 30 minutes, is that correct?
Yeah, variable per person, but you can argue for that, yes.
Okay. But you only waited 3 minutes before the second dose, doctor. So you really didn't know what the effect was going to be, right? There's only 3 minutes between the 546 dose and the 549 dose. You just told me that peak effect can be between 10 and 30 minutes, right? So the peak effect for the 546 dose is going to be 10 to 30 minutes later, and yet you order lorazepam again 3 minutes later without knowing what the effect of the first dose was going to be. Isn't that right?
No, that's incorrect. As I talked to it last time, the timing to me doesn't really make sense as far as what's listed, given my conversation with Holly, who had already given the lorazepam prior to calling me or paging me, and then me calling back and having that conversation, already reporting that she had given it and observed her, and essentially that she, what to do next. And at that point, I was worried that, okay, well, we do need to get this situation under control in a time-dependent manner, and so that's when the second order was given. So my goal was then to go down there, which I believe was 5 to 10 minutes afterwards, and assess.
Well, let me ask you another question. You just said the timing doesn't make sense with the 3 minutes, but you're the one that just told me the times. Okay, so are you saying that now not only do you challenge the timing of the Precedex and the morphine, but now you're also challenging the timing of the lorazepam?
I didn't challenge the Precedex timing. The only statement I was making during my adverse examination was that to me, the timing between 3 minutes didn't really make sense to me. And I was questioning it just based off of my conversation with Holly on the phone and the amount of time it does take to converse that, understand what the situation is, and then give a verbal, and for her to, I presume, then
Yeah.
get off the phone, go get the lorazepam, then administer it,
so
which
let me just-
would take a certain amount of time, more than 3 minutes.
I appreciate that. I just want to clarify here because my memory is that last week you testified that the Precedex was shut off before the morphine, but that's not how the record reflects. And so you said, I challenge the validity of that record because I was in the room and I saw Holly McGinnis go to the machine. I don't know if she turned it off or not, I think is what you said, but you saw her go to the machine. And that's why you challenged the timing of the Precedex. And now I think for the first time we're hearing that you also challenged the timing of the lorazepam in the record.
No, you are correct. I did say that last time with the Precedex, because when I first came to the room, that was the first thing I turned off, and I apologize for that. But the Ativan, no, we talked about it last time as well, and my concerns and opinion about the fact that the 3 minutes just doesn't seem correct. And I wondered at that time, as well as I do now, why you have 2 doses listed 3 minutes apart when clearly there was enough elapsed time between the two. But even after that, let's say I did order the, whatever time is listed, it did take me 5 to 10 minutes to get to the room, in which case then I started my evaluation, which would have given a good amount of time for me to assess. And I turned off the Precedex, still waited. The morphine administration wasn't done until a few minutes after that as well. So there was enough time to assess for Ativan.
I got you. And I guess my point was the record reflects only 3 minutes before the first and second dose. Peak time, 10 to 30. If I were to believe the record, it would reflect that you did not wait until the peak time until waiting to see the effects, right?
Even with the 2 doses, there was enough time that elapsed before the administration of morphine to assess for peak time.
I'm not talking about the morphine. We're going to get there. I'm not talking about it yet. I'm talking about the 2 doses of lorazepam 3 minutes apart. You understand that?
Do.
Okay. We're going to get to the morphine. Nurse McGinnis testified via the medical record with my friend attorney Frankowiak that there were no further interventions available at 4 p.m. on the day that Grace died. Who was responsible for administering morphine at 6:15 after there were no further interventions available?
Who gave the morphine as far as
yeah.
actually administered it?
Yeah, who was responsible for that?
That would be Holly McGinnis, once again.
And then in fact, she died less than or within an hour of that morphine, is that correct? I'll withdraw it. She died within an hour and 15 minutes of the morphine, right? 6:15 to 7:27.
Yes, I would say that's roughly accurate.
Roughly accurate that it's within an hour and a half? Or an hour and 15
hour
minutes?
and 15 is what you said, right?
Yeah. We heard testimony from Grace's sister that she pled with nurses to save Grace, but no one came in the room. Based on your experience at St. Elizabeth, wouldn't you have expected at least one nurse to go and get a physician?
Objection, may I be heard, Your Honor?
Sure. questions on this. So eventually when you get the verdict form, you're going to be asked to answer a lot of questions, but one of those questions will definitely be on the standard of care for the nurses. And you'll have to determine what the standard of care is, and then you'll need to determine whether or not it was breached. So it would be improper for this witness to comment on what the standard of care for nurses was in October of 2021. And I'm not going to allow that. But I am going to allow you to hear what this witness's experiences were and have been when individuals revoke DNR orders. What is his experience? What happens? How does it happen? Because we've already talked about it in this trial, and you've heard about it from all parties. And I think it's appropriate for you to hear what Dr. Schara thinks on that, if he has experience with it. But that, again, is completely different than what the standard of care is. The standard of care will be something that I'll instruct you on, and it'll be something that you'll need to determine. So with that being said, Attorney Fleiter, I think you need to lay a foundation first, and then you can go ahead and ask the questions consistent with my decision.
Judge, Dr. Schara, you were a physician at St. Elizabeth Hospital in October of 2021?
Yes, I was.
We've established that. How long had you been there at that time?
2020, so a good year, I would say.
Year and a half or so?
Yeah, about that.
Okay. And in that year and a half that you spent at St. Elizabeth prior to treating Grace, did you have experience with DNR orders or DNI orders?
Yes.
Okay. And it was your understanding that a DNI or DNR order could be revoked at any time, is that correct?
Correct.
Okay. And if a patient at St. Elizabeth was coding or crashing or having a rapid deterioration of condition of some type, and that patient was, for some reason, a DNR, and then the person with the power to revoke or terminate that DNR said, I'm terminating, she's not DNR. Okay, how quickly does that sort of direction take effect?
That's a good question because it's situational. It might help if I explain what normally happens.
It might.
Okay. So normally when someone's deteriorating, we call a rapid response, and you might hear that rapid response in the hospital where a team goes and assesses the patient, hopefully catching before they actually have a code. And if we aren't able to do that, or someone's DNR, DNI, we get a call, like for instance, I get a call to go and assess a deteriorating patient without announcing that overhead, because we know that the whole team doesn't need to be there to intubate because that was not the direction of care. If someone just all of a sudden arrests, then a code blue is called in the hospital, where we have a code response team, and the design of a code blue team is so that everyone is paged for that emergency, and that includes the doctor that will go there. In the absence of if you're not going to call it code blue and you have someone who's already established as a DNR, DNI, then a code blue would not be called. And so you don't have that immediate messaging to everybody. You would then have to go through paging the physician to have them come to the bedside, which is what happened in this case, where I came over, in this emergency situation to try to help. If there was a code in the same situation that was happening, or again, a no code, but let's say that the event happened, the same thing would apply then, where a nurse would have to page a physician to have them come to bedside. Page, respond, come to bedside in that capacity, given that there was a no code on and the understanding. Now, there are situations where if you have, like, as you're saying, a POA or somebody that's there and they're trying to revoke it, the same thing would apply. The only difference in that situation is depending on the context of the patient's, as far as what the nursing staff would know in regards to, would it help that patient or not. Like if you had a futile case such as this, you would have essentially an understanding from the nursing side and the physician side that in an emotional situation and non-logical thinking at that point, right? Because that's why we have these conversations before, to understand these conversations in direction with logic and, you know, in a non-rush capacity, because we know that in a situation where emotions are running high and at the end that you have people essentially pushing for things, right? But if there's an understanding futility, then you wouldn't, your decision tree would go down to paging and having a provider call.
So doctor, are you saying that you would not have expected any physicians to come in this case when the daughter or the sister is screaming for help and that she's not DNR? You said a lot of things there. I'm trying to get to an answer.
Hold on. Objection, Your Honor. It's the discussion.
I'm going to sustain, and I think you can continue, but you need to ask appropriate questions.
Your Honor, do you think it would be okay if I had that question read back to me so I can understand? I can't remember exactly how it worded. I don't want to.
You worded it with expectation,
Oh.
Which was the same way you had worded it prior to the sidebar.
Is the objection foundation at this point? Or
I think the objection is what they said during the sidebar. Is that what you said? And so again, you can ask questions on that. I just think you need to word those properly, because just so the jury knows, I'm not going to allow this witness to comment on his expectations, because it may set in your mind some standard of care on what should have been. He can testify about his experiences, his background, what happens when somebody revokes a DNI, but not about expectations or standard of care.
okay. Let me try to ask a different question.
And again, that's going to be for you to decide.
Describe, doctor, some situations that would occur in the case of a family member or somebody properly or attempting to revoke a DNR order. It sounds like you would anticipate at least a response. Is that fair?
Objection. Same issue.
Overruled. Go ahead.
Sorry, a response?
Yeah.
If someone's communicating to you, then yeah, you give a response.
Dr. Nurse McGinnis testified that the family was on FaceTime with you at bedside when you decided to give morphine. In fact, you did not talk to Scott until after the morphine was already given, right?
Correct.
Okay. Nurse McGinnis testified that she did not stick around after the morphine because she thought Grace's condition was stable. Do you agree that Grace's condition was stable after the morphine on October 13th?
After the morphine, her vital signs improved, and we were able to stabilize that crisis situation. She was still critical, obviously, but we were kind of through that event, which was, with the morphine administration, essentially everything improved. We monitored, and then I left the room. I believe Holly was still in the room, I believe, when I left, because I went to go talk to Scott, and maybe she was charged or something at that time. But does that answer your question, sorry?
I don't think so. Was she stable or not?
She was stable from that crisis.
Okay, but what about just generally stable?
She was critical. I mean, she had been critical all day. Right? She could crash anytime. I had mentioned that.
And I think Nurse McGinnis said that she stopped caring for Grace at 7 p.m. And in fact, she wasn't stable. Grace wasn't stable because Grace died 27 minutes later. Isn't that right?
Like, it sounds like she had another event, yes. Which often happens. That's the problem when you have critical patients. You can have.
She didn't receive any treatment after the morphine, right? Was that the last thing?
My administration of morphine in that crisis was essentially digging deep and really the last things that we could do.
Digging deep. Doctor, I want to talk about some notes that you discussed yesterday, your progress notes. You go in and do an evaluation, you write this note that we saw up on the screen yesterday, right?
Yes.
It's got your plan and your evaluation and all that, right? Yes?
Yes.
Just want to make sure everybody's clear on the timeline here. You treated Grace on the 12th, correct?
Correct.
Okay. What time did you make your rounds on the 12th?
I'm twice. One was in the morning. When essentially, if you look at my notes and when I write my notes after I see the patient. So sometime before I wrote my first note is when I rounded on Grace. So best of my recollection, I chart review in the morning. I go see the critical patients. So it would have been sometime around 9 in the morning that I had seen her, 9 or probably around 9, and generated my note thereafter, the morning note. The second time I saw her was briefly, only to get a clinical status update prior to calling Cindy and Scott, because I usually like to see the patient to give them a updated clinical report.
Sorry, what time was that second one?
For my conversation with Scott and Cindy, which would have been, I think, in the afternoon, 4 o'clock-ish or so.
I want to do the same thing with 13th. Take Grace died. What time did you do rounds?
Again, in the morning. I would have done morning rounds prior to having a discuss. Well, around that time that I had a discussion with Scott.
Okay. What time's that?
Hard for me to say. Probably roughly around time, same time, 9, 10 maybe. Oh, it was around 10 because I believe Jessica was coming back from taking a shower or some. She was coming back at that time. Okay. So around that time. I just saw her because she wasn't in the room when I saw her on the 13th, and she had come back.
Was that the first time you saw Jessica on the 13th?
I think I saw her on the 12th and got a report from her, or briefly just discussed on the 12th in the afternoon.
You got a report from Jessica?
She was sitting at bedside on the 12th.
What did she report to you?
Just general, how's she doing? She's doing good today.
You appropriately documented all your interactions with Grace in the record, correct?
I believe so.
And you appropriately documented all your interactions with Jessica in the record?
I believe so. Usually in my subjective, if I see someone bedside, I would mention it to there if I was going to mention it.
And then last one, you appropriately documented all your interactions with Scott and Cindy Schara in the record, right?
Correct.
I want to look at one of your notes here. This is from 10/12. Are you able to see that?
Yes.
Now here on the plan, you talked about this yesterday. Oh, first let's look at the plan. This is the plan here, 1, 2, 3. And they continue here, 4, 5, 6. Number 6, you talked about yesterday, you said, oh, well, we weren't really trying to do physical therapy or occupational therapy. This is like something that's in all the notes and it's like a long-term thing. Can you explain exactly why you would put plans in here that aren't, something that you're actually trying to do? I mean, if you wanted a long-term plan, you say, well, full recovery, right? That'd be like a good thing to put on a long-term plan. So can you just explain why you're putting something in a plan that isn't really something you're trying to accomplish?
Sure. So general hospitalist notes are different than specialist notes. Specialist notes essentially go targeted for their specialty, for instance. So there's a contrast to those type of notes. But general physician notes, if you have ever been in the hospital, for instance, you'll see that their notes are much more extensive, going through more problems, acute and chronic, and PTOT. I usually put. She had signs that she was in the bed for quite a while. So it was anticipated that in the future we would have to have PTOT involved to see what her physical capabilities were for her to be able to get out of bed, walk around, and be discharged from the hospital at some point if we were to get there. So it's listed as my last problem, and there was no explanation past it, which was essentially how much credence at that time I had put to it. I didn't even write out physical therapy.
Yeah. Doctor, you didn't sign this note until 4 days after Grace died. Right. Isn't that correct?
Yes, that's what it says there.
I want to move on to Exhibit 222. This is your note from the 13th. You see that?
Yes.
Now, I listened to you just talk about why you put PT in the plan and how it's really just something you're trying to do with everybody, but you got rid of that in this plan, right? The next day you thought, well, no more long-term goals, huh?
These are dictated notes. So, I'm dictating quite a lot of information. You see there's 8 problems here. Much more extensive problem list now that I've seen this patient 2 days in a row. And so I could have put number 9 PTOT, but I think there was a lot of information to go off before that.
Yeah, doctor, maybe there was something unexpected happening on the 13th, around 12:57 a.m. or p.m. here when the Precedex was up to 1.4. Maybe that's the case?
Overruled. Go ahead.
I'm sorry, I'm not really clear on what you're alluding to.
Yeah, well, the day before you're having long-term plans, all of a sudden on the 13th, no more long-term plans. And this is dictated at the time.
Right.
Precedex was turned up to the max about 2 hours prior, right?
The October 12th note, as you remember, was my morning assessment. The first time that I was seeing her. Events started to transpire after that note. Where our BiPAP settings were up to 12 or 20 or 15. We had extensive conversations. This is the next day's note. So there's the context is different in how I'm generating that note.
Well, this is the plan, right? At the time you wrote it?
Yeah, this plan is much more extensive. Based off the information that I had gathered over the last day.
Dr. Shokar, has anyone ever written on your behalf the statement that, quote, Dr. Shokar did not place any orders for lorazepam or Precedex?
What basis? So this is a point in time where apparently I made a ruling on this a couple weeks ago, and I don't remember exactly what I ruled. So I think I understand what I ruled, but I'm being told two different things. So we're gonna take a break, and I'm gonna have to review some transcripts. So use this as a morning break. It'll be probably more than 5 minutes, and I don't know if the personal needs can be done then, or if it'd be okay. So then we'll get you back in here as soon as we're done with that, or if it takes a long time, we'll just keep you posted. So we'll update you in 5 or 10 minutes. The jurors are excused. You may be seated. Right. Dr. Shokar, you can step down and go back with Mr. Guzzi for a few minutes. So so let's just talk about the first sidebar, and then we'll get into the second one. During the first sidebar, Attorney Guzzi and Attorney Frank Toliak, you took the position that it was improper solicitation of Dr. Shokar to provide opinions on the standard of care. You cited alt violations, and the fact that you had to raise it during a trial was an issue too. I think plaintiffs, you disagreed with that and argued that you should be able to get into it. And I explained to the jury what I was going to allow, so I think I explained to the jury similar to what I explained to you guys a couple of times. So anything you want to say regarding the first sidebar?
No, Your Honor.
Okay.
Correct. We'll send in the record.
All right. And then during the second sidebar, Attorney Guzzi, you indicated, that this is the letter that you submitted to DSPS back on or about August 23rd of 2023. And I'm trying to figure out if that's been marked as an exhibit. We're going to have the clerk pull it and let us know what number that is. And during the sidebar, Attorney Guzzi, you had indicated that it was something that I took under advisement, and yeah, and I don't remember that exactly. I didn't want to tell the jury, but my recollection was I took I think I agreed with the plaintiff's version of it. So during the sidebar, the plaintiff said the thing I took under advisement was the curative instruction, but they would be allowed to ask Dr. Shokar the question on whether or not somebody made that representation on his behalf. And if he answered that yes, which would be consistent with your letter, then that was the end of it. So assuming that he answers the question yes, they would move on and there'd be no more questions on it, correct?
That's correct.
Okay, and then it's up to you if you want to dig deeper into that. During the sidebar, Attorney Guzzi, there's really no relevance. It's you did it under different circumstances. He testified, I think you said 6 different times under oath, and during all 6 times of his testimony, he testified the same as what he did during this trial, which was that he verbally ordered it. You also indicated during the sidebar that he only briefly looked at this letter. So, all those things that we've argued. So I think you can clear that up in your redirect if you want. Okay. Sure.
Do you know whether this document was submitted to the DSPS? Answer, I don't know that for a fact. I know that it was sent to me prior to or along that process of the complaint, because Mr. Guzzi was the one that was helping me out with that. And you mentioned the question, you mentioned that you did review this document. When you reviewed this document, you find that it was accurate. Answer, after objections on as to the relevance. But when I reviewed the document, I was happy with it. I didn't dissect it to a degree in which I could verify every aspect being completely accurate. but the overall context I agree with.
Keep reading a couple more.
I know. I don't give you instructions, sir. Question, was there anything in this document that saw that you believe to be inaccurate? I would have to review it, to be honest. If you mean at that time, yeah, at that time. Answer, I signed off on it, so I'm assuming no. That is a far cry from an admission that he reviewed every jot and tittle of that letter to determine whether it was accurate or not. So, and he, in his testimony, he testified he didn't know where it was being sent at the time. So for them to make the leap now, ask that question based on his deposition testimony, it's based on an inaccurate assessment of his deposition testimony, the reading of his deposition testimony, and they've left out the fact that his deposition testimony is littered with instances in which he admitted to placing the verbal order for lorazepam in this trial, I don't know, 15, 20 times. That's his testimony. There is no impeachment here based on that deposition testimony.
Yeah, I appreciate all of that, and I think we've argued that, but I don't think they're using it to impeach his deposition testimony.
No,
Okay, so let me just sort of explain. So I understand that based upon his deposition testimony, even, and what his testimony would be here, but I'm not going to allow him to say that he signed off on it unless you want to. But the question is, was there a time when someone represented on your behalf that you did not place any orders for lorazepam or Precedex? And the true answer to that is yes.
not, because that's, as Your Honor noted, when you
Okay.
the letter.
I wasn't finished, but go ahead.
Oh, sorry,
Okay, I mean, I think the true answer to that is yes, because if you look at it, you say Attorney Guzzi represented this on behalf of Dr. Schokar, and Dr. Schokar testified during his deposition that he signed off on it after briefly reviewing it. That's the truth. And so if that's the truth, you go, well, I don't know if we want to revisit this whole DSPS thing. I don't know if we want to get into the attorney-client and what you were doing on his behalf. So my ruling back then, I don't think I took it under advisement. I thought my ruling was that they will be allowed to ask the question on if somebody made that representation, and keep it general, so it's not pointing fingers at you, Attorney Guzzi. It's not bringing up the DSPS. And if his answer is yes, then that's all they get. And then if you want to clean it up on redirect and going in and explaining all the stuff that you just explained, then I'm going to leave that to your choice, and you can strategically decide that. But I think it is important, given what has just been said, that the jury can hear it. They might disregard it, they might not care, but it's relevant.
I will say one thing.
Okay, all right.
Number one, this court has consistently talked about relying, once there's testimony in the record from the court, even based on the deposition testimony, what is specifically stated that the relevant testimony is the primary testimony ought to be what's been given in this book. Okay. Number two, Your Honor noted at the time we had this discussion that there was some gray area as to the accuracy or inaccuracy of those statements in the letter. I.e., if you look at the record, there is no record, written order by Dr. Schokar for the lorazepam. Both of them show up under fact. Okay? And so I just, that's my record. The court is going to proceed on this.
But I think that's a good.
I think that the answer will be yes, and then I will follow up on it if needed.
And again, I think I'm glad that you made the record, because I think it's understandable that somebody like Dr. Schokar just signs off on something you sign that's 8 or 9 pages long, and you misrepresented it. And you did it probably by accident. I'm not saying it intentionally, you know. Well, you stated something that Dr. Schokar, you stated something that is different than Dr. Shokar's testimony. And we all make mistakes, right? And so you're going through records, you know, years ago, and you make a representation. I wouldn't let it in other than he approved it. And so then the jury can decide whatever way to, but I'm not gonna allow them to clean it up and blame it on you and what it was and the context. I'll let you do whatever context you want on that. But if you open the door on the context, just keep it consistent with his deposition testimony, and then I'm not gonna allow you to dig deeper unless it's some error or, you know, some mistake. So that's gonna be the decision. We can
Your
put
Honor,
the jury. Yeah, go ahead, Mr.
just a
Slider.
clarifying question. If Dr. Shokar says no, it's open.
Yeah, I doubt he's going to say.
I do too, but if it
Okay.
happens, I don't want to have to, I don't know what he's going to say, but I assume he's going to say yes. Yeah, I just
Then
wanted
you
to be
gotta,
sure.
then you have to move on, and
Sure.
then Attorney Guzzi can decide how he wants to handle it. And it's probably, so the question that you asked, I know you have it written down, is what?
Dr. Shokar, has anyone ever written on your behalf the statement that, quote, Dr. Shokar did not place any orders for lorazepam or Precedex?
Okay, I think that's consistent with my ruling.
Yeah.
All right, Dr. Shokar, you can come on back up to the witness stand. We'll still give the jurors a break around 9:30.
Oh, yeah, thanks.
All right, everyone may be seated. You know, welcome back and sorry for doing that. You know, I now know how those officials feel when they're in the replay booth and they're looking at their previous call, right? So I've made my decision. And just to let you know or get you comfortable, we're still gonna give you that break at 9:30-ish. So, you know, that wasn't your morning break, and I know some of you have things to do. So we'll take a break in about 30 or 35 minutes. So before you took a break, there was an objection. The objection's overruled. I'm going to allow Attorney Fleiter to ask the question. Go ahead, Mr. Fleiter.
Dr. Shokar, this is the same question we asked before the break. Has anyone ever written on your behalf the statement that, quote, Dr. Shokar did not place any orders for lorazepam or Precedex?
Yes.
No further questions.
Okay. Back to you, Attorney Guzzi.
Dr. Shokar, with regard to that question, you give opposition in this case.
Yes.
In your deposition, did you ever deny giving a verbal order to Holly McGinnis to administer lorazepam at 1749? In this case, in this trial, you've been on that stand twice. You've given sworn testimony. At any point in time, have you denied that you gave that order for that, a verbal order for that dose of lorazepam?
No.
You've made it very clear to this jury, to this court, that second order was a verbal order given by you to Holly McGinnis. Doctor, as far as the DNR order is concerned, that is an order entered by a physician.
Yes.
In this case, it was you. That order can only be revoked by another physician.
Correct.
In your case, or in general, it doesn't necessarily have to be the doctor that actually placed the order, right?
All right. What do you mean?
If, for example, you are, we'll give you the hypothetical, a situation where an individual wants to revoke a DNR that you placed in the record, and you are not at the hospital, can another physician, if requested, revoke that order?
They can, and any physician can revoke that order.
The bottom line is the order has to be revoked by a physician. It cannot be revoked simply by the nurses.
Correct.
You were asked some questions about Holly McGinnis and your interactions with her on October 13th. Based on your recollection, what you have in your notes, was Holly McGinnis fully communicating to you all the information that you needed to know about Grace Schara's condition?
Yes.
Thank you, doctor.
Attorney Frankowiak?
Doctor, just a couple of questions to clarify. You've reviewed the records in this case, and they were records from the EMR, electronic medical records,
Correct.
and they were a complete set of records, and you were able to tell that there was nothing missing from the records.
As best as my knowledge.
Okay. Medications have side effects.
Everything has side effects, yeah.
Okay. And obviously in an ICU, their medications are closely monitored in the ICU setting.
Yes.
And there are known side effects for certain medications.
Yes.
Okay. And you were asked some questions about, some medication, some norepinephrine that was given. It's expected that, a patient for any number of reasons might need to have their blood pressure assessed and perhaps modified if they're in an ICU setting.
Expected.
Okay. And that's not particularly unusual in an ICU setting?
No, that's what they do in the ICU.
Okay. And that would not necessarily be something that would be considered an unusual situation if indeed an agent had to be given to a patient for whatever reason in order to, bolster a blood pressure under any sort of circumstance.
No, they have the capability of doing that. The bigger problem is when someone's on the floor, not in the ICU, and there's a delay in trying to get them to the ICU to do rapid interventions like that easily.
Sure. And when they're on the ICU, obviously that's where we have the
It's an expectation.
Yeah.
You should do that because you have the capability.
Okay, thank you. That's all I have. Thank you.
Go ahead, Attorney Platt.
Thank you, Judge. Just had a few questions. Doctor, you were talking about medications with Attorney Frankowiak, and it reminded me of something that you said yesterday. I think you said something like 2 milligrams of morphine is like 2 Tylenols.
All three.
Tylenol 3s. Okay, so this isn't like regular Tylenol, right?
Sorry. Tylenol 3s it's like 325 milligrams of Tylenol in conjunction with 30 milligrams of codeine
Okay, they're narcotics.
as a combination medication with Tylenol and a opiate class medication like codeine, which is
A narcotic.
a narcotic.
You also said, Dr. Shokar, that Grace was on, I think, I want to talk about the medications on the 13th, correct? I think there's a board over here. Jason, Attorney Frankowiak, can I use your board real quick?
I think that's exhibit 448, right?
It's marked as 448.
Do you mind? Can I use it? Permission to.
You may.
Here at 7:30 a.m., Precedex went from 1.0.
She was higher than 1.1 at some point.
She was.
Yeah. After that dose, right? I think she went all up to 1.4. Yeah.
Fair enough. So then this would be the highest dose up to that time.
Up to that time, yes. Yes,
And
you're
then this
correct.
would be the highest dose up to that time.
Correct, yes.
And then I assume this is the next day. Grace had never received lorazepam this close together, had she?
In her hospitalization, she had not.
And she never received it before, right?
She had not, no.
For now.
Anything?
Thank you.
Commissioner Koyak?
No further questions.
All right. Does the jury have questions for Dr. Shokar? Okay, it looks like 3 hands. uh, 580, the questions from juror 2746. And then exhibit 581 are the questions from juror 587. And I'll mark as exhibit 582 the questions from juror number 262. Doctor, the questions are the following. On the phone call with Mr. Schara on October 13th after the morphine was given to Grace, you're familiar with that call?
Yes.
Did you tell Mr. Schara that the only thing that could be done at that point to save Grace's life would be to put her on a ventilator if her condition got worse?
We actually had that conversation prior. It was not something that I revisited at that time. It was more of a breakdown of the events that had happened, her clinical situation, and the effects of the morphine in her, which has stabilized her condition at that time. It was about I think a 10-minute call.
So during that call, there was no discussion about it?
There was no discussion at that time in regards to revisiting intubation.
And then the next question is, was this discussed with Jessica at that time?
No, my primary contact person that I was going through was Scott. He seemed to be the person that I had created the most foundation with, and was the major decision maker of all the family members. So I was talking to Scott directly.
The next question is, why wasn't an NG tube or nutrition started prior to October 13th?
Actually, those conversations were occurring. The previous notes from my colleagues actually indicated conversations about nutrition, and they had not wanted the nutrition at that time. I think they had conversations about different modalities. So they're still deciding on it. So it was something that I revisited when I was having my discussions about goals of care as well.
Could Grace have had an infusion for COVID-19 back on October 6th when she first showed up in the emergency room? Question would be why or why not?
Yeah, October 6th when she first came in, I think she was about day 10, so that would have been a collaborative decision with the infectious disease doctor or whoever was kind of admitting her. The treatment options at that time would have been remdesivir, which is an infusion that could prevent the viral replication if they felt that was useful at that time, and considerations for that IL-6 or that anti-inflammatory medications. But again, the benefits and risks have to be weighed with everyone's situation and looking at everyone's labs. And so our infectious disease doctor generally has those discussions and determines which medications. They're also restricted to those physicians, so they're the ones that have to order it. So they'll have those discussions to determine. But she did have some options, I think, on the 6th besides dexamethasone, the remdesivir and the Actemra, I think were on the table, and monoclonal antibodies were also being used, I believe, at that time.
So is the answer to that one yes?
Yes.
What are the risks of intubation?
So again, this kind of goes into patient-specific and individualized care based off of their situation. So if I was to put it into a nutshell, the biggest concern everyone has when they get intubated is, are they going to be able to get extubated? Or are they going to be stuck on a life support machine for the rest of their life? Remember, when you're in a life support machine, you're unconscious. They have to knock you out essentially with sedative medications so that you're on it. And then if you're able to kind of regain consciousness and they're able to wean, the long-term effects potentially could be a tracheostomy and a tube in your throat kind of for a very long time. You may never exit that stage. And if you do, then maybe you can get off that tube, and it really depends on how you recover and what your lung function, your residual lung function is. So everyone's different. So there are risks. You're getting put on ventilator support. Nothing's better than natural, right? You want your own lungs to breathe for you. Anything that you do, be it dialysis or intubation, because you're using a machine, it's not the perfect physiology for your body. Your body has better conditions. So we're trying to mimic with these machines what we can do. I mean, these are generally temporary. People don't stay on a ventilator or shouldn't stay on a ventilator forever. It will have long-term consequences.
The next question is, do you think the family understood that without intubation, Grace did not have a chance to survive?
I do think they knew, but remember, these conversations are extremely difficult. I mean, they also knew that her chance of survival was very low, and in context where if she were to survive, there was going to be likely fibrosis and damage to the lungs, and what is that going to look like for Grace's life? This is why we put this conversation to the family members who know her best and say what she would want, because that's their liaisons to what she would want. And so when we have these conversations, essentially, there's no good option in this situation. These are both, it just wasn't a good situation. So when I have a conversation, with Scott about this and his family, it's to understand that there's no 100% fix here. There's a bad option, and that option has its risks and its consequences. And so please weigh the considerations. So I felt we had a good discussion, and that's why, again, there's no wrong decision in these. I don't want people to think that there was wrong decisions. These are very tough conversations between provider and patient.
I think you answered that you believe they understood that without intubation, Grace did not have a chance to survive. Is that accurate?
I believe so, but I also believe they felt that she would survive with BiPAP and get better.
I'd like Attorney Slider, if you could put up that exhibit 222 that you had up there with the doctor's note. The next question, I think, has to do with that, and I just want to put it up there so I can read it correctly. It's the note that you had listed up there with 8 items, I believe. Blow that up, and we focus on number 6. Okay, and so the question I'm going to read to you is October 13, in your note, number 6, you wrote, begin quote, if out when she recovers, end of quote, why? And now that we're looking at number 6, I think it reads, goal of activity is to have her in a chair watching television. If she is lightly sedated as related by family, at this time she is more agitated than on a higher dose Precedex and relatively bedbound, although we are working towards this goal if and when she recovers. So if you can comment about if and when she recovers.
Right, so again, this is my more extensive note the next day in regards to her activity level. I clearly say that she's bedbound at this time. We talked about her being sedated and trying to get to a goal of lightly sedation. And you know, her interest, you know, watching TV, and it would be beneficial to get her to a chair to watch TV. So I included that in the care plan based on my conversation with family. Agitation was, and taking off your BiPAP obviously takes precedence over doing anything like this. I mean, we want to make sure someone's in the right state to initiate a care plan where we're removing sedation and getting them to chair, particularly with the energy concerns and, you know, how distressing changes like that can be when you're in such a delicate balance here.
Okay, good. Thank you, Doctor. Are there any other questions from the jurors for this witness? Attorney Guzzi, any follow-up to those questions and answers?
Infusion of something specifically address COVID-19. You mentioned medication. Are you familiar with medication? What's the use of that?
Yeah, that's Actemra. I call it by brand name just because that is a hard thing to pronounce. You did a good job.
Took me 2 years, doctor. 2 years. Was there any reference that you saw in the records in which that medication would have been recommended by another physician to Mr. Schara?
Yeah, those conversations are in Dr. Zymet's notes when he talks about conversations he had with Scott about this medication Actemra and the time window in which he uses it, and in relation to kind of stopping or alleviating that cytokine storm I mentioned before, which is that inflammatory cascade that happens. And so that's what that medication does. It essentially stops that, alleviates that, let's say. So it's one of the medicines we use. So he talked about it.
And based on your review of the records, is that something that Dr. Zymet recommended?
Yeah, he recommended it, yes.
And based on your review of the records, what was the response from Mr. Schara?
At that time, I think he declined it.
Thank you, doctor.
Frankowiak?
Dr. Shokar, tocilizumab that you just talked about, that was under an emergency use authorization at the time Grace was in the hospital, isn't that right?
I believe so, yes.
Yeah, that means it hadn't been fully approved by the FDA?
I believe so, yes.
Okay. You mentioned some other drugs with those infusions, doctor. I think one of them was remdesivir. You said she could have received remdesivir?
Yes.
Did you also say convalescent plasma?
Yeah, the monoclonal antibody was another treatment modality. I think Dr. Zyma talked about it in his note as well.
Yeah. Okay. I want to show you here a note from the record. Yeah. Oh, I need to bring back. It's on. Present output. Oh, okay. So she's doing it. It's on. Okay, this was a note from the record here. And it's signed here by Dr. Vermata Murata. And he talks about Dr. Zymet, who was the infectious disease doctor, right?
Yes.
Okay, and I want to just talk about number 3 here, because you kind of made it sound like, you know, these drugs could have been given and, you know, Dad said no. So I just want to make sure everybody's clear about what these drugs were and if they were recommended or not. So this is the note. It says, Dr. Zymet is managing COVID infection issues. She is not a candidate for remdesivir convalescent plasma. I can't say the next one, baricitinib. I can't say that one. Or monoclonal antibodies. So in fact, this does not comport with what you said about these are drugs that she was a candidate to receive, correct?
Objection mischaracterized this testimony. Only testified as what may have been available.
Right.
And so the question is, were these available to Grace at that time? Is that what you're asking?
Yeah, I think what the juror question was were there any infusions that she could have received? I interpret that as, was she a candidate to receive these drugs? This note says that she wasn't.
Just maybe ask that question.
This note says that she, in fact, was not a candidate for those drugs, correct?
I think this is the pulmonologist's note, I believe. I leave these conversations with the ID doctor who runs those risk-benefit conversations, as I had mentioned. So those are available medications in someone who comes into the hospital sick as Grace was, but the time frame has to match and the conversation has to be had as far as if it's actually going to be beneficial or not.
Okay, and that's fine. Just wanted to make sure everybody was clear about, you know, these drugs
Sure.
that you're saying she could have got. Okay, that's all I have, Doctor. Thanks.
Anything else from Attorney Guzzi?
No, Judge.
Any other questions from the jurors? You may step down, Dr. Shokar.
Thank you.
For your testimony.
At this time, Dr. Shokar rests.
Thank you. And Attorney Frankowiak, you're resting as well.
Yes, Your Honor, the hospital and Nurse McGinnis rest.
Okay, maybe just a question for the jury. Is it a good time to take a break or is it too early? Okay, so because they rested, it would be nice for us to take a break now, and we'll treat that as the 20-minute break. This will hopefully be sort of the last break that you have, because I think we're going to be able to do the rebuttal in the next session and then probably be finished for the day. Just a reminder, you know, don't discuss this with anyone, including each other. The jurors are excused. All right, everyone may be seated. This is a hearing outside the presence of the jury. So the jurors' questions are 580, 581, and 582. Any objection to receiving those? All right, so those will come in. I just want to, well, let's finish with the exhibits. I marked your letter, Attorney Guzzi, as Exhibit 105. Definitely not. And I'm going to receive it. It hadn't been marked because it hadn't been used yet, but now that it got used in front of the jury, I just think it's a good idea. A portion of it was, so, and we've talked about it. So now that we've talked about it, in case someday somebody wants to look at what that letter is, it's at least part of the record. Okay. 103 was offered. Is that right?
Correct.
Any objection to receiving 103? Okay, 103 is received. Did you offer 104 or was that just skipped?
I think 104 might be coming some other time.
Okay.
We didn't know exactly how this was gonna go, so.
Attorney Frankowiak, during your questions of Dr. Shokar, you got into medications and what the expectations were in the ICU. Do you remember that? We can have it read back. And his testimony was, yeah, we expect nurses to administer medications and expect when people come into the ICU, and he was testifying about when they go from the hospital down to the ICU. And I thought that was a little bit unfair, given the nature of the objections that we didn't allow the plaintiff to ask questions about expectations because it might establish a standard of care. Understood, and it sounds like he exercised it when he answered Attorney Frankowiak's questions, and you didn't object. And so it seemed like the door got open there, but you didn't ask any questions on it. So I just thought I'd point it out that.
I felt that the question asked by Frankowiak was much more general in terms of the
General or beneficial? Right. Understood. I just thought I'd make a record of it. Everybody, you guys are trying. The idea? Okay. And so cross-examination. You what? Yes. Cross-examination. Will it be more than an hour and a half, or we're going to order the jurors lunch?
What he's gonna say, but I don't think it's gonna be that long.
Okay. So then the plan will be to, just go and then excuse the jurors at that point. Anything else before we take a break?
Your Honor, my request, I know you emailed a copy of your I guess, current thoughts on the verdict. Would it be possible to get a copy, like a printed copy of
Yes,
that?
we'll print those out now and they'll be on your table in the next couple minutes.
Okay, thank you.
Okay, we'll do that for everybody. All right, we're adjourned.
Judge, just so we're clear on the time that you want to.
Yeah, I was thinking 1:45 on this clock is 20 minutes.
Okay.
I think the one juror is going to do 20 minutes.
At this time, Dr. Shokar synchronized watch the phone.
Okay. We're adjourned. jury's coming down the hallway. All right, everyone can be seated. Members of the jury, I think you heard that the defense had rested its case, and I explained to you a couple weeks ago that the plaintiff gets to go first and last in everything we do. So after the defense rests, the plaintiff gets to call rebuttal witnesses if they want. They've identified one witness that they plan on having as a rebuttal witness. So we're going to take that witness, and then I believe the evidence is going to be finished as it relates to this case. So your next witness, Mr. Boylan.
Plaintiff calls Scott Schara.
All right, Mr. Schara, if you want to come on up to the witness stand. Remain standing and raise your right hand, please.
You do solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth to help you God? Please have a seat. Can you please state and spell your name for the record?
Scott Schara, SCOTT-SCHARA.
Witness, Attorney Boylan.
All right, Mr. Schara, you've been sitting here for the entire trial?
Yes.
And at some point in that trial, do you remember one of the defense witnesses testifying about general consent upon presenting at the hospital?
I do. That was Dr. Beach.
Judge, I'm going to have an exhibit for this that I'm going to ask about, and it's the exhibit 100 that your clerk has, and I'd like to bring it up on the screen. The defendants have it as well. Oh, I need the plug.
Exhibit?
It is.
Okay. Any objections to Exhibit 100?
No, Your Honor.
Okay. And so Exhibit 100 will be received and you may publish it.
Mr. Schara, I've put up on the screen what is labeled as Exhibit 100. On the copy here, it doesn't yet have the clerk's designation as 100, but do you recognize this document?
I do.
Okay, and I'm going to blow it up in certain points so that we can get to the pertinent parts of this. But what do you recognize this document to be?
Received the medical records. I saw this general consent in the medical record packet.
The top of the page, it says it's page 3 of 3. But the exhibit, then the next page has page 2 of 3. Do you see that? And based on the numbers on the bottom corner of the page, do you see those? 898 is on the first page. And then 899 is on the next page. That's page 2 though. And then the first page is page 900. Do you see that? And this is the manner in which St. Elizabeth's Hospital gave you the records, right?
That's correct.
So the last page, the signature page, was at the front.
Yes.
There's a part here. First of all, tell me what your general understanding of this document is.
Well, my general understanding is that in order to get any treatment in a hospital, they want you to sign away your rights.
This is what I asked you about. You heard an expert come in for the defense and say, Mr. Schara would have had a general consent by which he consented to all of these things, such as Precedex and lorazepam. Do you remember that? Okay. Well, let's look at this general consent form by which the defense expert testified that you would have consented to medications such as Precedex and lorazepam. Do you see there's a part there for the patient's or legal guardian's signature?
I do.
Do you see a signature?
No.
What does it say?
So on the line above person signing on patient's behalf relationship, it says Grace due to COVID-19.
Okay. So you didn't sign the form?
No,
Did you ever see the form while you were at the hospital?
no,
Well, it even has a signature and it says Grace is signing, but somebody just wrote in that Grace gave verbal consent.
that's correct. Grace could sign her own name.
Did you hear Holly McGinnis testify yesterday that she hadn't been able to verbally communicate with Grace?
I did.
But this form says Grace gave verbal consent, and you're saying she could actually sign her own name, right? Well, there's another blank underneath here. There's a blank line that says patient unable or unwilling to sign the form. Do you see that?
Yes,
And there's supposed to be a documented reason in the medical record why the patient was either unwilling or unable to sign the form. Do you see that? What does it say is the hospital's documented reason of why this didn't happen?
it's blank.
You first saw this form when you requested the medical records after Grace died?
That's correct.
Did anybody at the hospital have a conversation with you about this form at all?
No, when we got to the hospital, we went right from the ambulance into the emergency room.
Handwriting on there that there was verbal consent per Grace due to COVID-19. Is that your handwriting?
It is not.
Did anyone explain to you why there would even need to be a consent form if their experts have testified they don't need a consent at all for these medications of Precedex and lorazepam?
Yeah, that's interesting. Based on hearing the testimony of their experts, it seems like the paperwork that they want you to sign is not even necessary.
Did you hear another defense expert say during testimony here in court that the hospital discussed Precedex or lorazepam with you because the hospital wanted you to be informed?
Yes, that was also Dr. Beach.
You've reviewed all of the medical records in this case?
Unfortunately, yes.
How many times?
I can't answer that for certain.
More than 10? Did any medical provider ever discuss Precedex with you?
No.
Okay, if we're having the microphone issue a little bit, we gotta make sure it's centered. Like if you're the umpire for the ball and strike, you gotta be right there in the strike.
Let's test. Hey,
Okay.
thank you, Joe.
All right, so did any one from St. Elizabeth's Hospital ever discuss Precedex with you?
No,
Did anyone from St. Elizabeth's Hospital ever discuss lorazepam with you?
no,
Is there anywhere in the medical record that you've reviewed at least 10 times? Any documentation in the medical record that anyone from St. Elizabeth's Hospital ever discussed Precedex with you?
no,
Is there any documentation in the medical record that anyone from St. Elizabeth's Hospital discussed lorazepam with you?
no.
And you say that knowing the defense is going to cross-examine you. If there's a document, they're going to show it to you.
I presume so.
Mr. Schara, were you ever actually asked to put Grace on a ventilator
Never.
from October 6th through October 13th?
Well, let me explain one incident, because when Dr. Murata came in on the morning of the 8th, he said you're going to need to put your daughter on a ventilator in the next 2 hours. So that would have been the only time that somebody said that a ventilator was necessary. And that's when I said at that time, you know, what is that recommendation based on? And he told me that they had done a blood gas the night before, and the time of the blood gas was during the overdose event on the 7th. So I asked for a blood gas to be redone because that was his source of the recommendation. And he did order a new blood gas. And so a ventilator then was never an issue again.
And when we say never an issue again, did anyone ever again tell you, here and now, Mr. Scott Schara, you need to place your daughter on a ventilator?
No,
Or not even in the way that Dr. Murata had about, you've got 2 hours to put your daughter on a ventilator?
that's correct.
Nobody ever said that to you?
That's correct.
Dr. Shokar did not ever say that to you?
That's correct.
Now, you've been asked, if someone asked you the only way to save Grace's life is with intubation, would it have changed your mind? Do you remember that?
I do.
What's your answer to that question?
The answer to the question is, of course, it would change my mind. Because
would it refresh your recollection if I told you your answer to that question was yes, it would have changed my mind, not of course?
Yeah, that refreshes my recollection. Thank you.
All right. So substantively the same answer.
Yes,
So if someone had asked you, the only way to save Grace's life is with intubation, would it have changed your mind?
yes,
No one ever asked you that, did they?
they did not.
No one ever asked you that until Mr. Goosey asked you that in a deposition. Is that right?
Yes,
Mr. Schara, because something's in the medical record, does that mean it's correct?
No,
Have we seen that?
Overruled. Go ahead.
Here for the whole trial, Mr. Schara, right? Have you seen and heard testimony multiple times of where the medical record is not correct?
I have.
You heard Dr. Shokar testify this morning that he documented all interactions with you in the medical record. Did you hear that?
I did.
He testified that he documented all interactions with your daughter, Jessica. Did you hear that?
I did.
Have you also heard Dr. Shokar testify at trial to any number of things that are not found anywhere in the medical record?
Yes.
Dr. Shokar testified that he told you Grace could crash at any time during an October 12th call. Do you remember Dr. Shokar testifying to that?
I do.
Did that conversation ever happen?
No,
How do you know that?
because that was not the purpose of the October 12th call. The purpose of the October 12th call was to introduce himself as the new doctor in charge of Grace's care. And after that, we went through the past. He wanted to hear my version of things that have happened. I talked to him about the faulty equipment situations. And then he went into an elaborate discussion of a ventilator. And at that time, what I did, he testified that there were a number of people in the room that I identified. Well, that isn't what happened. When he started getting into the ventilator discussion, I first called, we tried to get a three-way call with a doctor friend of ours because I don't know anything about a ventilator, so I wanted to have somebody who we trusted hear part of that conversation. She was not available, so then we called our pastor, and the reason we called him is because he's EMT trained. So I wanted to have somebody on the line who I trusted that would be able to interpret what he's talking about with a ventilator. And then that conversation closed with that we would take what he said and think about it overnight, and he would call the next day.
So in this conversation with Dr. Shokar, did he ever tell you that if you wouldn't give him a pre-authorization for a ventilator, that would mean that he was going to label Grace, do not intubate?
No,
And there's a difference to you, is there not, between a pre-authorization versus actual intubation?
definitely.
Did Dr. Shokar ever tell you that once he then labeled her do not intubate, that also meant to him he would then place a do not resuscitate order in her chart?
Overruled. Go ahead and answer.
That was never stated. In fact, when I was first on the stand here last week, I explained very simply, if that question would have been posed that way, or that statement that way, just so you know, if you don't want to give us a pre-authorization for a ventilator, that means DNI to us. And once we label somebody DNI, that means a DNR order will go on our chart. Well, all kinds of red flags would have went up at that point.
And in terms of the red flags that would have gone up, you also heard some testimony during this trial, somebody questioning, why didn't you call Jessica and let her know that Grace was labeled do not resuscitate? Do you remember that testimony?
I do.
Okay. Well, why didn't you call Jessica and let her know that Grace was do not resuscitate?
Because we had no idea she was labeled do not resuscitate.
Judge, I'm going to want to bring up the next exhibit was Exhibit 102. We've seen this before. This is Dr. Shokar's note from October 13th. With your permission, I'll publish it to the jury again.
Any objection to receiving 102 and publishing it? All right, so 102 is received and you may publish it.
Thank you, Judge. Mr. Schara, you've seen this note before, right?
I have.
When's the first time you saw the note?
I would say it would have been on November 4th. We received the records between the 3rd and the 4th of November, you know, a couple weeks after Grace died. So that was either in the batch on the 3rd or 4th. So whatever day we received it is the day I reviewed it.
Okay. After Grace died is the first time you saw this note, right?
That's correct.
And did you hear Dr. Beach, one of the defendant's experts, testify at trial that this note was just really good?
Yes, I was shocked when she said that.
If we read if you read through the entire note written by Dr. Shokar.
You make it just a hair bigger, Joe.
Okay.
That's good.
All right. Do you see somewhere in the middle of that second paragraph, there's a couple of abbreviations for CPR? See that?
Are you talking about CPR resuscitation?
Yes, right there.
I see it.
I'm just trying to get you to the right part. What I want to look at is the other abbreviation is DNI. Do you see that?
Yes.
So do not intubate. See that in Dr. Shokar's note on the 13th?
I do.
That Dr. Beach said was just so well done, right?
Yes.
Anywhere in this note, does Dr. Shokar recount a conversation with you about Grace Schara being DNR, do not resuscitate?
No, he doesn't.
But as a result of the call that he summarized here in this note with you, in terms of his plan of care, he then went on to his number 8. And this is it. He then labels her DNR/DNI. Do you see that?
I do.
But in the call with you, making something DNR/DNI. In other words, if we put her DNI, then she's going to become DNR. We're not going to resuscitate her. That's nowhere in his note, is it?
No, it is not.
And it was nowhere in the phone conversation that he had with you, was it?
It was not.
Do you remember being asked about, no, let me back up. Do you remember some prior trial testimony about some of what is generally referred to as COVID drugs or COVID therapies?
Yes.
Those being the remdesivir, the convalescent plasma, or the tocilizumab, which no one can say.
Tocilizumab.
Tocilizumab. Do you remember that testimony? And Mr. Fleiter went over this with Dr. Shokar earlier, that the infectious disease specialist had determined that Grace wasn't a candidate for those. Do you remember that? There was also some testimony from Dr. Shokar that those therapies were EUA. Do you remember that?
I do.
What does EUA stand for?
Emergency use authorization.
What does emergency use authorization mean?
If you know.
When the government, through the HHS secretary, declares a public health emergency, the emergency use authorization kicks in, which then whatever modalities are given emergency use authorization status are immune from liability if something happens as a result of giving them.
Immune from liability, meaning what?
Meaning that if a patient suffered an adverse event or death as a result of giving an emergency use authorization modality, then the hospital physician could not be held liable.
Well, I'm interested in this questioning about whether or not this is in the scope of your knowledge, okay? Because whether something was emergency use authorization, that would have had to been explained to you by the physicians at St. Elizabeth's Hospital, wouldn't it have been?
Yes.
Did the physicians there at St. Elizabeth's, did anyone at St. Elizabeth's tell you about any kind of incentives for this tocilizumab?
No, they did not.
Do you know anything about an incentive for tocilizumab that would go to a hospital if it is administered one dose?
You mean?
Question, Judge? That's fine. Speaking of your contact with Dr. Shokar, was there ever a time that Dr. Shokar called you and you didn't answer?
No.
Is it your habit to answer when someone you expect to call you calls?
Yes.
If I call you, do you answer the phone?
Yes.
Always?
Well, not always.
Is there a time you remember you didn't answer the phone when I called you?
Yeah, because you reprimanded me.
What were you doing? What were you doing?
I was spreading manure this spring.
But how fast did you call me back?
Well, I heard the phone ring I was on the tractor. I heard the phone ring in my pocket. And so then I waited till I could slow things down and have the manure spreader empty. And then I called you. So it was probably 2-3 minutes.
It's your habit to answer when someone you're expecting to call calls you.
Yes.
You never failed to answer when Dr. Shokar called you, did you? No. Speaking of your conversations with Dr. Shokar, was Dr. Shokar ever really perfectly clear and to the point with you?
No. His version, for example, of the call where Grace would crash anytime, I testified to this earlier, it doesn't resemble what he wrote in the notes.
Judge, may I approach? All right, Mr. Schara, I'm gonna put up another exhibit and judge. The exhibit I would like to next put up is a copy of the hospital bills related to Grace's care. And I would ask the court's permission that I could publish that to the jury.
What exhibit is that?
It doesn't have oh, it should be 104, I believe. Now I'm given a card that it says it's 104.
Okay. Yes, so is 104 marked?
It is not,
Okay.
except by our paralegal. 104 would be the next exhibit, we understand.
Okay. And so we have a hard copy of it?
I don't have a hard copy. I just have the computer screen. And it's simply going to ask him if he recognizes the document.
And how many pages is it?
One second, let me see. 4.
Okay. So we'll mark exhibit 104 eventually, and it'll be a 4-page record of what you called the hospital bill. Is that correct?
And the other one will be 3 pages. That's the funeral bill.
Okay. And I understand the same objections. And so 104 will be the hospital bills, and then what's the next exhibit? And 106 will be the funeral bill. Attorney Boylan.
Mr. Schara, I'm bringing up a document. It's really small now. We'll blow it up. But I'm going to ask you if you've ever seen this document before regarding the bills, the bill summary from Grace Schara's stay at St. Elizabeth's Hospital, October 6th to 13th, 2021.
I have.
And I've just scrolled through all of the pages of this bill. What is the total at the bottom of page 4?
$64,127.12.
I'm next going to show you the funeral bill. Do you recognize that document, Mr. Schara?
I do.
What is the total funeral bill?
Can you zoom just a little bit? Thanks, Joe. $14,237.89.
You were here for all of Holly McGinnis's testimony yesterday, yes?
Was.
And Holly McGinnis repeated a number of times this phrase. This is what it looks like when someone is dying. Do you remember hearing her say that?
I do.
I don't mean to be insensitive. I'm sorry but you heard her say that over and over again yesterday. That was a catchphrase.
Yes, I did.
On October 12th or October 13th, in all of your conversations with Dr. Shokar, did Dr. Shokar ever tell you, Mr. Schara, this is what it looks like when someone is dying?
No, he did not.
Those are all the questions I have. Thank you, Judge.
Attorney Frankowiak.
Yes, Your Honor. Thank you. Mr. Schara, you were shown a document marked as exhibit number 100 from the emergency department at St. Elizabeth Hospital. You saw that?
I did. Yeah, you're saying from the emergency department. I
That's
don't know what department it was from.
exhibit number 100 was from October 6th of 2021 at 14:27 hours. That was the document you were shown, the consent for treatment.
That's when Grace and I were in the emergency room.
Correct. And I believe you said you got there right around 2 o'clock or somewhere in that range, 2:30?
We would have, I believe, got to the hospital about 2 o'clock.
Okay. So that document actually would have been, it's timed at about 2:27. So that would be roughly a little after you got to the emergency room.
That's correct.
Okay. And were you with Grace at all times in the emergency room?
I was, other than for approximately 10 to 15 minutes in the 4 o'clock range when she got her CT scan.
Okay. And she was 19 at the time of her admission to the hospital, true?
Yes, she was.
Okay. And she was an adult, true?
Yes,
And she did not have an active guardianship, true?
we had a supported decision-making document in place versus guardianship once Grace turned 18.
Correct. And that's different than an active guardianship, right? Guardianship is actually a legal proceeding, right?
So is supported decision-making.
Right. And they're two different things. So my question, sir, is she didn't have a guardianship, correct, at the time of her admission to the hospital?
That's correct.
Okay. At some point, several days after admission to the emergency room, you provided a copy of a POA to the hospital?
I provided the POA when it was asked for me the morning of October 8th.
Okay, October 8th. So that would be about 2 days after this consent for care, true?
Yes,
Okay. And that was the first time that you had provided that document to the hospital?
yes, it was.
You didn't have a copy of that document, for example, with you when you were in the emergency department, did you?
The way I provided it was via email. So
Okay.
nobody asked for it. And when they asked for it, I provided it
Okay.
immediately via email.
And that was on the 8th of October?
Yes,
Okay. And then you were obviously conversing with the doctors in the ER?
there was only one doctor, Dr. Barlow.
Okay, and that doctor was conversing with you about Grace?
Yes,
Okay. Did you tell the doctor that you were a decision maker or a POA for Grace?
I believe based on the conversation, she assumed it.
Okay. Did you tell her that?
I'm not sure.
Okay, so you don't know if in fact the doctor you were speaking to knew that.
That's correct.
Okay. Did you tell anyone that you were the decision maker for Grace, given that you did not have a POA document available to give to anyone at the hospital?
No, because it was obvious.
Okay. So it's obvious, you believe it was obvious to all of the providers that you were speaking that you were in fact the POA and that you were the decision maker for Grace?
Yes,
Okay. Did they treat you, I guess, as if you were the decision maker for Grace? Okay. So they asked for your consent to whatever they were doing while in the ER?
no, they didn't ask for, so the ER stay was about 10 hours.
Mhm.
And during the 10 hours, what I had consented to was the CT scan and the oxygen cannula.
Okay. And you obviously, they came to you for that consent and you gave them that consent for those things?
Yes,
And whenever they wanted to do anything or administer any type of care, they came to you and they asked?
there was no other care administered.
Okay. And nonetheless, whatever care they were going to do, whatever discussions they were having about Grace, they came to you to do that.
Yes,
And I think you told us earlier that you had consented or you spoke with your wife when it came time to decide whether or not Grace would be admitted to the hospital.
yes,
And your wife was the primary POA on the POA document.
yes,
Okay. And I believe you had said that you and your wife conferred and came to a decision that yes, we will consent to having Grace admitted to the hospital.
yes.
Okay. And did you communicate that then yourself to the hospital?
I would say we did, yes.
Okay. And then she was eventually admitted to the hospital pursuant to the consent that you gave on the, I guess it was on the 6th, but she was eventually on the floor of the hospital early morning on the 7th?
At 12 minutes after midnight.
Okay. So in all respects, you were treated as the decision maker for Grace while you were in the ER. Okay. And in all respects, while you were in the hospital, you were treated as the decision maker for Grace.
Yes.
Okay. And you're not saying now that in fact you did not consent to Grace's admission to the hospital, true?
I'm not saying anything different than I said before.
Okay. And if you had any questions of any care while you were in the hospital with Grace, you were the one who would ask those questions?
Could you repeat the question?
Sure. While you were in the hospital with Grace, you were the one who would ask any questions, or if you had questions, you would be the one asking them of the doctors?
Yes.
Okay. And if they had any questions, or if they wanted to, give any care to Grace, they would come to you?
Yes.
Okay. So there was no question in your mind that everyone in the hospital understood from the beginning that you were the decision maker. And
Say that again, please.
there's no question in your mind that from the beginning of the hospitalization, starting in the ER, that the hospital personnel knew that you and your wife were the decision makers.
Yes.
Okay. And certainly every communication they had and every action they took confirmed that they knew you and your wife to be the decision makers for Grace.
So when you say every action they took, can you explain what you mean?
In terms of decisions that you made or questions that were put to you by the care providers, you were understanding that they knew that you and your wife were the decision makers for Grace.
Yes, they would have only come to me or Cindy
Okay.
relative to decisions for Grace.
We talked a little bit when you were on the stand the first time around about a letter that you wrote to St. Elizabeth Hospital, maybe about 2 weeks or so after Grace passed away. You remember talking about that?
But the huddle. That letter was written on November 8th and sent to the hospital that day.
And do you recall writing in that letter that the ventilator push from Dr. Murata was the first of 5 different times the doctors attempted to steer us this way?
Judge, I have an objection, which is the reading back entire paragraphs or lengthy portions of a document without establishing the foundation with the witness for either refreshing the recollection or impeachment.
It was just one sentence from a letter, and
I don't know when it was
if
going to
you
stop.
remembers or not.
Exhibit is that?
Exhibit 360.
Helpful if we put it up so everybody can see it? Would it be, how you guys have done it throughout the trials, we just put it up so everybody can see what you're talking about?
And objections in the past to doing that?
But let me just make sure, is 360 received?
There was an indication that there were portions of this document which would need to have been redacted
Right.
in order for the document to be shown.
Right. So I have it, I can show it to him, but he hasn't told me whether or not he remembers this or not.
So, just so the jurors understand as well, but I told the attorneys on the law allows me to decide what scope people can do rebuttal witnesses and cross-examination. And Attorney Boylan, when you called Mr. Schara as a rebuttal witness, I explained to you, I think it was last night, there were objections from the defense to that. And I overruled the objections and I allowed Mr. Schara to testify because there's been a lot of evidence that has come in and he can take the stand and rebut it and offer thoughts about whatever that testimony was. I'm also going to allow cross-examination with that same kind of wide latitude, that it's fair game to ask questions. And because this was brought up throughout the trial, and by this, I'm talking about Mr. Schara's letter that he submitted and testified to 2 weeks ago. I will allow counsel to cross-examine on it, and then you can ask redirect questions to whatever extent you want, Mr. Boylan. And I'm okay with Attorney Frankowiak. In the past, there's been a lot of reading, but if you can just say, I'm going to read to you one sentence, do you remember it? And he'll either answer yes or no, and then you can go from there.
Sure, absolutely. So I guess the pending question was, do you recall writing in that
And what page are you referencing?
page number 10, beginning of the 4th paragraph? 60?
Page 10. You're saying the 4th paragraph?
Paragraph,
I'm with you.
okay. Mr. Schara, do you recall writing in that letter, the ventilator push from Dr. Murata was the first of 5 different times the doctors attempted to steer us this way? Do you remember writing that?
I do.
Okay. And then the next word you followed up is why question mark? Do you remember adding the word why question mark?
No, I don't remember, but if you could show me, I'm glad to acknowledge it.
I'll hand to him Exhibit 360.
Okay.
I'm ready.
Okay. If you could reference page 10, the beginning of paragraph 4, that's what I'm referencing.
I'm there.
Okay. Do you see the little, you have the, after that sentence I read, you had why question mark? Do you see that?
Yes.
Okay. Did you also write Grace didn't need a ventilator any more than a hole in the head?
I did.
Okay. And that statement was written in a letter that you wrote approximately 3 weeks after her passing.
Yes.
Okay. In fact, at that time, you believed that the hospital had offered the ventilator or wanted to use the ventilator because they were going to make some kind of money on using that ventilator. That was your belief at the time you wrote that, wasn't it?
It wasn't a belief, it was a fact. I had researched emergency use authorization modalities, and ventilators were also an emergency use authorization modality, which means that if somebody was put on a ventilator and died on a ventilator or is maimed as a result of a ventilator, the hospital and doctor would be immune from liability.
And that was something you researched and knew while Grace was still in the hospital?
No, I researched it afterward.
Okay. You also testified in your deposition that you did not want a intubation or ventilation for Grace under any circumstances?
As we talked about when I was in the stand on June 4th, Attorney Goosey cleaned up that trap question that you had posed.
Okay. Well, you had mentioned to me that you had stated in the hospital when you were talking to one or more of the doctors that you had mentioned a comment by your wife that you wanted them to do their best with the caveat that you do not want her to be intubated or ventilated. Do you remember saying that in the hospital?
Can you give me the context? I'm not quite getting where you're, what day, time, what are you talking about?
Sure. I think
you said when I was in the hospital?
While you were, no, while you were in the hospital with Grace.
While I was in the hospital with Grace, the 3 references to ventilators were first with Dr. Murata. We already talked about that just this morning. And then 2 references by Dr. Baum. Dr. Baum later the day after, in the same day with Dr. Murata on October 8th, in front of Grace said, isn't the 20% chance better than no chance? I'm calling that the first pre-authorization request for a ventilator. And then Dr. Baum followed up with that request the following day with the similar type of question. And then the first serious discussion that we had about a ventilator was the discussion with Dr. Schokar on the 12th.
You remember Dr. Schokar discussing with you what you wanted to do if Grace's heart stopped and you weren't, or they weren't able to bring her back? You remember having that conversation?
Yes.
Okay. And you recall your wife saying at that point that we would expect you to do your best and God will do the rest?
I do.
Okay. And she said that in the context of a conversation with Dr. Schokar?
Yes, that was the morning of October 13th.
I asked you at your deposition to clarify that statement. And you said you agreed that the caveat to that statement, I asked you specifically, and that statement is in the context of we want you to do your best with the caveat that we do not want her to be intubated or ventilated. Do you remember asking that question at your deposition?
I don't remember you asking it, but I'm not denying that you asked it.
Okay. And your answer to that question was that's correct.
Could you repeat the
Yes,
context again?
I asked you at your deposition, and that statement is in the context of we want you to do your best with the caveat that we do not want her to be intubated or ventilated. True? And your answer to that was that's correct.
So the broader context was we're always talking about a pre-authorization. Nobody ever gave us the question or the statement, Grace is going to die if you don't put her on a ventilator.
That's all I have.
Your Honor, may I push one of the clarification on something before I ask questions?
members of the jury, I just will let you know that you heard testimony from Mr. Schara that the total hospital bill was in excess of $64,000. That's Exhibit 104, and I believe the attorneys or parties have reached a stipulation, and that stipulation is that the total amount of the medical bills was that $64,000 number, and the amount that Mr. Schara paid was, or
Total amount paid,
total amount paid was 11,000. I don't have the exact number.
11,763.72.
Okay, so the total amount paid is $11,763.62.
72 cents.
72 cents.
And it's on the document.
Document. Okay. Okay.
With that, I do not have any questions.
Okay. You have redirect?
Very brief, I do, yes. And Mr. Schara, the beginning of Mr. Frankowiak's questions for you were about your consent to specific items of care. Do you remember that?
I don't. When you say specific items of care relative to in the emergency room?
Sure. You testified about you approved a CT scan.
I'm there now. Thank you.
So you testified in response to Mr. Frankowiak's questions about specific therapies that you did consent to, right?
Yes.
He didn't ask you about you coming in and giving a generalized consent for anything and everything.
He did not.
There was also a question for you about who was the decision maker and whether that was you and your wife, Cindy. Do you remember that? The questions that he asked you, though, weren't cabined, confined to a specific point in time. So I want to follow up with you on this. If you or Cindy were not available and couldn't be reached, who was at the hospital? Jessica, again, is on the power of attorney, right?
Yes, she is.
That's all my redirect. Thank you.
Attorney Frankowiak, anything? All right, do any members of the jury have questions for this witness? If you do, if you could just raise your hand. It just looks like two. Excellent, if we can get those to the bailiffs. Attorney Boylan. Those questions are being circulated. Just want to maybe update you as to what our plan is. When you leave today, which will be shortly after this witness, you're going to be free for the day. The plan will be to have you back here tomorrow morning at that 8 o'clock time. One concern that I have, and I've expressed it to the attorneys as recent as this morning before you guys came in, is I'm not sure how many hours of work we have left before we give the instructions to you. I've estimated that, I think I told you a couple days ago, it was like 6 to 8, and we've been trying to knock out those times. So if you do 6 to 8, say, well, we spent about 4 on it, then we should be down to 2 or 4. But the current update, and it's a credit to the attorneys, they've been sending me stuff all last night from all sides, and there's issues that need to be decided. I mentioned to them I came in at 4:30 this morning, and I was working in the back trying to get ready so that we can get done with our work today. The reality of it is I have a really strong feeling that by 5 o'clock or 6 o'clock tonight, we're not going to be done. And if we're not done, then the question is, well, what do we do with you? Do we bring you in tomorrow and just have you wait until we're ready? Or if we have 4 or 5 more hours of work, do we just spend the day tomorrow working on that? I think the bailiffs collected your numbers, and I think a fair cutoff is, you know, around 3 o'clock today. A bailiff will call each of you and let you know what the status is. But it's either gonna be report tomorrow at 8 o'clock or report Thursday morning at 8 o'clock. If we can get it done and it's 5 o'clock and we only have another hour left, we're gonna work until 6 o'clock. But if we're at 5 o'clock and it's 4 or 5 more hours, I just think it's better for us to use tomorrow to get ready. So each of you can expect a call by 3 o'clock or around 3 o'clock, letting you know which of those two options exist. The rules are going to be the same. So when you come back the next time, you will come down into the courtroom without any of your notebooks. And because the evidence is over, the evidence is going to be complete. And all you're going to have is instructions from me. I estimate that that's going to be about 45 to 60 minutes. And then you will have, I'll read to you the verdict form and kind of walk you through that. So the plan would be the same. The one thing I don't want to do is bring you in at noon tomorrow, because I think you'd get the case by like dinner time, 5 o'clock, and I just don't think that's a wise decision, as opposed to waiting until the next day so we have a full day with you. I'm going to mark as Exhibit 585, questions from Juror 2377. Question for Exhibit 583, the questions from Juror 630, and Exhibit 584, the questions from Juror number 587. I skipped that rotation. I started with 585 on accident, so I'm just going to ask them in the order that I just marked them as exhibits. All right, and the questions are the following. Okay, so the question is the following. I'm going to read to you the whole thing and then comment at the end, and then you can answer. Why were you unsure of giving Grace medications / therapies for COVID, which were suggested by specialists or medical providers, if you are all right with giving her experimental drugs such as, is it ivermectin? Yes, so that's one they reference, which wasn't proven by specialists to have any clear benefits. And then that's the question. And then they put in parentheses, referring to treatments suggested to Scott on October 6th, which he refused. That is Exhibit 583. Go ahead.
Okay, I'm going to attempt to answer the whole question at once, but if I fail, the judge will remind me. Okay, so we'll just talk about ivermectin first. Ivermectin was not experimental. It has been labeled in the media as experimental. It's been labeled as a horse dewormer. These are all stories that are simply not true. Ivermectin has been used in medicine for well over 50 years. And so it was not an unproven drug. In fact, for COVID, ivermectin alone, without anything else, had a 62% success rate at a cost of $1. So ivermectin was not used because of the financial situation relative to ivermectin. In the hospital, the only modality that was ever suggested to us was by Dr. Zymet. It was specifically suggested to me, and that was tocilizumab. All the other ones, as you saw, were not, Grace was not a candidate for them. So like remdesivir, Dr. Zymet told me that Grace was outside the window for remdesivir. So when he suggested tocilizumab, the first thing I asked him, of course I couldn't pronounce it at the time, I said, can you spell that please? So he spelled it, I wrote it down on my pad, and I said, I'll research it and get back to you. So I immediately sent the drug name to the doctor friend of ours outside of the hospital, had her start looking at it. I started looking at it, and we both came to the same conclusion by the end of that day, which was on the 7th, that we both found the same article. It was from the New England Journal of Medicine, and that article said that the
Sustained. So I don't want you to talk about what that journal says, but just the reasons that you were unsure of giving Grace medications and therapies. If you want to continue or if you're finished, just let us know.
Be heard on the objection in terms of hearsay?
I know, I mean, you can later. Okay, go ahead, Mr. Sheriff.
just let me know if I'm out of bounds here. I mean, so I'm not going to reference the article, but the conclusion that we saw.
Go ahead. You're talking about your conclusion based upon your research and your communication with the doctor friend, is that right?
Correct.
Okay.
The conclusion that we came to was that the drug had virtually no benefit because the placebo group and the drug group were identical results. And tocilizumab has respiratory distress as a side effect. So we were not going to do it because it was a net neutral with a side effect of respiratory distress.
The next question, Mr. Schara, is do you know, and only if you know, do you know who manufactures Precedex?
Pfizer.
What about lorazepam?
I'm not sure.
And who manufactures ventilators, only if you know?
I don't know.
Do you have any knowledge about other COVID patients at St. Elizabeth and whether they survived or didn't survive with ventilators or not?
I do.
And how did you get that information?
Once I started speaking out, people were writing to me and sharing their stories.
Would you know how many patients at St. Elizabeth died as a result of COVID?
I do not know that.
Do you know how many patients at St. Elizabeth Hospital lived after the use of intubation or a ventilator?
I do not know that either.
The exhibit with Dr. Shokar's note about DNI CPR talks clearly, shows he wrote about the futility of CPR efforts because of DNI. I believe that the note said you agreed. Are you saying that this was not discussed?
So the doctor's note, I agree that that's what he wrote. That was not what was discussed. So the idea of DNI, for example, DNI was not discussed. We talked about a ventilator. So DNI is their internal code word for ventilator. We did not talk about no code. We did not talk about DNR. We did not talk about the futility of CPR. What the context of the discussion was the morning of the 13th. So October 13th, when Dr. Shokar called us Cindy and I were both on speakerphone. He asked us what our decision was relative to the pre-authorization for a ventilator. We said, no, we're not going to do the pre-authorization for a ventilator. And then he immediately went into the discussion that Grace had such a good day yesterday, we should work on nutrition. And he went through a fairly elaborate discussion relative to an NG tube so that we could get Grace nutrition. He said, we've got to get her bowels moving. We've got to get her out of bed so we can get her out of here in the next several days. Then once we had approved the feeding tube, he switched gears one more time and said, if Grace took a turn for the worse and her heart stopped, would you want us to keep working on her over and over? And I said, what are you talking about? Grace is doing fine. And then Cindy said, we expect you to do your best and God will do the rest. And that was the end of the call.
And so just focusing on what this juror asked you, are you saying that this was not discussed? And by this, meaning the futility of CPR efforts because of a DNI?
So the exact words were not discussed. Futility would have been a buzzword for me. So then I would have probed further. So the exact words that were written in the medical record were not discussed.
All right, do any jurors have additional questions? There's at least one. I will receive exhibits 583, 584, and 585. All right, I'm going to mark as .586 the questions from juror 2749. I'm sorry, exhibit 586 are the questions from juror 2749. And the question is, did you or anyone else give Grace Invermectin? If not, why? If yes, why did she get worse?
Yeah, that's a great question. Yes, we did give Grace ivermectin. We had gotten a prescription for ivermectin plus or minus, I think a couple days before October 1st, before we tested her, because we saw she had symptoms. And then we gave her ivermectin. And so then the question is, why didn't she get better? The answer to that question is a little bit more detailed. So first of all, I don't know why she didn't get better. It's not a silver bullet. So no med can ever fix something, instantly. Why didn't she get better? I don't know that she was getting worse. We were fixated on Grace's oxygen saturation. And you might remember we had bought a pulse oximeter and we were measuring Grace's oxygen saturation, and on the morning of October 6th, it had dropped to about 88%. And the protocol that we were following at the time said that that's an emergency, admit yourself to the hospital. And so this was by the frontline COVID critical care doctors. We were following that protocol, and it said, if the oxygen saturation got to 88%, admit yourself to the hospital. At the time we went to the hospital, I would have looked at Grace's symptoms as like allergies. She had a cold, she had allergies. There was no emergency, but we perceived the emergency that was based on her oxygen saturation.
Okay. Exhibit 586 is received. Any other questions from the jurors? Any follow-up to that, attorney, or any of the questions, Attorney Boylan?
Yes, Judge, briefly. Question's been asked to you a couple times on ivermectin, and I believe you did say you got that by prescription from a doctor, right?
Yes, Dr. Tracy Page in Appleton.
You didn't get it at Quick Trip somewhere.
No,
You also answered about this conversation with Dr. Shokar, and you concluded with, at the end of the call ended this way, and tell me if I'm wrong, that you said to him at that point, "What are you talking about?" Do you remember that?
I do.
Okay. And then the call ended shortly thereafter?
After Cindy said, we expect you to do your best and God will do the rest, then the call ended.
And the impression on you at the time was, what is he talking about, right?
Correct.
And so when your conversation ended with him now, looking back at this, did your conversation with Dr. Shokar leave you with a clear understanding of what Dr. Shokar actually was going to do?
No,
That's all my questions. Thank you.
Attorney Frankowiak.
I have nothing.
Any follow-up questions from the jurors for this witness? All right, Mr. Schara, you may step down. Thank you for your testimony. Does the plaintiff have any other rebuttal witnesses?
Just allow me to confer with our team for 1
Sure.
minute. None, Judge. Thank you.
Right, and any witnesses? Attorney Frankowiak?
No, Your Honor.
Dean? Okay, so we're at the stage of the trial where the evidence is complete. You know, the work of the jurors in terms of listening to the evidence is over. I have some questions from the jurors that I'm going to try to answer, and the counsel, feel free to correct me to whatever extent if I say something that's wrong. Some of these questions I've never been asked, but like, who pays me? It's a good one. So just to try to answer it and then direct you on what the relevance of any of this is. So I'm elected by all of you. Judges are elected for 6-year terms. I'm in my 4th term. I was elected in 2023 and I'll be finished in 2029. We get paid by the state of Wisconsin as judges. The question was, you know, who pays for the bailiffs? And the bailiffs are paid for by Outagamie County Clerk of Court's office, and same with your lunches or the fees that you're going to get paid. That all comes from Outagamie County, so that's like a local expense. There was a question about who pays for the witnesses, you know, to whatever extent they get paid, and that is paid for by the parties who call them or are responsible for them. And same thing with the attorneys. So whatever the arrangements are between the clients and the attorneys, I have no idea. That's attorney-client information, but they're all sort of responsible for themselves. And I don't know how they've worked that out, you know, and it might all be different and it might all be the same. But those are the answers to, I think, most of those questions. And then another question was about alternates. You will find out the alternates, the 3 alternates at the close of the closing arguments. So at the time that the closing arguments are finished, the 3 alternates will be announced by the clerk. And so she'll just name who you are. And at that stage, I'll give direction to those 3 alternates. I think it's important to say that you won't be off the hook if you are an alternate necessarily. So, and I'll explain that when we get there. So all 15 of you hopefully come in prepared and ready to go when that happens. And the alternates, if you are selected to be an alternate, you're not going to be going home right away. So you're going to probably stay most likely until we get verdicts back. So you'll stay as long as the rest of the jurors. And I'll explain why when the time is right. With that being said, just a couple of things. I want to make sure we don't let our guard down. So, you know, we're in the closing moments of a trial. All of the rules that have been in place remain in place. You're not allowed to look into any issues or research any people or any situations or things that have been testified to. You need to make sure that you're not listening or reading about it. Okay, and I have a son who lives in a different part of the country, and believe this or not, you know, somewhere in his world yesterday, he had heard about this case and contacted me last night. So it's out there. And I only say that for you to understand that if you turn on the TV or you open up a newspaper or you're on social media, those are all avenues that might expose you to this. So I would encourage you, maybe don't go there if you can avoid it. But if you do and you see something or hear something, the obligation is to stop, walk away or get away from it, and then just report it back to the bailiff. When you report back either tomorrow morning or Thursday morning, I mentioned this a couple weeks ago, but your contact with the outside world will be over with, okay? Meaning until you're done deliberating. So I would encourage you to make whatever arrangements you need to make so that we don't have any issues coming up at noon on either tomorrow or Thursday. You know, something came up, I need to do something, or at 5 o'clock at night, you need to go somewhere. So if you have something on Wednesday evening, if we start tomorrow morning, or on Thursday evening, if we start on Thursday, I would encourage you to make those changes now and just make sure you have that time so you're not being bothered by anything else. The other thing was asked, you know, if one of you needs a break during the deliberations, that can be given, just like has been given during your breaks. And what you do is just stop your deliberating while that person is taking a break. And I think we all know what we're referencing without publicizing it. So it's not going to be, it'd be the break in the same way that it's been happening, and the deliberations would just stop and everybody would just pause, and then you'd pick up when everybody's ready to go again. Okay. Hopefully I've answered the questions, but if you have any for the bailiff, you know, just let the bailiff know. We're going to be working, and all of you can go down to that room, make sure all of your questions have been answered. You're kind of comfortable before you take off. But if somebody has a question, write it down, and then I'd encourage bailiffs to keep everybody here in case we want some explanation on any of that. I appreciate your efforts so far in this trial. I just want to let you know that and say thanks for your work so far. This case is going to be thrown upon you soon. You know, it's a big responsibility, and I'd encourage you to you know, do whatever you need to do the rest of the day and to get ready for that service. So we are going to excuse you. Just make sure no questions are asked, and if there aren't any, then you'll be free to go for the day, and we'll see you tomorrow morning at 8 o'clock. We have numbers, right? Okay. The jury is excused. All right, you may be seated. I'm going to owe the court reporter a break in a minute, so we'll just kind of clean up and then we'll take a break. So the exhibits have been received, the jurors' questions. I just asked the clerk, and I'd like to make sure of this, but she had indicated to me that all the exhibits that have been marked and mentioned during the trial have been received. Is that accurate? Okay. And we just need 104 and 106 to be printed off and, you know, put the exhibit stickers on. So if you can do that with her at this next break, that'd be great. Is that good, Mr.
Yeah,
Boylan?
yes, Judge, I
Okay.
can print it or email it.
You'll let me know if there's issues with that. Mr. Boylan, you said you wanted to be heard on a question from a juror, and I said not now, but I sustained an objection, and you said, could you be heard? So is there anything you want to say?
At this time, no, Judge.
Okay.
If the answer came.
We had two different sidebars. They were somewhat related, but I would like to deal with each one in the way that they came in. So during the first sidebar, Attorney Boylan, you had mentioned that you wanted to offer information about funeral bills. You didn't mention a hospital bill. Eventually you did the hospital and funeral, but my answer wouldn't have been different. Defense, I think both of you objected to that and said it's outside the scope of rebuttal, that they didn't do it in their case in chief, which I thought were fair arguments. Attorney Boylan, I think your response to that was, you know, it was just missed or mistaken, and you wanted to get it in. And I thought, in the interest of justice and out of fairness, that it was appropriate to do it. I think I asked during the sidebar, I asked defense counsel, you had it. It wasn't surprise information. It was done in discovery, and both of you said yes. So that was my ruling. You then went ahead, Mr. Boylan, and talked about what exhibit 104 and 106. Anything else you want to add to that sidebar?
Judge, you indicated that I did not bring up the did not bring up the medical bills, and that's my mistake.
Yeah, and I don't think my decision would have been any different. I thought we were only talking about funeral, and then you brought up hospital, and I thought, well, that's the same thing to me. So I didn't have a problem with it, but I didn't hear hospital bills. I know you guys want to make a record, so Attorney Frankowiak, go ahead.
Obviously, the first one was, the first sidebar dealt with the funeral bills.
Yeah, and let's only deal with the first sidebar now.
We're doing the first one. Okay,
Yes.
I didn't know, I don't think he brought up the medical bills, but certainly I would disagree with both of them. The medical bills have additional objection. I would object to both because both are outside the scope of cross that should have been placed in during the case in chief. I don't believe it's proper, and I would certainly object to including either the medical bills or the funeral bills on the verdict. And of course, as I mentioned in the sidebar, that in terms of the medical bills as well, that was the subject of a motion in limine. It was kind of left open to see if there was going to be any testimony put in there. But those medical bills they're basically for the whole stay, and you need medical testimony. It's all cited in my motion in limine to be able to tell which of those bills are supposedly related to alleged acts of negligence. For example, there's been evidence that she was being treated for COVID. Well, the defendants are not responsible for COVID. To the extent that any care was rendered for treatment of COVID, that would not be the responsibility of the defendants. To the extent that whatever they can prove, they need a doctor, someone with some expertise to be able to say these 6 line items were related or were necessary as a result of some act or omission of these defendants. Therefore, they are claimable. There was no doctor who testified, no doctor even looked at medical bills. So I think it's speculation at this point which of those bills are related. That would be a separate and distinct reason why I would say they should be excluded in their entirety. It was incumbent upon the plaintiffs who have the burden of proof to produce that expert testimony to support those bills that are reasonably related, and that has not been done. So that would be my objection on those bills as well.
Attorney Guzzi.
Judge, it's even more problematic with regard to Dr. Schokar. From the standpoint that Dr. Schokar, to the extent that there's not any damages, Dr. Schokar can only be held responsible for damages arising out of his own alleged negligence. That cannot be the entire hospital bill. And it can only be related to care and treatment that he provided on the 12th and 13th. At this point, there has been no evidence placed in the record by any expert as to which medical charges on the 12th and 13th would be related to the alleged negligence. A room charge would not be related to negligence. And so I think the state of the record is such, I think it applies to both defendants. As Attorney Frankowiak pointed out, he was there to be treated for COVID. And there's clearly treatments related to COVID. And there's been no designation by, or expert testimony by Dr. Burdine saying this treatment, this treatment, this treatment, this charge is related to the negligence of the hospital or to the negligence of Dr. Schokar. I don't think the medical bills can come in. They just can't, because as it stands right now, it is a all or nothing. And that essentially means that Dr. Schokar, they could award medical bills, in the event they find Dr. Schokar negligent, for which he wasn't even at the hospital.
So it sounds like both of you are arguing jury instructions and verdict form issues again, as opposed to the admissibility of the evidence.
No, it is admissibility.
Okay, because I was just ruling on admissibility. How we frame it or draft it in the verdict form and the instructions we'll deal with when we get there. But
it's pure. Everything I mentioned is admissibility because it's based on the need for testimony
So if,
Those are related to the alleged negligence.
Well,
And we don't have that.
yeah, if Mr. Schara testified that this is the medical bill, he has the foundation to do that.
He's not an expert to be able to sit there and say,
Just finish if you don't mind.
oh, I'm sorry. I thought you
And so if your issue is foundation, he can lay the foundation. This is the bill I received. And this is the number that was at the bottom. And you could have asked him questions about a lot of the things. We're going to get into one of them on the second sidebar that I think you then kind of backed away from. But you were allowed to ask him what of these is attributable to Dr. Shokar. You didn't. And you didn't ask him about the room charge that you mentioned. But I'm glad that nobody asked those questions. It makes my job easier, but it got in. On the second sidebar, you ended up, Attorney Guzzi, indicating that you were going to ask questions to Mr. Schara about the fact that the insurance company paid either all or part of the medical bill. I said I'd probably allow it. I think Attorney Boylan, you were, I think, indifferent to it. And then I looked at you, Mr. Guzzi, and said, you're really going to bring an insurance company up in this case? Like, do you think that's smart for your clients? And you said, oh, yeah, maybe I won't, because I said that's going to create a whole nother can of worms. And we've avoided a trial where there's been any mention of insurance or insurance coverage or insurance companies. So as soon as you opened that door, I don't know where it was going to go, but and you said, well, maybe we can stipulate to it. So everybody then agreed to stipulate what ended up being the stipulation. Anything you want to comment on that second sidebar, Attorney Boylan?
No, other than to say I did stipulate that and we put the number on the record, the final number. I do want to comment one thing on this lack of testimony about the bills.
Deal with the second sidebar first.
Okay, sure. I agree with that all, Judge, yes.
Attorney Guzzi?
that was the stipulation that the jury can be informed both on what was charged and what was paid.
Anything you want to add or say on the second sidebar?
Just that I believe I indicated that that the stipulation would be acceptable with the caveat that I did not want it to be construed as me waiving my objection to having those on the verdict at all. I do still maintain the objection to having either the medical bills or the funeral bills on the verdict at all. But subject to that, I didn't have a problem with the stipulation itself.
Okay. We're just going to bring them back in. There's a couple questions, and we should make sure we're on the same page as they're coming down. It says, if you're an alternate, can we have our phones or video game to pass the time? I think the answer to that's yes, right?
They're still going to be subject to the same
rules. Yeah, so they've been given their phones during lunch.
Okay.
Everybody agree with that?
In airplane mode, their phones?
I don't think I put that restriction on.
That's my question.
I mean, they've been doing it now, so they're going to be treated just like they are now. They can't research the case, look into anything. The second question is, should we bring medications and medical devices in case deliberations go overnight, or would we be given the opportunity to go home? And I think the answer is they're going to go home at the end of the day, and we'll just bring them back the next day, right?
Yeah.
Okay.
I don't know if Milwaukee County has a hard and fast rule that everybody has to be out at a certain time. You kind of leave it up to the jurors and say, look, 4 o'clock, whatever.
What I normally is ask around 4, like, do you want to order dinner? And that usually gives them a sign of, if they say yes, then in my mind, they're going to be close and they're ordering dinner to try to get the next hour or two and be done. And if the answer is, it's going to take more than a couple hours, then we probably end it around that time, 5 o'clock or so. Mr. Administrator. Keep them right. Yeah, go ahead, Mr. Administrator.
But if we are not where we begin closing arguments tomorrow morning, 8 a.m., that's going to obviously extend the calendar to such a point that they may be deliberating Friday late afternoon.
They would start on Thursday morning, right?
If you're saying if we close
Thursday morning,
Thursday morning, right, right.
on Thursday afternoon.
We don't close it until Thursday morning. Reasonably, they're not gonna, with instruction and closing by 3 parties, they're not gonna get to it until Thursday afternoon.
Okay.
What are your thoughts relative to, we haven't finished the verdict by Friday afternoon, in terms of bringing them back? I mean, for instance, we've got flights scheduled, to get out of town.
Yeah, I think my idea would be to ask them how much longer you need. And then, hopefully work into Friday night to get done. Or see if they want to come back on Saturday or Monday, but I would probably give them the choice of Saturday or Monday.
Okay.
I think the best practice would be Saturday. But if they have stuff on Saturday and one of them says I can't make it, I probably just say we'll come back Monday morning. But I'm optimistic that they'll be done by Friday night. What time's your flight?
5:22.
Can't wait to get out of Appleton.
I love that.
We love Appleton.
Let's stay longer.
I may move here.
Okay, you may bring them back in. All right, you may be seated. Members of the jury, we have a couple questions, and I thought maybe just easier to bring you back in here and try to answer them, and then you can go down, and if you have additional ones. And I'm not sure if everybody knows what the questions are, so I'm just going to read it, and then at least you're all on the same page. If you're an alternate juror, can we have our phones or video games to pass the time? The answer is yes, is like the direct answer. And then I'll explain. So my plan and what I've worked out with the bailiffs is the 3 alternates will be in a different jury room, very close to where you have been the last few weeks. The rules will continue like they are right now. So yes, you'll have your phones, but you can't research or look into things. The fact that somebody said video game, it makes me think that, we're talking with teenagers, but I recognize people our age play video games maybe too. So video games, or you can work or do whatever you do at lunch on your, phones. But we want to, I say it joke, kind of with a smile, but, once you're deliberating, there's some strict rules. But I'm going to allow you to have your phone with the same rules that you've kind of done with lunch. If something were to come up on your phone, you'd report it to the bailiff and talk with you about it. The second question was, should we bring, personal stuff, medications or medical devices in case deliberations go overnight, or would we be given the opportunity to go home? So I talked with the attorneys about that after you had written the question, and you'll be going home is the short answer. So I wouldn't bring anything other than what you kind of brought during your normal day. But I want to explain a couple things. So if you start deliberating, say Thursday morning, and the case goes to you, sometime around dinner, I would have the bailiff check with you and say, do you want us to order dinner, or do you want to be finished at 5 o'clock and come back on Friday morning? And then whatever your answer was, is what we do. So if you felt like you were close and all you needed was a couple more hours and you wanted to get it done on Thursday night, then we'd order you dinner and you'd stay for a couple more hours and try to get it done. But you wouldn't have to. And if you wanted to go home at 5 o'clock, say on Thursday, then you'd go home. And then the same thing would spill into Friday. So you'd come back Friday morning, just continue your deliberations. And so I don't think you have to bring anything in, other than the kind of the stuff that you've already brought with you for a normal day like this. But there is a possibility that you might be here at 7 or 8 if the jury thinks you're going to get it done. So whatever you need to bring with you to help during that time period might be smart, but you don't have to bring stuff to sleep over. Okay. Hopefully I answered that question. I will tell you that you guys were out there for 15 minutes, and I've been dealing with issues with the attorneys for the last 15 minutes that haven't even scratched the surface on the other stuff that we need to do. So I have a feeling it's gonna be Thursday morning. I just, the way, it's just a lot of time and a lot of things that need to go through. But again, we're gonna let you know this afternoon around 3 o'clock, okay? The jury is excused. All right, you may be seated. I owe the court reporter a break. So do we want to mark like that questions that they just, and are you guys good if I throw it away?
Doesn't need to be marked, in my opinion.
And then we had 2 sets of questions from the jurors that I talked to them about as the notes were being handed about who pays for me and the bailiffs and stuff. You want that note marked?
I don't.
Okay. And then the other one is talking about alternates, same thing, we can throw those away.
I agree.
All right, let's take a break. Do you want to take a lunch break? Okay. No, absolutely not. In terms of the admissibility, we are, and what happened at the sidebar, we are. But in terms of the way that it's presented to the jury, no, we're not done.
Heard on that.
And when we come back is, okay. So do you want to take a lunch break right now and then come back, or? Okay, and how much time does we don't have a jury, so how much time do you guys want? An hour, so we'll do 12:30. Yeah. Okay. Sounds good. We're adjourned.
Oh, just one more thing.
I think I win a bet that you said one more thing at least once today now. Yes. Yep, parties don't have to be here, so, and not all attorneys have to be here. I think some representative who's able to do things. Yes. All right, we're adjourned. opportunities to put things on the record, both in written form as well as verbally, and you'll be allowed to do that again today to whatever extent you're comfortable, but I don't wanna, sometimes we've been talking about one issue and then somebody else brings up another issue, so I'll select the topics, except if somebody has an idea in a way that I think is gonna get us to the finish line. I know, Mr. Boylan, you said that the first issue that you wanna talk about is the Prohat Vice document that was filed yesterday. Is there any objection to that, Attorney Frankowiak?
Yes, I don't know, my understanding is that was in order to argue an issue that I assume has been decided, or which is the battery issue. So I mean, I guess I would oppose it to the extent it's unnecessary. As a waste of time, I'm not sure where it's going. That's the only reason. Trial's over, so if that's the only reason for it, I don't see a reason.
Yeah, I don't think that issue is final. I think I've given my preliminary thoughts and decision. Attorney Guzzi, any objection? Okay, so that motion to admit Attorney Andrew Barnhart Prohat Vice is granted. My understanding is he's going to deal with the battery issue when we get to the battery issue. Is that right?
And I believe, Judge, he also would be superior to me in talking about the emergency doctrine in some ways. But Mr. Attorney Barnhart works with Mr. Fleiter. He is well-versed in the legal or the law, case law on these topics. And so he wouldn't intend to present an argument, Judge. He'd be available to answer your questions.
Okay. All right. So to whatever extent he wants to join in, he can. The first thing that I had is I had the clerk bring out the box with the jurors. Do we want to select the alternates now, so it's out of the way? Or do you want to formally do it like when we bring the jury in, tomorrow morning, for example? It's just one thing we can eliminate if we do it now.
I would agree to do it now.
Any objection?
The only hesitation is that someone, I think, if they throw it back in, and something happens.
Oh, absolutely. So, well, I mean, my thought would be we draw them out, and that's the order. So the first one drawn out would be the first one to go in if something happens to the remaining 12. And I would also suggest that we do it in a way that's public here, so everybody's seeing it. But those alternate jurors aren't going to be announced to the people watching us right now on YouTube or whatever else is going on. So it'd just be something that's over there. The attorneys would go over there with the clerk. The 3 numbers would be drawn out. There'd be an agreement on 1, 2, and 3 as the alternates. And we don't publish that information until after closing arguments. Any objections to that, Attorney Boylan?
No objections.
Attorney Frankowiak?
No.
Attorney Guzzi? All right, so I'm gonna just encourage the 3 of you to go over with the clerk. You can stand there and make sure the 15 numbers go in the way that you want. And then she'll pull out the 3, and I do too. I prefer not to have any issues later on, so we all trust her. And Mandy, when you pull them out, if you could maybe write alternate number 1 on the first one you pull out, and then alternate number 2 on the second one, and alternate number 3. If you want to bring that up to me, Mandy, after you mark it and the attorneys see it. Right, so it seems like the 3 alternates have been selected. Any questions or issues with respect to that process or the selections of the alternates?
No issues, Judge. Would you just be putting on the record who those 3 are?
I didn't want to do that today because I'm not sure that is it the public's information?
Just a question, that's all. No objection.
Do you have any issues with it, Attorney Frankowiak, the process or what we did or not making it public?
No, Your Honor.
Okay, Attorney Guzzi. And so tomorrow, when those 3 alternates are selected, the clerk will announce them as alternate number 1, and that'll be that first one that got pulled out. Alternate number 2 will be the second one that got pulled out, and then alternate number 3. And at that stage, if you think it's different than what the 3 were today, then we could have a sidebar. But I trust it'll be the 3 that you saw. Any issues?
No, Judge.
Excellent. I think the next step is the defense filed or requested several different motions at the close of the plaintiff's case. Both Attorney Guzzi and Attorney Frankowiak argued it, but I didn't give you the time that you wanted, to go into the details. So I think it'd be helpful to me if we took those one by one, instead of one of you arguing all 4 or 5 that you're going to have. And I may have written, both of you requested to dismiss the plaintiff's causes of action as relates to negligence and to wrongful death, but I think we should separate those and start with negligence. So the focus right now will be plaintiff's motion for a directed verdict after the plaintiff's case in chief as relates to the negligence causes of action. So Attorney Guzzi, you want to go first? Okay.
Yeah, I'm looking for my other brief.
And there's no rush, so just take, look for your brief, and I think all of us are going to have to do that at various times during this session this afternoon. I can give you my decision, I can avoid the argument, but
Well, yeah, I mean, honestly, I focus more time and thought process on the other claims than the negligence claim.
Okay.
I don't think with Dr. Schara, I don't think they've met their burden of proof in terms of causation. There are the theories that have been put out there are based on correlation, causation, and I don't think that there's been, based on the evidence that's been put into the record as far as the timing of the administration of medication, when an expected adverse reaction would occur, etc. I don't think that it's effective burden of proof to establish that Dr. Schara was negligent or that any negligence was causal in terms of great injuries or the death of the patient.
Okay, and maybe I can address that right now, and then we'll go to you, Attorney Frankowiak. So during the
Your Honor,
let me just address it one defendant at a time, just so the record's clear. Yeah, so with respect to Dr. Schara and Ascension Medical Group, Fox case in chief, there was evidence presented that Dr. Schara failed to obtained consent from either Grace Schara, Scott Schara, or any other power of attorney to use any of the 3 medications throughout the hospital stay. And by those 3 medications, we're talking the morphine, Precedex, and the lorazepam. There's also, there was evidence presented that not only was there a failure to get consent, but that Dr. Schara failed to get informed consent before giving those medications to Grace. During that case in chief, there was testimony that each of these medications are considered dangerous medications that are, implemented and used in the ICU unit, as well as, under the supervision and care of trained individuals that can order and administer those medications. I think that during the plaintiff's case in chief, there are indications that Mr. Schara may have consented to the Precedex on October 7th. He had written in a document that was submitted to the hospital, and that's been marked as an exhibit that he had authorized a sedative on that one occasion. And there is also evidence presented during the plaintiff's case in chief that the admission into the hospital, the admission into the ICU area constitutes implied consent for both the Precedex and the lorazepam. I think that's in dispute potentially, and will be something that the jury will need to decide. There was also evidence during that case in chief that the use of morphine was done in an emergency situation. And as a result of that, informed consent was not required. Dr. Burdine testified that administering Precedex without permission and without informed consent violated the standard of care for Dr. Schara. He described the giving of the Precedex on October 13th to Grace as insane. Dr. Burdine also offered an opinion that given the verbal order for lorazepam on October 13th was a violation of the standard of care. Dr. Burdine also testified that given the morphine to slow Grace's breathing on October 13th was a violation of the standard of care. He elaborated and indicated that giving morphine to an unconscious patient was the worst clinical decision that he had ever seen. There was also evidence presented during the case in chief that using Precedex in violation of the insert warning, specifically that it not be used in excess of 24 hours continuously, was a violation of the standard of care. I'm not so convinced by that, and we'll get to that later on. But for right now, with where the status of the motion was, there was also testimony as relates to Dr. Schara that he failed to spot the metabolic acidosis, and that the failure to spot or diagnosis was a breach of the standard of care. Subparts of that include that Dr. Schara failed to connect the maximum respiratory rate with progressive metabolic acidosis, that he failed to diagnose metabolic acidosis as a cause of hyperemia in Grace, who lost blood pressure, was receiving Precedex, and had an abnormal total CO2. There was also testimony that Dr. Schara failed to confirm metabolic acidosis with a blood gas and lactic level, that he failed to treat the metabolic acidosis with bicarbonate, and that he failed to prevent the progression of metabolic acidosis by stopping the infusion of Precedex, that he had failed to recognize hypotension as a complication of Precedex being administered. That Dr. Schokar, in place in the DNR order, had violated the standard of care by not discussing with either Grace Schara or her power of attorneys, or have an informed consent type conversation and enacting that with informed consent. I'm not suggesting any of that is true or untrue, but that's all was presented. And Dr. Burdine offered opinions in many ways on violations of the standard of care. I understand, Attorney Guzzi, that your other argument as it relates to this is causation and not correlation. And, you know, assuming that the jury finds that there was a negligence or breach in the standard of care in one or several of those categories, they will need to answer the question of causation that will provide them by an instruction. So that motion is denied. Mr. Guzzi?
Just one thing, Judge.
Okay.
I apologize. My brain, when you say care and treatment, is focused on care and treatment, not about that. You asked my question. I would just ask the following, Judge. On the emergency issue, there's two bits of testimony that I think are very important. And I think.
For a second, I don't know if we're talking emergency issue right now.
I thought we're talking about the issue.
We are just getting it to the jury.
Right.
Right.
And that's, yeah, and that's part of my motion here is on the informed consent issue is with regard to the lorazepam and morphine, which you just mentioned several times.
Go ahead.
The testimony, there's two parts to point to. One is Dr. Shokar's testimony is that's an emergency. In his cross-examination, Dr. Burdine testified that it is the treating physician that is in the best position to determine whether a situation is an emergency or not. By that testimony, I think that is a default. And these two situations, those two medications were administered in the context of an emergency. Dr. Burdine can't have it both ways. I don't know if he later testified that it wasn't emergent, but if that's the testimony in the record, and I'm sure it is, that it's treating physician that makes that determination. I don't see how those two medications on an informed consent basis go to the jury.
But if you take a look at the instructions that I drafted or the verdict form that you have, I tried to address that. For example, in 1B, 1C. One B, the jurors would be asked a question of whether or not Dr. Shokar was negligent by ordering the use of morphine on that date to slow the breathing of Grace Schara. Nothing to do with an emergency or not an emergency. Just was that decision, for whatever reason, negligent? Did it violate the standard of care? When you get to 1C and 1A, those are questions that are focused on informed consent. And I think they're worded either very similar or close to similar. We find that the standard of care required Dr. Gavin Shokar to get informed consent prior to, and we're going to have to define what that means.
to the nurses, and he admitted as much. He said the only, in his deposition, he told me the only criticism he had was of Nurse Allison Barkholtz, and the only criticism he had for her was the removal of Mr. Schara. So he did not criticize anybody else. He didn't criticize the administration, the nurse's administration of any medications. For instance, he had no opinions about Holly McGinnis or anything like that. And the nurse, again, focused mostly on issues related to the relationship of Mr. Schara and the nurses in the hospital, and whether they included him, and whether the things of that nature. What I didn't hear was necessarily an opinion from these experts that the removal of Mr. Schara caused Grace's death, or the alleged failure to care plan for Mr. Schara. These basically that list of 13 different things that Nurse Eichinger focused upon. I don't believe that there was testimony that said these caused Grace's death. Her death is obviously, the defense theory is that it was COVID, and the plaintiff's theory is that it was some sort of medication overdose. And for example, the removal of Mr. Schara, there seems to be I guess a lack of causation, or a break in causation there. It doesn't. I didn't hear anything, and I don't see that it makes a lot of sense that the connection there between the removal of, for example, of Mr. Schara, or including him in certain things, resulted in her death. And I brought the motion primarily for that reason. That I didn't hear that testimony. I didn't recognize that there was any causation. Of course, expert causation testimony would be necessary in addition to expert testimony on the standard of care. So in terms of the negligence question, I think that would be the main issue on my motion.
Okay, and I'm just going to give a decision instead of asking for argument, because I'll just lay out what I think are the issues similar to what I just did with Dr. Chokar. I want to first emphasize, I think one of the things that concerning to me is this distinguishing between nurses and hospitals, or hospital. And I mentioned that yesterday, and I'm going to throw it on you, Mr. Perkoliak. I want to hear how, if we distinguish, how do we distinguish it, both in terms of the instructions and the verdict form. But so what I'm going to do now is indicate during the plaintiff's case in chief, facts that were set forth that would establish negligence or liability on either a nurse or nurses or the hospital. And I'm going to not try to distinguish between one nurse and the other, or between the hospital. But there was evidence that was presented that neither Grace Schara or were informed of the medical event that took place on October 7th, 2021. I'm not calling it oversedation. I'm not calling it overdose. We've fought over that for, I think, too long, but there was a medical event involving the Precedex. Nurse Eichinger believed that fact, that it was never communicated to Grace or her power of attorney or Mr. Schara, led to a breach in the standard of care by preventing Mr. Schara or the power of attorney from making informed decisions from that day forward. In other words, how can you make an informed choice if you're not aware of what had just previously happened with the use of this medication? There was also testimony that the event on October 8th, 2021 involving Precedex, again, I'm just going to call it a medical event, when the Precedex was increased to 0.8 at 4:00 a.m., that event was never communicated to Grace Schara, her power of attorney, or Mr. Schara. There was testimony that the event on October 8th, the increase in the Precedex to an amount above that 0.7, violated the standard of care. Dr. Burdine testified to that, and he further testified that conduct in increasing it to a level above that 0.7 was reckless, using his word. There was also testimony by Dr. Burdine that that medical event on October 8th violated the standard of care by using Precedex without first obtaining informed consent after the disclosure of the October 7th event to Grace Schara, Scott Schara, or the power of attorney. Dr. Burdine said this was unforgivable. As you noticed by my instructions, or my verdict form, I'm sorry, I did not include that under Dr. Shokar or on the nurse or the hospital, because the informed consent responsibility, I think, is with the doctor, and Dr. Shokar wasn't involved on October 7th or 8th. But it's hanging out there in terms of the nurse and the hospital having to communicate that to Mr. Schara or the patient or the power of attorney. Further, there was testimony during the case in chief that administering the Precedex again on October 9th after the two medical events on October 7th and October 8th was a violation of the standard of care. I think the other category, and you mentioned it in your argument, Mr. Frankowiak, was, how does this one single event add up? And if you look at, do we have that exhibit? Nurse Eichinger's 13 points. So the clerk is going to get me that. But if you look at that exhibit, which was marked during the plaintiff's case, the whole tone of it was, that the nurses or the hospital failed to inform Mr. Schara at or before the time of admission about the conditions of eviction. There was testimony that there was a billboard up, that had different policies, but Nurse McGinnis, during the plaintiff's case in chief, didn't provide any testimony about what was specifically in there or who had been made aware of it. There was also a failure to honor Mr. Schara's request on October 10th to talk with a supervisor or a doctor. I included that as one of the 7 questions I think that I have under question number 4 in the special verdict form. But there are medical notes in Mr. Schara's testimony that confirm that on that early morning hour of October 10th, he was upset and frustrated, and he had asked to talk with a doctor or a supervisor, and that was never honored. He was never provided the opportunity, and instead he was evicted. And I think one issue will be, did that violate the standard of care? In addition, there's an issue of whether or not Mr. Schara's eviction from the hospital on October 10th was a violation of the standard of care by the nurses or the hospital. And I think a lot of that is based upon what the testimony was, the nature of the eviction, the process that was used to evict him, and the failure to arrange for another person to be in the room with Grace. Dr. Burdine testified in his opinion that that conduct was, begin quote, shameful, end of quote, by the hospital. All of those things that I just mentioned, I think were testified by Nurse Eichinger as an expert opinion that it was all just subparts of a failure by the hospital or the nurses to have a care plan in place for effective communication during Grace's stay at the hospital. And part of that failure to have a care plan involved the failure to replace Mr. Schara at the time that he was evicted from the hospital. I mentioned at some point to you guys, I think it was yesterday, that there was also testimony about the fact that Grace Schara went for more than 24 hours without an advocate or a power of attorney or somebody by her bedside to comfort her, or to assist her, or to speak on her behalf. It wasn't until the following day that Jessica Vanderheiden was admitted entering to the hospital room. And one of the questions will be, did the failure to have a care plan or the failure to effectively communicate with the power of attorney, either by the nurses or by the hospital, end up in resulting in Jessica Vanderheiden from being excluded from admission into the hospital. Ms. Vanderheiden testified that she went to the hospital and was denied entry. In addition, as all part of that, on October 11th at 7:00 p.m., it's undisputed that Jessica Vanderheiden was removed from Grace's hospital room, and it was not allowed to come back until the following morning on October 12th. I mentioned yesterday to everybody that the hospital and the nurses in that situation treated Jessica like a visitor instead of as an advocate or a power of attorney or somebody who was authorized to stay on the bedside in place of Scott Schara. There was testimony by Nurse Eichinger that that all involved a breach in the standard of care, that there was a lack of communication or a lack of effective communication, and that there was some trouble in having a healthy communication that would be best for Grace during that window. In addition, there was testimony about the nurse in the hospital failing to act at the time that the DNR order was revoked by the family, that there was a failure to put a purple wristband on Grace at the time the DNR order was implemented, or have a conversation with Jessica about that issue, all from the nurse in the hospital, that there was a failure to develop a nursing diagnosis or care plan involving Scott Schara as a caregiver, which would have a successor after Scott Schara was removed from the hospital. That Nurse Eichinger provided testimony that the failure to include Scott Schara in the care plan was a violation of the standard of care. Ignoring family-centered care planning that led to communication issues was that the failure to recognize Scott Schara's role-related needs in a nursing care plan or to communicate his concerns effectively with an interdisciplinary team or at a meeting was a violation of the standard of care. That one swings back to his request on the morning of October 10th to meet with a supervisor or a doctor. Just wasn't honored, it seems. And if it wasn't honored, that may be a breach in the standard of care, it may be negligence. And then just lastly, that there was a failure to address the questions and concerns that Mr. Schara had as the power of attorney or the decision maker. This happened twice, once at midnight on October 8th, and the second time was at morning hour on October 10th when Mr. Schara made a request to meet with a doctor or a supervisor. There was a failure to create a comprehensive care plan for communication. There was a failure by the nurse in the hospital to inform the power of attorney and the family of Grace's steady decline. And there was a failure by the nurse or hospital to discuss the DNR order with Jessica that made it more difficult to revoke. So when you combine all those together, Mr. Frankowiak, I think your argument is that none of that caused the death. And I'm not suggesting any of those are true or not true, but if the jury were to believe those or some of those, the next question will be, well, did the hospital or the nurse's failure to do that, do their standard of care, cause injury or cause death? And again, we'll give instruction on what causation means, and they're not going to be held responsible for anything other than what's caused. But I think it's probably not appropriate to just pick one of them and say, well, the removal of Mr. Schara didn't have anything to do with her injuries or her death. So, well, the removal and then the failure to replace and then the kicking out the next night, when you take a bunch of those things together, it indicates potentially a lack of communication, a lack in following what Nurse Eichinger said was the standard of care. And then ultimately, when it came down to the decision to revoke the DNR, it seems as if the evidence, even now after all the evidence has come in, that the nurses did nothing, which may or may not be appropriate, but is there doing nothing kind of like what they did back at the time when Jessica was trying to get into the hospital and nobody did anything to do that, or at the time that they were trying to figure out and get attorneys to get her into the hospital. And had they responded timely on October 13th to the revocation of the DNR, could she have been saved? And if they say yes, then I think all of those negligent acts or any portion of those on the nurses or the hospital's behalf would have been the cause of her death, if that's what the jury decides. Again, I'm not arguing it one way or the other, but in terms of the way that it's framed, I clearly think there's enough evidence to get past a motion for a directed verdict on that, so that's denied.
I guess just for the purpose of
Yeah.
the record, I do acknowledge, all those were opinions that were out there, and so negligence has been testified to an X-ray. I guess my thing was that there is required expert testimony on causation too. So I mean, if there's no expert causation tying it up, for instance, an expert saying this caused that, I think under the law, then they can't get to the jury. It's not a jury question if an expert doesn't tie them up. And I guess that was my point, is I didn't notice an expert tying that up rather than leaving it to the jury. They've got a series of alleged negligent acts, but did those negligent acts cause the death or injury? And I guess that's what I thought was missing, that they don't have an expert who has said this act of failing to care plan caused death for this reason, or that's what was missing, I guess.
Fair. Exhibit number 70, which are the 13 breaches set forth, I think provide a basis for the cause. So this failure to communicate, the failure to have a care plan, the failure to treat the family sort of with respect and with the interest of having somebody present, the failure to keep up to date and to keep informed, the failure to do something when somebody's revoking a DNR, all can lead to cause. I'm not suggesting that they caused the death or the injury. That'll be up to the jury. But if the jury were to find that all of these things or some of them happened, then they'll have to decide, did any of those things cause injury to Grace or cause Grace's death? And Nurse Eichinger's report links it. I think Dr. Burdine said it, as it relates to given the, I don't have to go back and repeat it, but if you go back with everything I said on the most insane and his opinions about what happened, that if they believe Dr. Burdine, then there's a causation that given that and not detecting metabolic acidosis caused her death. So that's denied. Let's go to the wrongful death. Start with you, Mr. Guzzi. I agree, but I wanted you to have an opportunity to make a record if you want.
Yeah, I mean, the only other record I would make on the wrongful death is portions of that claim disappear.
You're speaking a foreign language. Portions of which claim? With what?
Components of them disappear if the court does not allow the battery to do any other thing like that in terms of wrongful death. But in terms of negligence and causation, it's same mark.
Attorney Frankowiak on the wrongful death claim.
Yeah, I guess, and I just want to make sure we're still arguing the motions that were filed as opposed to what's going to be on the verdict, right? Okay, good.
But I'm trying to give you a prelude to why I drafted the verdict. So you'll see with the comments that I've made, I'm not going to have to repeat myself when we get to the verdict. Because okay. I tried to itemize where I was at and things that were important or not important.
Okay, yeah, then basically I think the argument is very similar. Again, it's a cause thing. I think the argument would be that I didn't hear any expert. I still believe that an expert testimony is necessary to connect the alleged negligence with the death or the harm. I don't believe that anyone on the death claim has connected any of these kind of, I guess, amorphous planning and things and removing Mr. Schara to the death of Grace Schara, whether that's by overdose or whether that's by COVID. I don't see that's there, I guess. So I would again rely on the causation. I just don't see the expert testimony that's necessary in the record to connect those, the death with the alleged negligence.
If it's not there, then the jury will have an easy time answering no. And if it is there, but it's close and it's not by the burden of proof that the plaintiff needs to establish, then you're going to get your no answer too, that it didn't cause on question number 5. But I think there's enough there to give it to him. So let's go to the next issue, still dealing with your motions for a directed verdict. Both of you had argued, I guess the 3 that I have left for each of you are battery, declaratory judgment, and the informed consent claim by you, Attorney Guzzi, and the removal of Ms. McGinnis on your behalf from Attorney Frankowiak. So, okay. Okay. Okay, so you want to deal with that one first?
Yeah.
Go ahead.
Yeah. There's absolutely no evidence in this record of file after control. Even if we see that there stipulate that Dr. Shokar was an employee of the medical group Fox Valley, under the law concerning vicarious liability in the medical malpractice case, Cameron governed, and Cameron says that it's not sufficient to show to establish an employee-employer relationship for there to be vicarious liability. It has to be a master-servant relationship with evidence of control. And there is absolutely no evidence in this record. In fact, Ascension Medical Group Fox Valley, I don't believe was mentioned once, other than when this court reviewed the case.
So your position is you want Dr. Shokar to bear the responsibility on his own if he's found to be negligent in any way and not have the protection of his employer? Is that what you're arguing?
Well, he's got
Seems like a conflict.
no.
Okay.
His protection in terms of the insurance policy or whatever relationship is not the
I mean, correct me if I'm wrong, but I would think Dr. Shokar would want some vicarious liability protection from his group, which is called Ascension Medical Group, Fox Valley, Wisconsin, Inc. You're saying he doesn't want that? He wants them dismissed and he just wants to be out there on his own?
Well, there's a difference between them.
Is that what Dr. Shokar wants? Okay. Is it what he wanted at the close of the case? Did you want to talk to him before making that argument, or? I think we get into some troubled areas, and I just want to make sure we're clear on what those troubled areas are going to be.
Sure, I appreciate that.
The next break, talk with Dr. Shokar about that. And then if he does, I'd like him to be on the record. I'm going to take him under oath and walk him through what that means so that he's informed about it. Okay. So we'll reserve that one. On that note, Mr. Frankowiak, and I know I've mentioned this, and maybe now is the time to just do it because we're doing it with Mr. Guzzi's client. You're representing both the hospital and its employees, correct?
It's nurses.
Yes, fair enough. The registered nurses.
Yes. Mhm.
And the registered nurses, if they're found negligent, then the hospital is responsible through vicarious.
Yeah. Nurses are covered under the policy of the hospital because they are employees. Like doctors are different. They have their own policies because they're thought of differently.
Maybe I won't, because I said that's going to create a whole nother can of worms. And we've avoided a trial where there's been any mention of insurance or insurance coverage or insurance companies. So as soon as you open that door, I don't know where it was going to go, but and you said, well, maybe we can stipulate to it. So everybody then agreed to stipulate what ended up being the stipulation. Anything you want to comment on that? Second sidebar, Attorney Boylan.
No, other than to say I did stipulate that and we put the number on the record, the final number. I do want to comment one thing on this lack of testimony about the bills.
Deal with the second sidebar first.
Okay.
And when we give the verdict, the agreement is if they find under the questions involving the nurses or the hospitals, other than the battery claim, if it's in there, everything else is going to be held.
The stipulation would be acceptable with the caveat that I did not want it to be construed as me waiving my objection to having those on the verdict at all. I do still maintain the objection to both, to having either the medical bills or the funeral bills on the verdict at all. But subject to that, I didn't have a problem with the stipulation itself.
Um, okay, so we're just between the nurses and the hospital, right?
We're not distinguishing like this, Nurse Jane Smith versus Nurse Holly McGinnis or something like that. That wouldn't be a distinction. I mean, they can say this nurse was negligent, this nurse was negligent, but
rules. Yeah, so they've been given their phones during lunch.
Okay.
Everybody agree with that?
In airplane mode, their phones?
I don't think I put that restriction on.
That's my question.
I mean, they've been doing it now, so they're gonna be treated just like they are now. They can't
Okay.
research the case, look into anything. The second question is, should we bring medications and medical devices in case deliberations go overnight, or would we be given the opportunity to go home? And I think the answer is they're gonna go home at the end of the day, and we'll just bring them back the next day, right?
Yeah.
Okay.
I don't know if Milwaukee County has a hard and fast rule that everybody has to be out at a certain time. You kind of leave it up to the jurors and say, look, 4 o'clock, whatever.
What I normally is ask around 4, like, do you want to order dinner? And that usually gives them a sign of, if they say yes, then in my mind, they're going to be close and they're ordering dinner to try to get the next hour or two and be done. And if the answer is, it's going to take more than a couple hours, then we'd probably end it around that time, 5 o'clock or so. Mr. Administrator. Keep them. Yeah, go ahead, Mr. Administrator.
But if we are not where we begin closing arguments tomorrow morning at 8 a.m., that's going to obviously extend the calendar to such a point that they may be deliberating Friday late afternoon.
They would start on Thursday morning, right?
If you're saying if we close
Thursday morning.
Thursday morning, right.
It's on Thursday afternoon.
We don't close it until Thursday morning. Reasonably, they're not going to.
Of the ship argument. And I think as a matter of law, that cannot hold. For Dr. Burdeen's opinion or withstanding. I mean, that is just, I think that is stretching the informed consent statute way beyond what it was intended to cover. And when you look at the statute itself, it is focusing on treatments that are being recommended by that physician, not treatments that were recommended by another physician, or adverse events that may have been experienced by the patient under the care of a different physician.
So the informed consent umbrella includes medications and the DNR order, correct?
Well, I mean, there's still going to be an issue of fact in terms of whether, number one, these are routine medications that require informed consent. But I'm just talking about in the construct, if we are to, for the sake of argument, assume that Precedex is, for some reason, some medication that requires an informed consent discussion, since he never ordered it, that doesn't fall on him. And neither does any of the adverse events on the 7th and 8th, because he wasn't.
I think I tried to accomplish your regarding informed consent as relates to the Precedex. My questions that were framed say, we find that Dr. Gavin Chokar violated the standard of care by allowing the ongoing administration of Precedex to Grace Schara on October 12, 2021. And then the same thing for the 13th.
Yeah.
So, and the reason that I drafted those in terms of deciding your motion, so at the time that the plaintiff closed its case, I find that they had stated a claim for informed consent on medications and on the DNR order. I've clarified that as I've listened to the defense case. So the motion is denied. But if we can just kind of cut to the chase of it on 1D and 1E, we're not asking the jury if Dr. Chokar violated anything by either getting informed consent or not getting informed consent. And but this question, the way that I worded it, assumes is that there was nothing wrong prior to October 12th when he clocked in at 6 a.m. with that Precedex. So it's just saying by continuing that order that had been in place, was that a violation of the standard of care? On the 13th, when it started increasing, you notice how I worded it, was there a violation of the standard of care by allowing the ongoing administration, meaning that range of, up to 1.4 or 1.5, every 6 hours or whatever it was. He authorized the continuation of it. And he had the authority to stop it later on in the day, which I think implies that he had the authority to stop it at any time during his 2 shifts. And so I've tried to frame it that way. Anything on that issue from plaintiff?
From plaintiff, no, Judge.
And you're not involved in that, right, Attorney Frankowiak?
Not an informed consent, no.
Okay. Let's then deal with the battery. And this is where you're gonna argue, is that right? Okay.
But my argument in regards to emergency battery was, I think we have to pull the definition of emergency response.
Okay, so when we get to the draft and the instructions, we'll incorporate that.
May
So-
I, on that point, Judge?
Sure.
It covers emergency.
We'll get up to that and talk about it. So let's go to battery. Just to kind of short circuit, I don't want to take away your arguments, but when the plaintiff rested, the motion was denied. I think there was enough in there. I didn't deny it right away, so you guys were able to present information on battery. Both of you did a good job of asking questions about, did you intend harm? Did you intend to do this to your witnesses? So I think it'd be better or more appropriate at this stage to address the battery with the motion right now. Because I didn't grant the motion for directed verdict and you guys then asked questions about it. And the trial involved everybody asking questions. So I think the best thing to do is say, okay, where we're at right now in the trial, with all the evidence that has come in, has the plaintiff created a case for battery? Is there any objection to that from Attorney Boozy? I'll start with you.
So I'll make the motion right now for a directed verdict on the issue of battery.
This stage of the
At
trial.
this stage of the.
Okay, that's what
All
I'm
the
trying to.
evidence is in at this point.
Right. Are you okay with that, or you want to go back to when the plaintiff rested, Attorney Frankowiak?
No, as long as we can make it and we can resolve the issue before the jury gets
So-
its hands on the case.
At the time of the plaintiff rest in its case, the motions were denied. I didn't. Let's wait until later in the case when we can hear everything. There was a stage somewhere in the trial where I said I was going to wait for Mr. Schara to do his rebuttal. So if you guys would have brought it up when you rested, like you said this morning, there's a bunch of motions. I would have, on the battery, I'd have said, I'm waiting until the rebuttal's done. So I think now is a good time to do it. Your motion, defense, can we take a 10-minute break?
Yeah.
Okay, does that work for both sides? Okay, so let's just start back up at like 1:45. Does that work for you?
treatment takes place within the terms of definite bodily harm. I guess initially what I would say.
So Mr. Schara is here, and we just started at 1:45. We were waiting for you, but Mr. Guzzi was just in his first sentence anyway.
And I did not see that fellow that time that we were preparing instructions, but if you look at 1023, that instruction already includes the word impairment and or impaired. And the question is, jury instruction says the question asks you to determine whether the condition of plaintiff's health, as it was when placed under the doctor's care, has been aggravated or further impaired as a natural result of negligence of doctor's treatment. So the concept of impairment of physical condition has already been taken into consideration, included within the jury instruction containing the sentence. Second of all, as it pertains to Dr. Schokar, there is no evidence of contact as required under and in terms of bodily harm, Dr. Schokar has testified that it was an emergent condition. It was not administered in an attempt to cause damage or worsen Grace's condition, but in an attempt to preserve her life. And the plaintiff's argument is that because, at least with regard to the morphine, is it was administered to slow her breathing. And the position that puts us in as far as the battery claim is when a physician orders a medication for the purpose of slowing the breathing down, and then it actually works to slow the breathing down, how can that possibly be a battery? The only thing it can be is a negligent order, or if the breathing is slowed down too much. But then that becomes a negligence claim. It's not a battery claim. I mean, it already is a negligence claim. It's not a battery claim. And there are medications used throughout the hospital and clinics that have a specific purpose. Blood pressure medication to lower the blood pressure. If it is if it's given to lower the blood pressure and it works, okay. But if it's given to lower it too far, then we're talking about a negligence claim, not a battery claim. In this case, the evidence is that once that morphine was administered, her respiratory rate still didn't drop to normal, and it wasn't even close to being normal, and it certainly never was suppressed to the point of being abnormal. And her blood pressure went up, and her oxygen stats improved. So on that basis, there cannot be a battery. Similar to lorazepam. In that case, when you look at the vital signs in the record, medication has no effect, number one. But number two, again, when we look at the testimony and why it was administered, evidence from Dr. Schokar that it was given in an attempt to buy Grace some extra time, try and fight off the infection, and that it wasn't given for the purpose of causing harm, damage, or worsening Grace's condition. And I think for all those reasons, I don't think this battery can go forward. Right now, as the record stands, there's no evidence of any intent. There are no statements within the record documenting some sort of intent other than to preserve Grace's life. No statements from Dr. Schokar. No evidence of conversations that he may have had with someone else. Beyond that, you have Dr. Berdeen's testimony, which he stated when asked that he did not believe that any of the healthcare providers here acted with an intent to harm. So I just don't see from either a legal standpoint or an evidentiary standpoint how there's any basis for a battery claim of proceeding.
Attorney Frankowiak, your motion?
Yeah, I think a lot of those same arguments apply, obviously, because they're kind of tied together. I think there was no actual touching. I think when the medications were administered, they were done via IV. The courts have said, and based upon, the original Trogan case, that, I mean, the theory of battery fits uncomfortably with allegations of medical negligence, because it's not, physicians are invariably acting in good faith and for the benefit of the patient. Unlike typical battery claims, failure to provide information is not an intentional act. It doesn't fit comfortably anymore, which is why Wisconsin has moved more to the informed consent claim. And I think key here is that there is no intent as well. I think 2005 is the jury instruction that would apply. That's what's been used by numerous cases that I found when they're talking about civil battery. It's always is the jury instruction 2005, and that of course requires an intent to cause harm. And I think, as Attorney Guzzi mentioned, all of the defendants have testified that far from having an intent to cause harm, their intent was actually to take action that were beneficial to Grace. In fact, the evidence is that the action that they took was beneficial to Grace. So I think, for all of those reasons, and I think I cited even a very similar case in my summary judgment reply brief, the Van Epps case, which had a very similar thing. There was an allegation that a facility battered an elderly lady by oversedating her. And the court said, no, that wasn't battery. That was just the administration of a medication. However, the estate presents no evidence from which a reasonable inference could be drawn that North Haven employees or at Mendyke's direction did anything other than administer several prescribed medications in the prescribed doses. They've not been seen as battery. They're more like an informed consent, and that's what we've done. So I think in this case, now that all the evidence is in, there just isn't. Not only does it fit uncomfortably, and the law does not prescribe it, but I think there's a complete lack of intentionality here. The other thing about the nurse, I know we've discussed the idea of informed consent and consent required by the nurses, but a nurse is going to typically inquire about, when giving a medication, the nurses don't ask the patient for consent. The nurses act on the order of the doctor, who has already gotten consent from the patient. So every time they administer a medication, it would essentially be, or could be argued, it's an unconsented touching, because they don't get consent. It's not their job. They wouldn't even think to do that. So it just does not comfortably fit a nurse either in this situation. For all those reasons, I think I would reiterate previous arguments made, and I would ask that the claim be dismissed as against the hospital. And tied into that, of course, I think if that claim were dismissed, I would certainly move for Holly McGinnis to be removed as a separate and distinct party to the case, because she does not belong in the caption of the case outside of this battery.
Okay. Yeah. Neglected to mention our trial brief that was submitted on this, I think last week. The court had, in previous discussions, had referenced the lack of case law since Trogan. And I think the recent case of Hanneman, Hanneman, H-A-N-N-E-M-A-N-N versus Boyson, B-O-Y-S-O-N, 2005 WI 94, I think may be somewhat instructive. And that is a case in which a woman underwent surgery. And during the course of the surgery, without any informed consent, her ovaries were removed. And in that case, it wasn't pled as an informed consent claim. I don't know what the exact pleadings were, but that is how the Wisconsin Supreme Court ultimately construed it, as a informed consent claim. And so if we are in a situation where we are in a spot in terms of the case law where a woman can undergo surgery and during the process of that surgical procedure have a portion of her anatomy removed that she didn't give consent to, and that is construed to be an informed consent claim by the Supreme Court, how can we then say that a medication administered for the purpose of slowing breathing down that actually achieves its purpose and stabilizes a patient can be a battery?
I thought in that case, and correct me if I'm wrong, that the lawsuit was against the referring doctor.
That
It's quite a bit different, I think, than that.
I think the context is, but I think the overall principle that is discussing informed consent and what occurred in that case is what is part and parcel of what we're talking about today. Yes, there was an issue as to who needed to get the informed consent, but there was no dispute that it was an informed consent case. I think that's one of the takeaways from the Hanneman case.
And the relationship that informed consent would have on a battery cause of action is what?
As I said, the fact that you have a physical removing of a portion of someone's anatomy without consent, and the court still construes that as an informed consent situation, I think bears directly on what the question is in this case from a legal standpoint.
Okay. Attorney Barnhart?
Thank you. Well, Your Honor, that's discussed in our brief, that case. In fact, it's not Hanneman versus Boyson. That case is Hubbard versus Newman. And first, before I even respond, I would just tell the court that I'm 100% convinced this court has a grasp of the facts and the law. And so if the court would rather just ask me questions, I'm happy to do it that way.
Well, sure. Here are my concerns or the trouble with the battery cause of action. So maybe summarize what my decision is or my thoughts, and then you can respond to it. As I think all of you are familiar with, this claim was a motion to dismiss it, I think, right when the lawsuit was filed, and I denied that. There was a motion to dismiss it on the summary judgment materials, and I denied that. And denials of those motions had to do with my belief that there may be times in the state of Wisconsin where individuals or estates representing, or the estate, representing somebody who's deceased, would have a cause of action against a doctor, nurse, or other medical person, chiropractor, dentist, anybody else who's providing professional services, including those in a hospital, of battery. I don't think the law to cover medical malpractice cases that was passed 50 years ago did away with battery causes of action. And I think I've said that a handful of times. When this case started, all of us had been talking about instructions 2005 and 2005.5. And those instructions, and I'm just going to start with 2005 because I think, as all of you know, that's the one that I think if there's one that's going to apply, it would be that. A battery occurs if, number one, the defendant or defendants intentionally cause bodily harm to the plaintiff, and second, that the plaintiff did not consent to them. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. the instruction then says in its last paragraph, the requirement that the defendant intended to cause bodily harm means that the defendant had the mental purpose to cause bodily harm to Grace, or was aware that his or her conduct was practically certain to cause bodily harm to Grace. And by bodily harm, that would include death in my definition. And it also includes, by the jury instruction definition, any impairment of physical condition, which is what I think I mentioned everybody months ago, causes me some concern on what that means in this context. So when the case started and I started listening to the evidence, my focus, or our focus, in dealing with this intent to cause bodily harm maybe skewed or blurred our vision as relates to the second element, dealing with consent. So I want to start my analysis with consent. And I think the law in Wisconsin and the jury instruction says really plainly, Grace Schara or her power of attorney did not consent to the harm. Now, it makes sense that they didn't consent to her death. They didn't consent that she have bodily injury, within reason of the medical care that she was going to get. So then as the evidence was coming in, exhibit number 360, which is Mr. Schara's 14-page document that he submitted, I think, to the hospital and then to the medical board, provides that in the third paragraph on page 3, that he gave permission to sedate her for the specific purpose of getting oxygen support. And so by his own words, and that document was marked, Mr. Schara, as the primary decision maker, power of attorney, gave permission to somebody, hospital, nurses, doctor, to sedate her for the specific purpose of getting oxygen support. Those are his words. From that language, it was clear to me that Mr. Schara, at least at some point during Grace's hospitalization at St. Elizabeth Hospital, was aware of and gave permission for Grace to be sedated. There was testimony, I think, that there were 2 medications to sedate, basically, as I understand it, Precedex and Mr. Schara did not indicate in that letter or I think anywhere else indicate that there was some express direction that he provided to the medical people, nurses, doctors, or anybody else at St. E's, that they should not use Precedex-lorazepam to sedate in the future if she needed it for oxygen support. His letter indicates, it was a one-time permission to restrain and sedate. I'm not convinced that that was communicated clearly to the hospitals, that they were aware of that. I don't know if that's important. There's also, I think, testimony, and Mr. Schara testified to it again today, that he and Cindy Schara on October 6th or October 7th consented to Grace Schara to be admitted into the hospital at St. E's. I understand that there was nothing signed regarding admission into the hospital, or I'm sorry, admission into the emergency room, and it doesn't appear that there was anything signed by Mr. Schara or anybody else about admission into the ICU or to the hospital. But you know, this morning at approximately 10:30, he acknowledged that he consented, and Cindy Schara consented to the admission to the hospital. So when you consent to be admitted to the hospital and you consent to being hooked up to all the stuff that he knew she was being hooked up to, and you provide consent to sedate at least one time. The other parts of the testimony, and the attorneys haven't made a big deal of it, but during Jessica Vanderheiden's testimony, I thought she said something or testified to something under plaintiff's questioning that when she was in the room between those dates of October 11th and October 13th, there was a machine that she saw that clearly marked Precedex. There was a label, it said Precedex, and then I have down here, it was clear and obvious to her. So I think that's what she testified to, or I wouldn't have written this down. And so when Precedex began to be administered to Grace on October 7th, it was continuously given to her until the 13th. And I take it that that machine and that labeling clearly and obviously indicating that Precedex was there was clear to Jessica Vanderheiden, that's what she said, and it was clear or should have been clear to Mr. Schara. And with as much detail as Mr. Schara was paying attention to what was going on in the machines and the alarms and everything else in that room, it would seem to me that he was aware that the Precedex was still labeled, was still involved, was still being provided. And that would be consistent with what the hospital said. There was also, you know, a lot of testimony, I think, from everybody, that the normal, routine, usual medications that are given in an ICU include Precedex and lorazepam, and that those are given without informed consent. That when you go to the ICU, you know that that type of medication is going to be used. And by you, I mean not necessarily Mr. Schara, but that you're consenting by consenting to being admitted into the hospital in the ICU unit, you're consenting to those medications. Dr. Fisk, Dr. Binstock, and Dr. Garibaldi all testified to that, as well as I think Dr. Badani. So that doesn't seem to be in dispute. Well, the last thing, one more thing I want to say is this argument about Ms. McGinnis testified yesterday that you know, she pushed buttons on a pump and didn't physically touch Grace. I'm not convinced that that negates a battery claim. I think, and I also believe that individuals can act alone or in connection with one another or each other in committing a battery. So if Dr. Shokar and Ms. McGinnis work together to effectuate something that would intentionally cause bodily harm and without consent, but they never laid a finger on Grace, I think that still could constitute a battery as that term is defined. With that being said, I'm not satisfied that there's any way that the plaintiff can articulate that the administration of the Precedex was done without consent. That the administration of the lorazepam was done without consent. And then when we get to the morphine, it's undisputed that on October 12th and October 13th, Mr. Schara had multiple conversations with Dr. Shokar. During those conversations, if you take the side that's best for the plaintiff, you conclude that the family made a decision that Grace would not be intubated in a pre-approval way, that there wouldn't be a ventilator in a pre-approval way, but that the medical staff would continue to do their best, that was language used today, to take care of Grace, that they would do everything other than intubate or ventilator to treat her medical condition that she was having. That, I think, includes medications when you're in the hospital in an ICU unit. So the conversation on October 12th and the conversation on October 13th, where the family is telling Dr. Shokar, we want medical care and treatment to continue to be given. We want the full treatment, but we don't want intubation and we don't want the ventilator yet. That is consent. So I don't see any way how on October 13th, when these medications are given, how a jury could find that they were given without consent. You confuse me, Mr. Guzzi, every time you bring up informed consent, because that's a different issue. And informed consent is, you notice how I haven't brought up informed consent in any of my battery discussion, because battery doesn't require informed consent. It just requires consent. So that's my basis to say I don't think you have a case for battery.
I'm willing to draw a distinction between the Precedex and the lorazepam and morphine. So, first of all, I do want to, I think I'm willing to concede that there was consent to the Precedex, not informed consent, but consent. And so that leaves it alive in the negligence claims. But for the purposes of battery, and if you remember the brief we filed last night, and I appreciate the court got up very early this morning and probably waded through all 18 pages of it. I think the court will see that we focused on the administration of the lorazepam and the morphine, but in the context of the Precedex being at full dose. Now, the reason I'm willing to concede the Precedex for the purpose of the battery argument is because I do acknowledge that from the letter Mr. Schara wrote, while we dispute the idea that he was ever specifically informed that the sedative would be Precedex, which is why we retain the informed consent objection, he was told that a sedative was needed for oxygen support. And the testimony from the defense has been consistent that it was in order for her to be able to tolerate the BiPAP mask. So the oxygen support, I think, that we're referencing here is the BiPAP mask. And that the hospital continued to take the position throughout the hospitalization that they needed the Precedex ongoing for her to tolerate the oxygen mask. So even though Mr. Schara's letter specifically says he only gave oxygen permission for sedatives for oxygen support that evening, I recognize that the hospital has testified that the need for Precedex continued throughout because of the BiPAP mask. But this is where I draw the distinction between that and the lorazepam. The hospital has not testified that the lorazepam was consistently needed for tolerating the BiPAP mask or for oxygen support. It may have been needed that first evening. And perhaps you could construe Mr. Schara's letter to express consent to the lorazepam for oxygen support. But that's where his phrase, that evening, becomes much more important and limiting. It's a conditional consent, and it's limited to that evening. And the hospital's own actions subsequent to that show that they never considered lorazepam to be necessary ongoing for oxygen support. So I think that was a conditional consent, and it was essentially, it didn't continue on. So what we have to talk about now is what we consider to be the main battery reason for this being battery is what happened on the 13th with lorazepam and morphine. So the court is, so I disagree with the court finding that Mr. Schara's letter gave consent for any lorazepam on the 13th. I think that was limited to the 7th. So talking about the 13th, was there consent? And the court has heard evidence of this kind of this general consent that the Scharas may have given when they admitted Grace. So the problem with finding—
Can I just stop you for a second? So on the lorazepam, the first of the 3 doses on October 13th was done for the purpose of the NG feeding tube, correct?
Yes.
And the family had consented to the NG feeding tube?
Yes. I don't believe that I think we can concede that that was not part of the battery.
Okay, so now we're down to lorazepam number 2, lorazepam number 3, and the morphine?
Yes.
Okay.
And I'll even be more candid if I could, because the lorazepam number 2 was part of the NPO, the thing that originated from Dr. Murata back on the, I think it was Dr. Baum, it was Dr. Beck. However, I think that if we're going to claim that Dr. Beck's original lorazepam order was connected to the need for oxygen support and tolerating the BiPAP mask, we know that that's not why Nurse McGinnis gave it at 1746. She claimed to have given that for a different reason, not for oxygen support, but to actually slow the breathing, which I think is different than what Mr. Schara meant by oxygen support. That was clearly the BiPAP mask. So focusing on the lorazepam at 1749, I believe 1746 and 49, because the one at 46 was given not for oxygen support. If you look at that, the court is I think next has indicated that it might find that there was a general consent to that was given at the time of admission. Now, this is where I think it's important to recognize that the courts that still allow medical battery claims to go forward, they do so because they're able to compare the specific procedure that was done that the plaintiff claims was the offensive touching or the harmful touching, and they compare that to the specific consent given and have to decide, was there specific consent to a specific procedure? And so I don't know how the court can summarily decide that when it's doing so in the context of a blanket general or implied consent. I just don't think that works. And I developed that a little bit in the brief. So I disagree with that notion. And so then in a minute, I would get to the emergency argument. But then going to the morphine, I think the court said that the morphine, there was a kind of an implied consent because Mr. Schara, if you view the evidence in light most favorable to him, when he refused the DNI but said he wanted everything else, that somehow within that everything else, this broad range of non-specified possible treatments could also include morphine. Again, I think that's the same problem with that, with trying to match up a specific procedure to a specific consent, something you need to do in the battery analysis. I don't know how we can do that when we're just talking about some kind of implicit consent to a broad range of possible but unspecified treatments. I don't think he gave anywhere near the kind of specific consent to morphine when he said, I want everything but intubation. And I don't know how the court can rule summarily on the consent aspect of the battery claim based on finding some kind of implicit consent there.
Well, consent can be implicit, right?
It can, but I don't know that it can be. We're not talking about just implicit consent to one drug. We're talking about implicit consent to a full range of possible, hypothetical, unspecified treatments. I think that really just fundamentally cuts against what battery is all about, which is more of the consent part of battery has to be a specific consent to that treatment.
Let's just stick with that thought for a minute, but at least you're, I think, narrowed in now to the 3 medications that were given to Grace at 5:46 p.m., 5:49 p.m., and 6:15 p.m. on October 13th.
Yes, and I believe that the unilateral undisclosed DNR factors into this, and the fact that Precedex was at full dose. I think this was all part of Dr. Shokar's knowledge, which I think makes the administration of the lorazepam and morphine offensive too. But yes, we are talking about those drugs given during that last hour of her life.
Okay, so if we look at those 3, my understanding from Mr. Schara's testimony, as well as the testimony of Dr. Shokar, is that Mr. Schara, Dr. Shokar, and Ms. Schara had a telephone conversation on October 13th where the Schara family made some decisions, correct?
Yes.
During that conversation, my understanding is that Mr. Schara testified today that he communicated to Dr. Shokar that there would be no intubation, no ventilator in a pre-approved way.
Right, he wouldn't give a pre-authorization for intubation, correct?
Okay. Other than that, he didn't give any other directions to Dr. Shokar on what not to do.
Correct.
Okay. And he knew his daughter was in ICU. He knew, I think to some degree, that she'd been there for a week.
Yes.
Right? That she was bedridden.
Yes.
That she hadn't been up watching TV or walking.
Yes.
That the oxygen was going in on the BiPAP at full speed, maximum dosage, and that they were running thin on options.
Yes.
And my understanding is, with all of that information, Mr. Schara, as the power of attorney or the spokesperson, with agreement by Ms. Schara, authorized Mr. Shokar or Dr. Shokar to do the best that he could and let the rest lay in God's hands.
Yes.
And so if Dr. Shokar takes that meaning, I'm going to do the best that I can do. And so at 5:46, when things are going south, and there's numbers that he doesn't like, and he starts making decisions to the best of his ability, he's doing it under the direction that that Scott and Cindy Schara had just given to him hours earlier, right? And if he screwed up, if it was a mistake and he erred, then that error comes under negligence or wrongful death as opposed to a battery. Isn't that what he was acting under at 5:49 with the lorazepam when he gave the verbal order, and 6:15 when he ordered the morphine?
Your Honor, could he have given 20 milligrams of morphine at that point?
If he thought that was the best he could do, like do the best he can do, and he gave 20 milligrams, I'm going to answer that yes on the battery. Maybe that would be offensive, but it would be a stronger case for the medical malpractice too. So I don't know if he could give 20. Could he touch her private area at that point too? I'm not sure, right?
Right.
And I'd hate to deal with hypotheticals, but 2 months ago when we started talking about battery, if somebody had gone into Grace Schara's room and sexually molested her,
right,
which happens, I think you have a battery cause of action. You may have a medical malpractice too, but you have a battery cause. Because I think when you go outside that box and you're doing something, but doing the best that you can do, which was the direction he was given by Mr. and Mrs. Schara, and by administering lorazepam and then the morphine, if he testified that that's the best he could do, and that's what he said, he was doing it in an effort to slow it down, I'm convinced that that's not a battery, it may be a medical malpractice. So,
Can I have one more shot at game one? See if I can.
I didn't hear what you said.
Can I have one more shot at this, like the Pacers got it in game one? And actually,
yeah.
The court said that doesn't like to get into hypotheticals, and I think the problem here is that this is what we're doing, and we're getting into the hypothetical of, did Scott consent to morphine?
I didn't suggest that he did. What he consented to was when he gave the direction to what he testified to today, and by he, I mean Mr. Schara, what he said is, we told Dr. Schokar no intubation, right? So we know that for sure. No ventilator, we know that for sure. And do the best that you can do with the other tools that are in the toolbox, and then let the rest lay in God's hands. And if Mr. Schara knew there was morphine in the toolbox or didn't know it, he sure didn't rule it out. So I think Dr. Schokar, when he hung up the phone, felt he had consent to administer medications, he could continue the bypass. He could do all the stuff that was in the toolbox other than a ventilator or intubation.
Two more quick points on that, and then I'll be done with that issue.
Okay.
So, Your Honor, so first of all, I believe consent, if consent can be implicit, like the court is suggesting for the morphine here, I think that has to be it's still a question for the jury. And so that's why I would object to it being summarily decided here. But also, I just want to talk about the toolbox. And this gets into the emergency, and I realize we're not actually there on this battery argument, but it's an overarching question we're going to have to decide the jury instructions for the emergency definition. So I just want to make this point, is Dr. Schokar testified that as of the 12th, he was already formulating in his mind how he was going to keep Grace alive or prevent a cardiac arrest in the event that he was not allowed to intubate. And there was plenty of trial testimony that emergency, at least subjectively in the defendant provider's mind, was at play, if not at some point on the 12th, for sure throughout the day on the 13th. And Dr. Schokar has testified clearly that with intubation off the table, he only had two things in the toolbox: lorazepam and morphine. And he knew that intubation was off the table by the morning of the 13th. And so he knew that morphine and lorazepam were the only tools in his toolbox at that point when he had the conversation with Scott. And yet his note provides no reference to the fact that he's going to be limited to lorazepam and morphine. It provides no support for the notion that he got any kind of consent from them. And the concern we have is that this was in the context of the testimony being very clear that he was asking to be informed of what drugs were being given, which I think is potentially going to invalidate or vitiate any sort of implied consent, because he's asking, I want to be told what she's being given. And Dr. Schokar knew in the morning of the 13th that there's only two tools in his toolbox. He had the opportunity to mention those to Scott, especially in the context of the DNR that Dr. Schokar knew he was placing. And he knew that the existence of the DNR meant that he wouldn't be able to use resuscitative and reversal efforts should the morphine that he must have had in his mind he was going to be giving as one of the few tools in his toolbox, should those cause an overdose. And so the concern I have is this takes it out of some kind of a informed consent negligence problem. There's enough intentionality here with the combination of the DNR, which we believe the evidence can allow the jury to decide was unilateral and undisclosed, and the fact that the morphine, an intentional decision, was made when Scott specifically wanted to be informed. Dr. Schokar must have known by that morning that he would have used it as one of the few tools in his toolbox, and also knew that he would not be able to use resuscitative measures should that drug cause an overdose. And all these things combined make the fact, and this is where that offensive conduct, the other jury instruction for battery comes in, all of these things would be offensive to a reasonable sense of personal dignity. Here I am, a patient who doesn't know there's a DNR, and I'm putting Scott in her shoes as the surrogate patient, but doesn't know there's a DNR, at least according to our version of the testimony, doesn't know that she's going to get morphine that can cause overdoses, and doesn't know that the DNR is going to preclude resuscitative and reversal measures. And a reasonable person in that patient's or Scott's position would be offended by the fact that they're going to be subjected to that undisclosed risk. And so my argument is that that whole scenario vitiates any potential consent that the court wants to find existed arising from that conversation. If there was consent, it was vitiated by that material non-disclosure that was in Dr. Shokar's mind of the consequences of the DNR and the morphine, or it was invalidated by a substantial change in circumstance, which was the consequence of the DNR that only he knew about. So that I'll be done with that, but it's in the brief, so Your Honor, I realize you've read it.
And I appreciate your arguments, and as you're going, I didn't want to interrupt you, but most of the things you were pointing out, I was thinking to myself, those are great arguments for informed consent, and how we're going to draft the instruction for informed consent, and whether Mr. Schara wanted to be informed about morphine, or was informed about morphine, or could have been informed about morphine, and when Dr. Shokar should have known that he might be using it, or it might be one of the two tools left. All those things are under informed consent and the standard of care. So with respect to the battery, given all of the evidence that has come in throughout the trial, everything that's been put on the record, including my past comments, I am going to grant the motion to dismiss the battery causes of action, which then results in Nurse McGinnis being dismissed from the lawsuit individually, although she's in like all the other nurses, with the liability being on the hospital. I've toyed with the last 48 hours, put it on the verdict, and then if they answer it yes, I can always overrule it on a motion after verdict. And in many ways, I've been thinking, well, maybe that's just the safest approach. It's the best approach. It preserves that issue for future litigation or future issues. But in my opinion, when there's no chance of winning on the law, it just confuses issues, and it might confuse the jury. And I don't want to confuse the jury on what the real legal issues are and the factual issues that we're going to ask them to determine. So that motion is granted. Anything else on that, Mr. Guzzi?
No, Your Honor.
Mr. Pinkoliak?
No, Your Honor.
And Mr. Barnhart?
No, Your Honor, thank you.
I think going back to your motions that were filed, we still have the declaratory judgment issue and the DNR issue, along with this Ascension Medical Group. Did you talk with?
I did. We are withdrawing our motion.
Okay, so you're no longer asking to have Ascension dismissed? Any issues with that, Attorney Boylan? Okay, so we're left with what I understand is let's go to the DNR statutory claim. Here's my thought on it, and I think this can be really short, is the more I thought about it, statutory claim, common law claim, if you look at the way that I drafted the verdict, my question is, does anybody have an issue or a concern with the way that it's drafted on informed consent? And if we can agree on the verdict form questions, then all of this will be argued in terms of the jury instruction. What are we going to instruct them on?
Which question, Judge, on the verdict?
The informed consent questions come in, let me just find mine, but it'll be question number 1A, which is, I think, what Attorney Barnhart was just asking. So that's the informed consent regarding the morphine. Then 1C, which is the informed consent regarding the lorazepam on October 13th. And which is informed consent for the DNR order. So I said to Attorney Guzzi before, as I tried to go through all of these issues, what I understood under the umbrella of informed consent is we have the issues about medicine and we have the issues about the DNR. And then what I did is I tried to go, well, let's not bog down on statutory or not statutory. Let's just go to, was there an obligation to get informed consent when Dr. Shokar was on call, or when he was the doctor, which involved the lorazepam on the 13th and the morphine on the 13th. So I'd like the jury to answer that. And then the DNR order. And you'll notice that I worded them different. For the two medications, I worded it where they're not assuming there was a standard of care, which was your concern, Attorney Guzzi. And then the question 1F involving the DNR order was worded different because we know there is an obligation to have informed consent when you enter DNR order. So I worded it, we find that Dr. Gavin Shokar violated the standard of care by placing the DNR order for Grace Schara on October 13, 2021 without informed consent. Notice how I did it that way? Then the last thing I'm going to say before I hope we can just agree that those are worded okay and we'll save the argument for the instructions is I didn't do it under the nurses. So there's nothing with informed consent under the questions 4 and then the subcategories of 4. So I don't know who wants to go first. Start with the plaintiff. Do you see any causes of action that you would have involving informed consent that would not be included on the, that are not included on the draft verdict form?
Quick thing I see is in 1C, it just has L instead of lorazepam.
I already added in
Gotcha.
that, and I misspelled Grace's last name in question number 1. That's been corrected. There's been a couple other corrections throughout the day, but assuming that that's spelled out, which it is in the current copy.
Could you give me one moment, Judge?
Sure, you have to take as, instead of us just talking around it, just take as much time as you need to look at the 3 of those and see if that covers what you want answered.
Judge, we did submit a proposed special verdict, and we had additional questions on each of those, but I believe you've married those together on the lorazepam and morphine, the DNR, and you've worded the Precedex question a little differently, but it covers all the topics.
Okay, and fair enough. So what's not on the verdict form that I think you asked for was anything prior to October 12th. Because Dr. Shokar, I don't think is responsible for informed consent issues back on the 6th, the 7th, or the 8th, correct?
He's not, and I'd be surprised if I asked for those, but if I did, then
So are you satisfied with the three that are, and this is not our final discussion, right? You guys at the end are gonna be able to make final arguments, but I'm just trying to narrow in on issues. Are you satisfied then with one A, one C, and one D, or I'm sorry, one F as drafted?
So, I'm sorry, Judge, let me get between these two different documents.
Okay,
With one F, I do still, this is a separate issue that I think your Honor is going to get to about the statutory part, but as to one F, that's fine.
okay.
I do have one issue when you when you reminded me about the events prior to the 8th that I do want to bring up.
Okay.
So in terms of the continued use of Precedex, and you do your Honor's version is question 1E. It's the next one.
D&E.
D&E about the 12th and 13th Precedex. We had also proposed that as far as informed consent, that part of that question should include the failure to inform anybody in the family that there was a prior adverse reaction earlier during the stay. That's where we referenced the earlier during the stay, October 7th and 8th, but our proposal referenced it in terms of the continued use of it without the information to the family that there was a prior event.
Okay, so let me try to give the exercise that I went through to get to the question. I mentioned earlier that some of the negligence causes of action that I think are fair game for the jury to decide include, and I'm not going to label them all, but I did earlier, include not informing Grace Schara, Scott Schara, or the power of attorney of the medical events on October 7th or October 8th, along with continuing the administration of Precedex on October 8th, when they increased it to 0.8 at 4 o'clock a.m. Those are just some examples. If those are things you're going to argue to the jury, I don't believe that Dr. Schara can be liable for those. He was not there on October 7th or October 8th. The doctors who would be responsible for the informed consent during those actions are no longer part of this case. And those causes of action, to the extent they arise under negligence, lack of standard of care, would fall on the nurse in the hospital, which is what I think you're going to be stuck with on that, the way that you guys have dismissed parties. However, when Dr. Schara comes on October 12th at 6 o'clock a.m., I do believe he has an obligation. And like he said, he reviewed the charts, he reviewed the medical reports, he got an update. I believe he testified today that he was familiar with those medical events involving the Precedex. So I think you have a standard of care question about allowing that to continue in light of the background information. So I worded it by saying, we find that Dr. Gavin Schara violated the standard of care by allowing the ongoing administration of Precedex to Grace Schara on October 12th. And then the same question for the 13th. So the jury will be asked, well, if a doctor comes in and reviews the record and finds the medical events on October 7th and October 8th, should that doctor in the standard of care, would a reasonable doctor have shut it off or stopped it, changed the order? And that's where I think that's what I think you've argued.
And so then you have in 4A and 4B the information being passed on to the family about the adverse events under the hospital.
Well, because I don't
Yes.
think you've dropped the doctors that were on call on the 7th and 8th.
I see that. Where you point that out, that's the missing link. I get it now.
Yeah, we haven't gotten yet up to 4. We're kind of just dealing with 1, but that's where I think that connection is missed, or not sure missed. I think what you're left with Dr. Shokar is when he comes on call, was it a violation of the standard of care, not the informed consent? I want to go back to the informed consent question in the way that I drafted. Are you satisfied with the 3 that are in question number 1? To the extent that you haven't already made a record to any dissatisfaction?
Yes.
Okay, Attorney Frankowiak, I take it you don't take a stance on it because it's not your client?
No, as long as we're not talking about, I have objections to the extra questions on the verdict, but I'm not taking at this point, I'm not taking it.
Okay, so Attorney Guzzi, involving the informed consent, motion to dismiss, but then we just start, the motion to dismiss is going to be denied, right? So here we are, and I see with respect to Dr. Shokar, 3 different questions where informed consent is mentioned, and it fits within the negligence, but it's a little bit separate, so I've worded it different. I like your comments on 1A, 1C, and 1E, which are the informed consent ones.
Yeah, and I know the court's probably not gonna like what I have to say on this,
It's okay.
but there is a pattern instruction on informed consent. And that pattern instruction, I think, can be used potentially accomplish what the court wants to do here, maybe.
Okay, let's direct me to which instruction.
1023.1.
Okay. But that's an instruction with the
Got an
question.
instruction with a verdict, recommended verdict form.
Let me just pull it up and everybody can get to it so that we're talking the same thing. Right. Okay, I am with you with respect to, are you talking about question 1 and question 2?
Yeah. Yes, and I think, Matt, we're all ready?
Absolutely.
Okay. I think this addresses a couple issues. First of all, I want to pull back on this just a little bit because I think the initial concern I have, and all due respect to the court, you're not going to convince me otherwise on this, as to why we're not using the ultimate fact verdict form. I still don't know why at this point there is a need to break out these separate acts of, or alleged acts of negligence and lack of informed consent. The statute, I think, seems to prefer an ultimate fact verdict as opposed to one that's broken out. Certainly the court and statute gives the court discretion to do what the court's proposing to do.
With the way that it's drafted, there is an ultimate fact question, right? So it's not like we're doing away with the ultimate fact. They're getting an ultimate fact.
It is.
Okay.
I agree. I mean, I guess the question or my thought process is, and maybe because I saw it here, but you had mentioned something yesterday about having them essentially answer the ultimate fact verdict or question and then bringing them back. If the court is really committed to doing this, then I think that's the way it has to be done, because I don't think it's reasonable to look at this verdict form the way it is.
Why is that?
Hold on. Sorry. I apologize.
No, but when you say that, I'm interested in knowing why.
Because I think it's unrealistic to think that the jury isn't going to look at the subset of questions before they answer question number 1. And so
Well, they're going to look at the subset if we do it this way. In fact, I'm going to instruct them, I'm gonna read them the questions, so they're gonna know them ahead of time, right? So it's not, they are going to know them. I don't understand why that'd be inappropriate.
because it's on the verdict form. I think it's putting the cart before the, I mean, again, this goes back to the idea of the ultimate fact verdict. In these types of cases, there's no reason under the jury instruction and the recommended verdict forms to break it out. This is only a recipe for a hung jury or inconsistent verdict. And it should be, as Attorney Frank Koyak argued yesterday on the, as to Dr. Schulkar, care and treatment is answer yes or no, cause yes or no. I do agree that when it comes to the informed consent issues with the medications and the DNR, I think there has to be a separate negligence cause question with regard to the medications and a separate negligence cause question with regard to informed consent of the DNR. That's the verdict form I would be comfortable with, and I know my comfort level is not necessarily concerned, but I think not only from a standpoint, this isn't just advocating on behalf of Dr. Schulkar, this is advocating on behalf of obtaining a verdict that is as free from potential problem and error as we can, because none of us wants to be back here trying this case again due to an inconsistent verdict, or worse yet, a mistrial because we have a hung jury on jurors that can't get, that have to answer all these sub-questions.
Starting to lose me, so I want to focus back in. So what you're suggesting with the separate questions on informed consent for medicine and informed consent for the DNR, have you ever submitted anything like this, that in this case? Yet, like a draft verdict form? I know you submitted something, Attorney Frankowiak, on Sunday, but I don't think that is what Attorney Guzzi just described.
No, and that's what my office is working on right now.
Okay, well, like I said a week ago, it's getting late. So when people start coming up with ideas right now, I go, well, last week when I asked you guys for this, and I know you're in the middle of a trial, but I'm hearing this for the first time, and sometimes you go, well, I'm not sure why a record wasn't made last week or last night or on Sunday when stuff was submitted to me. So I'm trying to understand the type of question you're asking for.
Well, Your Honor, to be clear, when we submitted this back at the pretrial conference, that's the verdict form we submitted. Although I don't believe that.
So we're looking at it. So I
think that's the one we submitted.
Okay, so what document is that?
I'd have to look. Got it now. 355. $400 to go. I think Judge, I'm pulling it up right now. I think it's docket number 355. It was submitted as a, I mean, it is the proposed verdict language from the instruction. I think there would be a modification made to that question, maybe specifically refer to medications, and then perhaps within the instruction to the jury under 1023.1 specify what the medications are. As far as the DNR, that is territory that I haven't been in yet. But I think there's a way to craft that same question, set of questions under 1023.1 to incorporate a DNR. And it probably is very close to what you have here, just rereading what you have as far as the DNR. I think if we modified the question asked in the jury instruction, or recommended in the jury instruction to read something like this: was Gavin Shokar, MD, negligent in informing Grace Schara, Scott Schara, and Cindy Schara it would be somewhere between what's proposed here and what you have. I'd have to noodle on it a little bit.
You can't respond to that kind of an argument.
Yeah, I mean, it's tough. I'm trying to understand what you're saying, Attorney Guzzi, and I'm looking at the draft that Attorney Koviak you submitted over the weekend. And I think it includes some of the questions that you're talking about, Attorney Guzzi, but the fear that the jurors are going to read ahead and then have that impact would be the same thing with the way you have it drafted. I think, you know, so the question would be, you know, the way, and I don't know if the plaintiff wants like the version they have that include, but we just ask it in each question and then with a cause.
Judge,
But let me just make, so I think, I agree with you, the ultimate question is important. So the ultimate question is number 1 and number 4. And then 1A through 1F articulates with more specificity what their findings are, because this is not a case, as was mentioned yesterday, where somebody went in and had their left leg removed and they removed the right leg, where you just ask one question: does that violate the standard of care? So here there's been several violations of negligence at several different times involving different things. Don't you think that the jury should answer those?
No.
Yeah, and that's the problem, because if the ultimate fact is they're going to answer no on number 1, then they're done. Then they don't have to get into it. But if they answer yes, then I think it's important for us to know, well, what is it that was negligent? Because in the leg case, you're going to say, well, yeah, they were negligent for removing the wrong leg. We know what they were referencing.
I go back to the question why. It's not important.
It's not important, you mean?
It's important for them to identify the specific breach for which they find negligence.
Okay, so it doesn't matter if it's informed consent or if it's a breach of a standard of care? I think it is.
From the standpoint of standard of care, okay, that's a separate question, but they don't have to identify the specific breach of the standard of care.
Okay.
They just have to answer whether you met the standard of care with regard to care and treatment. Same with informed consent. They can consider all of this within their deliberations, but I think to give them guidance, like, I mean, this is basically telling them exactly which breaches the court thinks they should be considering.
Absolutely not. As a matter of fact, yeah, and I don't know how it would or why it would any more than the way you drafted it. So, for example, on the draft form that came in, was Gavin Schokar, MD, negligent in informing Grace Schara, Scott Schara, Cindy Schara about the medications ordered and administered to Grace Schara on October 12th and 13th? Is that any more suggestive than my question where it says, we find that Dr. Gavin Schokar violated the standard of care by allowing the ongoing administration of Precedex to Grace Schara on October 12th?
I think, I think it's...
So to answer your question, just so we can save time, so I am going to use this type of layout for now, and I probably up until when we read it to them. And I think both of you are objecting to that, which is noted. So back to you, Attorney Guzzi. Do you have any objection with 1A, 1C, or 1E as drafted? Or I'm sorry, 1F.
Can I ask one general question on the procedure? Would the court give consideration to the concept that I mentioned yesterday, and that is having them answer the ultimate fact question, and then go back and answer the remaining ones in a separate deliberation, if they answer yes.
Yesterday.
I see it visually now, and I see what I think the problems are.
I think that violates the statute. The jury must be together until they reach their verdict, come out and read their verdict, and they cannot go back in there.
I don't think that's
That's the
correct.
statute says so.
Which statute?
Then in the words are then and there confined. Whatever statute that is, but the words in the statute are then and there confined. Jury doesn't get to do part of the verdict, come out, ask some questions, have a discussion, eat some pizza, and go back and do the rest. Not with the court and the attorneys.
Well, they would still be deliberated and they wouldn't say anything. And they wouldn't be eating pizza out here, so the pizza would stay in the jury room.
It's done in cases where there's bifurcation. It's done all the time.
I don't know if it's done all the time, but we do it in criminal cases, you know, on mental commitments or guilty by reason of mental insanity. I mean, there's trials can be bifurcated.
But these issues are the same. They're not bifurcated issues, they're the same issue.
Attorney Franco, yeah, keep impatient.
I don't want to jump the gun. I'm just bursting with, I'd love to come in here. Whenever we're ready to talk about the verdict, I certainly have some questions. I also, you can see from what we submitted over the weekend, it's an ultimate fact verdict, at least from in terms of the hospital, where there's just, it is absolutely my position that it would be negligence of hospital's nurses, cause of negligence hospital nurses, no other reason to break it out. There's a number of reasons. We can certainly argue about those when it comes time, but one of them is a concern for an inconsistent verdict. You never know. For one thing, I think all of these individual things would need like a separate cause question, because you're not going to know. You're going to need the same 10 jurors to agree to every question that needs to be put together for each particular claim. You need the same 10 jurors to agree on the negligence, on the cause, on the damages, in order to not have, you can't have like jurors 1 and 3.
I don't think you need a separate cause question. So let me back you up a couple sentences. Why would you need if the question is, was Dr. Gavin Shokar negligent with regard to the care and treatment he provided to Grace? And they answered that yes. When we get down to number 2, it says answer questions 2 and 3 only if you answered yes to question number 1. Doesn't matter what they answered in 1A or through 1F. So was such negligence by Dr. Gavin Shokar a cause of pain and suffering to Grace? And then was such negligence by Dr. Gavin Shokar a cause of Grace Schara's death? Why would we need to ask a cause for each of those? Because it's just did the negligence cause injury or death?
Well, but you could have somebody who answers, yes, there was negligence to question number 1, but they all have different views on which of those sub-questions constitutes that. And if you're going to have that, you have to have the same people lining up for each question. My concern is that you would need a cause question. There's also an issue, for example.
Hold on, stick with the issue I just asked.
I'm sorry?
Stick with the issue I just asked so we can walk through it. So why would you need a separate cause question? So assume that the jury answers 1 and then they go to 2 and the same jurors that answered 1 yes answer 2 either yes or no. And those same jurors answer 3 yes or no. That's what we need for a consistent verdict.
They have to, if it's the same 10 jurors, so the same 10 jurors for every yes would have to agree.
I disagree with you.
And they'd have to agree to the cause question too. So if 3 of these subsections are yes, the same 10 jurors would have to agree on each of those yeses.
Disagree.
I think.
Why? Because 1 yes is enough to create a cause question.
Well, you've already, once you answer that first one, that's all you need, because now you have it. Now you have 10 out of 12 agreeing to number 1. Then you just need that same 10 out of 12 for the cause question. Boom, you're done. Once you've got those 2 questions answered, whatever you decide is good for the damages. We're going to eventually talk about what damages
you're
are out there.
skipping ahead.
They're entitled to damages then.
I'm not worried about that. I'm worried about cause. So
Right.
I want you to assume something. I want you to assume that on number one, we have 10 jurors that answer yes.
Right, so the
Okay?
negligence.
Do you mind if I just set the hypo for you? And then on number two, those same 10 jurors answer yes or no, it doesn't matter. You following me?
Well, you're gonna, if they answer yes to one, you're gonna have them answer this other series of questions.
I'm going to, I just want you to agree on something real simple so you can picture it. Because either way, we're gonna get 10 out of 12 answering yes on one, and those same 10 or 12 are gonna answer yes or no on two, if they answered yes on one.
Well, if they do, at number one, okay, so 5 different people have different answers. They all want to answer yes to one, but they all want to answer different to your sub questions there.
Okay.
They're, the sub questions are always going to be suggesting what they should be looking at or what they should be, and I mean, that's a separate concern, but then, so you have different combinations. Well, jurors 1 and 2 want to answer to yes to this one, jurors 3 and 5 want to this one. You're going to have like, you have the basic, question, negligence question, but then you have 3 different yeses on the sub questions, all of which may have different combinations of 2 jurors. And then I'm not sure, this can be very confusing for these guys to try to figure out they all have to line up. But if they don't all line up, there's going to be a question about whether, well, did the guys who thought for sub question A really, they didn't agree on sub question B. I'm concerned about what that's going to do. It's going to severely complicate this for them in terms of what they need to
clarify it for you.
What's that?
Am I able to clarify it for you?
Well, sure. I mean,
Okay, because it seems like you're confusing it. So I was going to throw a scenario at you before, so I want you to just do my scenario without interrupting, if you don't mind. Is that good? You okay if we just kind of walk through my scenario?
Yeah, sure, that's fine.
Okay, so I want you to assume that 10 out of 12 answer no to question 1.
Answer no to question 1, so then there's no further questions then.
Good, then we don't have to worry about it, right?
Right.
Okay, so the only time we have to worry about it is if they answer yes to number 1, correct?
Right.
And I want you to assume now, without talking, that 1 through 10 of the jurors answers yes on number 1, and 11 and 12 say we dissent. Good with that?
Sure.
If 11 and 12 say we dissent, that we don't find Dr. Schokar did anything wrong, I find it hard to believe that they're going to answer A through F or any one of them yes. Because if they said no, he did nothing wrong, there's no way they're going to answer 1A yes. Or if they answer 1A yes, then they're going to say, well, then my answer on number 1 should have been yes. That make sense?
I see what you're saying
so
there.
the dissenters, the people who answer no to number 1, if there are dissenters, they're not going to answer yes to 1A through 1F because they've already answered no. So I find it hard to believe that they're going to answer no to number 1, that Dr. Schokar did nothing wrong, and then find, for example, 1C, he violated the standard of care in not getting informed consent. That would be a problem.
But what about if they're all?
How about just do the scenario that I just did?
Oh,
follow that?
Yeah, I get that part. I get that part. Right.
And so I don't think that's going to happen. And if it does, I think we could, have a conversation with the jurors. That just doesn't make sense. You're gonna have to go back in. And we can explain that to them, that if you answer question number 1 no, your answers to 1A through 1F should be no. Period. I mean, we can give that in an instruction. So now let's go to your next scenario and you say, well, we need a causation on each one of these. And I don't think you do. Because if they answer number 1 no, we don't have to worry about causation. We've already talked about that. But if they answer it yes, then our instructions to them will be the same 10 of you that answered yes to number 1 will have to agree on number 4.
Which is exactly what we would do in the ultimate fact version without having to break down these other ones, which is
That's right.
I'm not sure why we're trying to break these out. What if they're unanimous and they all say, yes, there was negligence, but then they break out in these 6 sub questions, they break out in different categories there. Then you have people who we're unanimous up here, but I guess, 3 of us want, or 2 of us object to this one, 2 of us different ones object to this one, 2 different ones object to this one. Are we kind of injecting like unnecessary conflict or like causing the potential here by just cutting out the subcategories and getting the ultimate fact done? Once we got 10 out of 12 for that one and then 10 out of 12 for the cause, boom, we're done. Then they're entitled to all the damages they want to award. There's nothing else. Like breaking them out doesn't really accomplish anything for us, is the concern.
Can I answer that for you? So just start with your initial one. So if they are unanimous on number one and they answer that no, then we're done. If they're unanimous on number one and they answer that yes, we go, wow, that's pretty good. They're unanimous. Dr. Shokar did something wrong. And then we get down to 1A and it's 10-2. And we get down to 1B and it's 10-2. Right? And it's a different 2. I'm still okay with that. That's a consistent verdict. It means that 10 people found, 10 out of the 12 found that he violated the standard of care revolving informed consent on morphine, and a different 10 found that he violated 1B, which he was negligent in ordering the use of morphine. So if that were to happen, I don't think that's inconsistent. I don't think that's confusing to the jury. Matter of fact, I think we'd say, holy smokes, they understand the differences. And one person saying yes to 1A, but no to 1B, but overall they said 12-0.
What about the cause question then though? Like the same 10 would need to, or the same group would have to, the number one and then number 3, the cause question.
Well, in your scenario, they were unanimous, remember? So they were unanimous in number 1. So then it would be just 10 of you have to agree on causation. Okay, so think it through. We're owed another break, but Mr. Boylan?
Very quickly, if that's Mr. Frankoliak's concern, the court, I think, would be free to ask the cause question as each one of 1A, 1B, 1C, 1D, 1E, and 1F.
Right, I thought about that, and I'll do that if that's
his
what he wants.
concern.
It's just a lot more questions.
No, I know. I have a lot of other issues, but that was just one I was broaching
Okay.
now.
So do you want me during this next break to add in causation under 1A, 1B, 1C?
No, because my argument went, at least for question 4, which is the hospital one, is that I just want the ultimate fact, negligence, cause, and there's other arguments. I don't know why we need any of the other ones in there because they're not going to do us any good.
Position, I'd want the same thing. I mean, I think that's fair. So I appreciate your advocating. I'm just trying to do it in a way that we're going to get answers from the jury. So my plan would be to do the same format. And so would you want causation under 4A and causation under 4B?
No, I'm going to argue that I want the opportunity to argue that for 4, I don't want the sub questions at all for various reasons.
Okay, and I think you've argued it. Do you have other arguments on that you want to take up after the break?
Yes, I have a few other things.
Okay, so I think we've covered to the extent we need to that the motions after verdict, both at the time that the plaintiff rested and at the time that the case was finished in full, all of them have been denied other than the battery claim. There's the DNR statutory claim, which has been undecided, which we'll talk about when we get to the instructions. And there's the declaratory judgment by you, Attorney Frankoliak, regarding the nurse having no responsibility, but I think we're answering that by the way we're doing this too. So those two are kind of still there, but the rest of them are denied. Take a 15-minute break. Is that good with everybody? And then what are our thoughts on being done today by 5 with this?
I'd like to be done today by 5, Judge. I'll answer your questions on if I can dispute your question. I wouldn't ask the questions the same way that you do, but your question, I don't find them unreasonable. And your question to me is that question okay? Yes, it's okay. It's not how I would write the verdict. I think we could be done.
I think we can be too. It's just a matter of what's reasonable. I think if we do it, it's going to be after 5 probably. Or we have the jury come in at 9 and we meet earlier in the morning and finish it up. At some point, we're just got to be done arguing and we're just going to do things. And I probably let the last half hour get away from me, which I'm not going to allow. Again, we're just going to dial in and focus. But we need to call the jurors like we told them we were going to call at 3 o'clock. It's now 3:15.
I think we can be done with all this today and have the closings tomorrow morning.
It seems like it's a little optimistic. I mean, thinking that it's after 3 already, and we haven't even started on we don't have the verdict form yet, and we haven't even started on the instructions. I'm concerned about. Are we going to be able to get that done tonight? I don't know. I think there's some issues that still need to be worked out on the structure here, and then the jury instructions will take a little time after that, I would imagine. Depends how long we want to go tonight, I guess.
We submitted proposed instructions. We might only ask for one additional on emergency. There was no response to I don't think there's a difference on the instructions. I don't think the instructions will take a long time.
Okay, let's try to get it done. We'll take a break right now until 3:30, and then we'll come back. And I'll talk with the bailiffs on what they're going to do with the jurors. We'll see everybody at 3:30.
She doesn't have to be separately there.
No, I just want to talk on this case.
Right.
So when we instruct,
There's absolutely no evidence in this record, file as to the fault. Even if we see that there stipulate that Dr. Shokar was an employee of the medical group Fox Valley, under the law concerning vicarious liability in a medical malpractice case, Cameron governed, and Cameron says that it's not sufficient to show to establish an employee-employer relationship for there to be vicarious liability. It has to be a master-servant relationship with evidence of control. And there is absolutely no evidence in this record. In fact, Ascension Medical Group Fox Valley, I don't believe was mentioned once, other than when this court reduced the case.
so your position is you want Dr. Shokar to bear the responsibility on his own if he's found to be negligent in any way and not have the protection of his employer? Is that what you're arguing?
Well, he's got
Seems like a conflict. maybe just change gears a little bit. Are you asking that Mr. Schara be on the verdict? You said yes? Okay, so if we go to that part of it, I think it's question 7. The way that I drafted it is on 7. Okay, so it's the first number 7.
The wording would need to be changed a little bit, I think.
Okay, to what?
Right. I would suggest something along the lines of this. Scott Schara was negligent with respect to his decision making as it related to the provide
Right.
or with regard to decisions made related to the Schara and to provide it's really not an overt action or admission that he was jury to look at.
Okay, so not decisions made, because what happens if Dr. Trokar made a decision or somebody else made a decision? So I think we'd want to direct it to him, right?
Yeah, Scott, maybe it's Scott Schara's capacity as negative with respect to his decision making as it related to
That, but I'm just trying to type it down. So was Scott Schara negligent in his role as power of attorney, or you said advocate?
Would be decision maker if in fact he was power of attorney. Was he negligent in his decisions?
Okay, so was Scott Schara negligent in his decisions?
Or decision making as relates to the care and treatment, something like that.
and actually, I don't think that it matters whether he's a patient advocate or power of attorney because he was the one that.
Okay. Was Scott Schara negligent in his decision making as the power of attorney for Grace Schara?
With respect to the
Okay, with respect to his decision making as the power of attorney for Grace Schara between October 6th and October 13th, is that what you're asking for? And then do you want it broken out, specific instances?
no. For the same reason that you don't want the same thing.
That's why I would add them in if you want it, but if you don't want it, that's up to you. Plaintiff's position on that?
Our position is that there's been no testimony that Mr. Schara was the proximate cause of Grace's death. There's been no expert report filed about that. There's nothing in anybody's expert report. There's nothing in anybody's expert deposition about that. There's a lot of talk about alarms and so on. Nobody ever testified that that caused any harm to Grace actually. And Mr. Schara should not be on the verdict in this place.
For argument or counterpoint, there's not a lot to argue, but I guess there's evidence that a decision was made not to intubate her, and there was incidentally testimony from the experts that intubation was the only thing that could have saved her. So no one is specifically writing in their report he was negligent, because no one's necessarily going to say that. But the evidence is such that this decision was made to take that tool out of the toolbox, and that the fact that tool was not in the toolbox was a cause of death. So that incidentally, it's all there. It's all in the record. Whether anyone argues it or not is a completely separate issue, but that's why we would say legally, I think it's proper.
No one testified.
His duty. What was the duty that he breached? In order to be negligent, right, you have to identify some duty.
Ordinary care, normal care. Ordinary care is to make decisions that a normal, ordinary person would make, and I guess that's for the jury to decide if that was done. You know, the doctors say this is, you know, we're getting to a point where we need to make a decision. This is something that, you know, she's not going to survive without certain things, or she's not going to be able to breathe on her own. Being able to make a decision one way or another, I guess that's clearly ordinary care.
So would it be better to say, you know, assuming that this goes in, which I'm not convinced it is, I'm just trying to draft the way, but was Scott Schara's decision to not intubate a breach of the ordinary care, similar to how I worded it for the doctors and the nurses?
Because it's not a professional standard, so it's like, it's just, was it a breach of what? Not really breach. Was it a failure of ordinary care to, I guess, to make that decision in the face of what was going on? So.
That's the only thing you're going to argue, is that was the breach of ordinary care?
Well, I don't know what I'm going to argue exactly.
Agreed.
But in terms of other areas of negligence, the clause that was very determined that the refusal of tocilizumab was a failure meet the ordinary care. Was, if the jury believes that, you know, we do have these issues with turning off the alarm, or the behavior exhibited in the hospital affected cause harm to Grace. That's ordinary care.
Or potentially delay of care while using, you know, the FLCC protocol at home. I mean, these are all things that did come up at trial.
Then maybe we need to change the word negligent.
You might need to, if you have the wording specifically limited between the 6th and the 13th, then I would probably have to expand it a little bit to cover decision-making before, then like the 10 days before the hospital. If you were going to.
Not in this case, right?
Entirely new.
I mean, if that's what you were going to do.
No, that's not what I meant is, so I'm looking at question 7. Right now, you guys have asked me to word it the following: was Scott Schara negligent with respect to his decision-making as the power of attorney for Grace Schara between October 6th, 2021 and October 13th, 2021? And I'm uncomfortable with the word negligent. Because I think what you guys have said is, has he violated, or has he acted less than the ordinary care? Has he provided something less than ordinary care? Isn't that the word we should use?
That is.
Okay. And then 8, 9 are the follow-up questions on cause and cause of pain and suffering, and then cause of death.
I don't know, court saw the brief, so continue to believe that the separation of the separate pain of suffering not with the law.
Okay,
Right.
maybe now's the time to finally ask or get an answer, because I've asked. What is the plaintiff's position with respect to damages on the verdict form?
Judge, our damages, let me pull that one out. Let me pull up the correct document. 1 second, please. So document 366.
Okay.
Which was our proposed instructions. Page 15.
Okay.
Personal injury, negligence in informing the patient. It's on page 15. We believe that we're entitled to have a line on the verdict for those damages. We believe we're entitled to have a line item on the verdict for the funeral expenses. And on page
So, and I'm on page 15 with you. Maybe let me back up. Do you believe the damages are different between the death and the injuries?
yes. Yes.
And Attorney Guzzi, do you agree with that? Let me just stop you, because they could cause injury in this case, but not cause the death. Right, so let's just pretend that the jurors say they were negligent by the way they administered the Precedex. But we don't think Precedex caused her death. So they could say, well, there was an injury, but not death. That's why I have it separated. Because I think in this case, which is what we're drafting these instructions for, we can rely on other cases, but we have to use sort of what has come in at trial. And I think in each of those questions, did you violate, for example, informed consent? If they find yes, they could say, well, it didn't cause any damages or caused the death or didn't cause any injury, you know. Sure. When we get to the damages, I just did it roughly because I still don't know what the plaintiff's asking for. So.
Well, let's be clear. I'm going back to it. Now is not the appropriate time, but in terms of the breakout of the question, let's assume that the jury answers question 1 yes.
Okay.
Then they go and they get to question 1A, which is, did the standard of care require Dr. Schara to give informed consent? They say yes. Then they go to question 1B. We find that Dr. Schara was negligent by ordering the use of informed consent. So that this no. Here's your verdict.
I'm back to inconsistent. I thought we were talking about damages.
I could answer the damages question.
That's why I go back to that or if you want to put that on.
hypothetical on the damages, but see, I don't see that being inconsistent.
How can a doctor be negligent, causing negligence, not obtaining informed consent, but not causing negligence for actually ordering the use of it? That's totally.
I think that's why the informed consent needs to be broken into a separate question rather than included in like the pattern jury instruction for that very reason, because you have to be negligent for the prescription before you can be negligent for failing to get informed consent for that prescription.
Okay, Attorney Boylan.
So Judge, your question to me was, what are the damages? And I would,
That's what I thought I asked, and we're off back on this other thing.
I'm ready to answer when I
Okay,
can.
so I'm interested in listening to damages.
Yes. So the document that I had brought up, document 366, we submitted this back in April. Page 15, personal injuries from negligence in informing the patient. That's a pattern jury instruction, 1741. Next, estate's recovery for the medical, hospital, and funeral expenses, 1850. And then next, 1855, the estate's recovery for pain and suffering. And that's also a pattern jury instruction. The law provides that the estate of a deceased person is entitled to be compensated fairly and reasonably for their pain and suffering. And then the death, because they're different injuries. Her dying on the 13th is different than her being what we say would be overdosed prior to her death. So different injuries. And that's it, Judge, it's that simple.
So let me just make sure, and I have that right in front of me, but how do we word that under the damage question then?
So on your verdict that you sent to us, Judge, which is at page, is that question 8, correct?
It's numbered 8, but it's like the second 8.
I'm sorry.
It's the last question.
Yep. So it would be I would be happy with the titles of those proposed jury instructions. And then the jury can look back at the instruction to see what it is they're putting on that line. So what I think is missing, so we would cross out loss of society and companionship. We would cross out past pecuniary loss and future pecuniary loss. But we would have those elements of damages, which I just pointed to in our document 366, as well as her death.
So in your answer, you skipped 1756. I'm not sure if that was intentional.
We didn't get a stipulation on that. And in our 1756, we said we should get a stipulation. We don't have one, so we're skipping it.
That's different than the 11,000 that we're talking about, or that there was a stipulation?
I thought we had a stipulation on that, but the issue was then the collateral source rule and the lack of, this is paid by United Healthcare.
Okay, so you're not asking for past healthcare expenses?
No.
So going back to question number 8, the damage question.
It's the personal injuries from negligence in informing the patient. And it's the estate's recovery for the pain and suffering. And the pain and suffering was on multiple days. So the pain and suffering also results in her death. So then there's another line item for her death. And I imagine the defense is going to argue they didn't cause the death and they didn't cause the pain and suffering. That's fair. But I believe that those are all appropriate line items.
key here is that there is
I have funeral and burial expenses, personal injuries for lack of informed consent.
Yes, Judge.
Okay. On 1756, you're not asking for anything.
Correct.
On 1850, that's titled Estates Recovery for Medical, Hospital, and Funeral Expenses. I think we've covered that with the funeral and burial expenses. Or do you
Yes,
think you need
Judge.
it? Okay. And then you want a line that says pain and suffering by Grace, and then pain and suffering to the estate.
The estate's recovery for pain and suffering, which is 1855. So, and recovery for wrongful death, which is along the lines of the pain and suffering, but the pain and suffering came before she died, but the death was the ultimate result of the medical negligence.
Take it, you don't have an agreement on that?
no.
What part of it?
Oh, I'm sorry.
What part do you not agree on?
Pain and suffering is a claim, and it belongs, I think, to the estates. There's one pain and suffering claim. It's whatever they give for pain and suffering. I don't know why you would break it out into pain and suffering is just pain and suffering. From our earlier discussion, I would object to the funeral expenses because there was no evidence of funeral expenses in the record. It was brought up on, today for the first time. It was long after the plaintiff's case in chief had arisen. I think the only element of damages that would go on the verdict would be a single line item for pain and suffering belonging to the estate of Grace Schara. And I think that would also eliminate that there's no reason to break out separate questions for wrongful death and negligence. I think the question is just, it would be cause the pain and or death, or just it can be one, because the Rennet case specifically says there's no logical distinction between injury and death claims arising out of medical malpractice. Once medical malpractice produces a loss, a remedy exists regardless of the consequence, regardless of whether the consequence is injury or death. So there really is no reason to break it out. There's only one element of damages. Doesn't matter if it's injuries or death, it's pain and suffering. So that we can shrink the question from, take two cause questions out and just make one question instead of a separate cause question for injury and a separate cause question for cause of the death. We can just say one cause question for did the negligence cause injury or death to Grace Schara? And then there's just one line item for the damages.
Your damages are the same based on what you just said, whether it was injury or death, right?
No, I don't think so, Judge, because there's different days. There was medical negligence on multiple days that resulted not in her death, but that resulted in pain and suffering on those days. On the 13th, it resulted in her death, the medical negligence, but on the other days, it resulted in pain and suffering that did not result in death.
We're asking.
Right. No distinction between pain and suffering resulting in death. Because under the wrongful death statute, there's limited things that you can get in, like funeral expense, pecuniary injury, loss of sight and companionship, but that's not available for an adult child in a medical malpractice case. So it's just pain and suffering regardless. It's one pain and suffering for whatever pain and suffering the jury feels she established, whether it was on the 6th, the 7th, the 8th, the 12th, the 13th. There's only going to be one line item. There's no, you wouldn't break it down like pain and suffering on the 6th, pain and suffering on the 12th, pain and suffering on the 13th. It's just one simple pain and suffering. Whatever they lump in there is what they lump in there. And then there is no distinction between death or injury. So that's where we can just take the two cause questions for each one and make it a simple cause question that just says pain and or death.
Going back to the simple, in an auto accident case, we don't break out and stuff like damages two the plaintiff for day one of the accident. Day 7, while they're here. Day 23, well, it's better, but they're still here. You just say time frame from, you know, when the accident occurred to whether it's the time of trial or time of death. That's your measure. Don't get too picked with the cat on it.
So, Mr. Boylan, the instruction that you provided, which I expect I'm going to read, either all of it as is or most of it. The estate's recovery for pain and suffering indicates the law provides that the estate of a deceased person is entitled to be compensated fairly and reasonably for the pain and suffering endured by Grace Schara from the time of the incident up to the time of the death. Follow along?
See that?
Seems like it's from the time of the first breach, it might be October 7th, up to the time of her death on the 13th.
Okay, but the word is the incident, and there were multiple incidents of medical malpractice. There are multiple breaches of the standard of care. As Your Honor asked earlier, right? Somebody can have medical malpractice and not die, and that happened to Grace on the 10th, 11th, 12th, 13th. So those are different incidents.
In those cases, they give one pain and suffering. That's what you say. Okay, in this, you take a different version of medical malpractice case. You have lack of informed consent on a surgery, and then the surgeon botches the surgery anyway.
And then does a surgery the next day and botches it again, and those would be two different incidents.
I think if there were two surgeries, I think there'd still be one damage question, right?
I don't think so, because they're different incidents. They're different incidents of medical malpractice. If they did heart surgery one day and then a hip surgery the next day, that would be two different incidents of medical malpractice.
All right, so let's go back to your items of recovery. So you have funeral and burial expenses, personal injuries for the lack of informed consent, and that's
Yes.
only if they find a violation of the informed consent. And then the estate's recovery for pain and suffering.
Yes, Judge.
Okay, and then did you say something about, did you have another one that I missed?
I don't believe I did. I had unless you just had left off the funeral expenses, but no.
So there's only three lines. And those instructions,
It depends on whether the court is breaking pain and suffering together with wrongful death. I believe there should be a separate question for the death rather than the pain and suffering, because she didn't die until the 13th, and she suffered on the 12th and the 11th and the days before.
so what instruction are you asking for with respect to the wrongful death damage?
That same instruction of the state's recovery for pain and suffering. And it may also get into on the lack of informed consent, because if the DNR order, which was placed without informed consent, resulted in her death, the jury could award damages there.
So I want to just, so if I read 1855, seems like the jury is being instructed to evaluate the pain and discomfort and suffering that Grace endured between the time of the accident or the incident and her death. Correct?
Yes, Judge.
And so nothing regarding the death.
I do think there should be a separate line item for the death. I don't have an instruction to point you to at this time.
Okay.
I'm not aware there's any, I guess, level of damages just for death. It's what the law allows. Whatever the law allows for wrongful death is that, I mean, death, there's not a separate thing. It's pain and suffering is an element. Death is not a separate compensable thing unless it's under the wrongful death statute. But we don't really have those issues. It's just pain and suffering.
What about like future pecuniary loss?
Well, there is no future loss because she's passed away, so there's nothing beyond the point of death. So it's just whatever the pain and suffering was from the first alleged negligence until the time of death that's where the lump of pain, whatever pain the jury believes she suffered in there. Anytime we're in there, if they think there was negligence, that's what it would be. If they think negligence was only on the 13th, then they'll just do that. They'll say, okay, it was only on the 13th. If they believe that the negligence caused injury on the 7th, then they would consider that and put the entire time between the 7th and the 13th on that one lump sum. And then it's very simple. There's just one line there, and that's all they award. If they whatever they want to do, they can do it on that one line.
Okay. I just want to make sure, Attorney Boylan, there's no other damage amount other than the 3 lines that we've talked about with the instructions that you submitted that you're asking. I know you're asking for the wrongful death, but
That would be the 4th line, the death.
okay. And how would we instruct the jury on that?
Worth, as I indicated, Judge, I apologize. I don't have an separate instruction on that. I think the jury could place that under an instruction very similar to 1855, or the jury could place that under the negligence in informing the patient, because that negligence in informing the patient ultimately led to her death. So that's where that could come in.
Okay, so you just argue that death would be the personal injuries?
The death would be the injury as a result of the failure to inform.
Okay.
But the same thing, Judge, I do think there should be a separate line for death. It could come in under either of those.
I guess I would object. There's no instruction for it. They're not going to know what to do with that. Just going to say death. I don't even know how you would instruct them for that. There's no statutory damage just for that without an instruction. I think it's just got to be a single line for pain and suffering. That's the only collectible damage here.
Is there pain and suffering for the family members, or just for the pain and suffering that Grace had?
For the death itself?
No, just in general.
It's pain and suffering for the negligence, whether it resulted in injury or death. That's what the Rennick case was saying. Once malpractice produces a loss, a remedy exists, regardless of whether the consequence is injury or death. If they find malpractice itself was part of the injury, but the pain and suffering, there's no separate pain and suffering associated with death as opposed to whatever pain and suffering was associated with the negligence that maybe caused the death. I think we can do the cause question by just saying injury or death, and that's how you put them in together. Once they find an injury, it doesn't matter whether it's injury or death, they're going to be entitled to that level of damages.
What I'm going to do, Attorney Boylan, is in your number C, you asked me to title it "The State's Recovery for Pain and Suffering." I think the better word might be past pain, suffering, and disability. That can include what you've argued today, and potentially other things. So how much you put on a death. Past pain, suffering, and disability.
Okay,
and the state's recovery for pain and suffering. And that's what the defense wanted as a word. I think it probably better fits and provides you more opportunity for argument.
But you're saying only past, not the death. Okay, I actually,
from today.
I get it, Judge. Yes, thank you.
Okay. And with that, then, Attorney Boylan, is there a need to distinguish between injury and death? I'm starting to agree with Attorney Mikuliak that those can be combined.
You said it's the recovery for past pain, suffering, and death?
No, the way that I will word it, let me just find it again. Past pain, suffering, and disability. Any objections to that from defense?
Just one line item for past pain, suffering, disability?
Yes.
Yeah, no objection.
That can include death?
Because the past pain or the disability may be the death if they find that.
Thank you.
Okay. So if we take that, we go back up to the questions like 2 and 3 and 5 and 6, I think we can combine those. Was such negligence by Dr. Gavin Chokar a cause of pain and suffering? You worded to say a cause of or death?
Right. Did the negligence cause injury or death? Then you can put them together and it covers both situations.
What about injury and or death? So if they find that it was both.
Yeah, injury and or death, that works. Yeah, there's no difference. Yeah.
Attorney Boylan, any objection to that?
Just one.
Okay.
I don't believe I have an objection, Judge, and I thought I had just followed up on this, but I'm asked to be sure of this, that the past pain, suffering, and disability, the jury will be instructed includes death.
Yes. We haven't gotten to those instructions, but that's the idea.
Included on the verdict that's going to be, it includes death.
It has past pain, suffering, and disability, which is consistent with what I've done in other death cases.
Okay.
In the instructions, we'll itemize that line can cause bodily harm, and without consent. Right? So, and we'll come back to that when we get to the instructions. So I'm changing the questions, so for example, number 3 will now deal with the hospital, because we're getting rid of the existing number 3.
And we're changing the wording on 2.
I did, yes. Print out for each of you an updated version of this as soon as I make these changes that gets us updated. The font or the separation between pages will not be perfect, but at least it'll give you a current version with the current numbers since we're removing a lot. Give me a few minutes. We want medical care and treatment to continue to be given. Informed consent in any of my battery discussion, because battery does. So when we get to Mr. Schara in the jury question, we would change it to be the same, right? A cause of injury and or death.
Sure, yes.
Judge, have you decided whether you'll include that or not?
No.
Okay.
It's on the form right now because it hasn't been ruled out.
Defense has been consistent that it was in order for her to be able to.
Okay, so one question that I have, print this out so you have an updated copy. So we're really down to 8 questions. 1 and 2 as it relates to the doctor with the subcategory still. 3 and 4 as it relates to the nurses or the hospital. 5 and 6 as it relates to Mr. Schara. 7 is the comparative question, and 8 is the damages. Okay. I think this was mentioned before. But is there a requirement that we distinguish between the cause for negligence and informed consent? Pretty comfortable with the way that we have it drafted.
Yeah, I think in negligence and informed consent really should be separate questions with their own separate cause questions. I think that's why I think the pattern instruction, I think what Attorney Guzzi was mentioning there is that the way they're currently kind of mashed together in one, there is a potential for an inconsistent verdict there. I think we would have to break out negligence cause for Dr. Shokar and then separate negligent informed consent cause, negligent informed consent cause. So there's like separate ones to break those out. Then we're keeping the negligence and the informed consent separate.
The verdict form I sent over the weekend, that was the negligence only. That sets out, I mean, it's not that far off. I don't think it's that far off the stuff proposed, but it stays within the construct of 10.1. But the only thing it really does differently, I think, is that it puts the medication as one.
And I would be fine with that too, because that's an ultimate verdict question, I think, which is similar to what I proposed.
Not sure what you mean similar to that, so let's, show me something that you're proposing, tell me where to look. Well, yeah, because you're the one who said it, so when you sent me something, I've received a lot, so.
Right.
I would say I disagree that this 1023 is the appropriate type of instruction to use. It talks about available treatments, reasonably available alternatives, and that's not what the issue here is with informed consent.
Yeah, so if we don't get bogged down on the wording, my concern was if they were to answer question number 1, yes, and does it matter for the comparative negligence if the yes was a standard of care violation or an informed consent violation? Mr. Guzzi? And if the answer is no, there's no difference, then I'm comfortable with the way that I've drafted it. Okay. So I think what you suggested is, and Attorney Frankowiak, that there should be a difference with the questions of, I think what you, ultimate fact questions that you want for informed consent, correct? Okay, so my question is, first answer question number 1, yes. And all of you now have an updated copy of the jury instructions, but if they were to answer that yes, for purposes of the comparative negligence question, does it matter if that negligence was a breach in the standard of care or an informed consent violation? Go ahead, Mr.
I think even under my verdict form, the one I submitted, there isn't a separate, in the comparison, there isn't 2 entries for Dr. Schokar consent, Dr. Schokar treatment. If he's found, if there's negligence cause determination on either one or both, then he goes to comparison. I think that answers the question.
I think you did too. And if that's the case, which I think is what the right answer is, then the way I have it drafted, and you have the updated copy in front of you, if they were to answer number 2, yes, which is the cause for Dr. Schokar, number 4, yes, which is the cause for the nurses in the hospital, and number 6, yes, with Mr. Schara, or they answer 2 of those 3 yes, then they need to answer question number 7. Okay, good. Then I think I like the way I have it drafted. Then. So, Mr. Guzzi's on board with that. Mr. Boylan, are you on board with that?
Yes, Judge.
Okay, then Mr. Frankowiak.
Well, I guess I'm only concerned about question 3, and again, I don't want the breakout questions, I just want the ultimate question. what were the nurses of the hospital negligent, and was that negligence causal? There are a number of issues with that, and I would prefer just to have those two questions. I don't think there's any reason to break them out. I'm concerned that those extra ones are superfluous and potentially confusing. And I think we're also, we're picking things and we're offering them to the jury here. For example, like Eichinger had like 13 different things, and we're picking certain things and serving them up to the jury as if we're putting them out there rather than just letting the parties argue. You know, you heard this, they were negligent because of this and this and this and this. They just have to, whatever they want to pick out of that, whatever they want to pick out of the argument, they're going to say, okay, I think they were negligent, I think they were not negligent. Rather than serving them up, well, why don't you look at this and this and this? We'll pick out 6 categories that we want you to take a look at. I would prefer not to have those in there and just let them answer. There is, and for one thing, there is no reason to, because as soon as they say yes to the negligence and then they say yes to the cause, boom, they're entitled to go right to that damage question. They're entitled to answer that damage question, and they're going to get those damages. Whether or not, you know, question 3A is yes, question 3B is, it's a completely unnecessary exercise. And that way we're just letting the jury have free will to do what they will with whatever we place, rather than picking and choosing issues and taking 6 out of the 13 Eichinger things and putting them on there. We're just letting plaintiff make his argument, defense make their argument, jury determines, okay, I think they're negligent, boom, negligent, cause, go right onto that damage question, lickety split. It'll be easy for 10 out of 12 to get. There's no reason to break them down, because we're not trying to parse damages here. We're not trying to, there's no real reason to add them at all. We're just overcomplicating and overthinking things. No one's going to care one way or another, whether, you know, 3A, 3B, 3C, but it is complicating. And I mean, I frankly have some problem with some of the wording here. For instance, some of these things could be, I think they kind of encroach on.
Let me, before you get to the wording, because then we'll talk about the wording. So in response to what you said, you know, any suggestion that the court was picking things and just throwing them on there.
Well,
let me just finish if you don't mind, because I let you talk. I think that's a little offensive. And I can explain each one, which we'll do as you start picking apart the wording. So what I did is I looked at the 13 items that Nurse Eichinger testified to, as you've just referenced a couple of times. Because I think when you go outside that box and you're doing something, but doing the best that you can do, which was the stuff on October 7th doesn't relate to Dr. Schara. There are a lot of things that I referenced earlier that relate to the nurses in the hospital that are not included on this form. And the reason is because I don't think it rose to a cause or a violation in the standard of care. It was coupled with something else. I'll just pick one example out so you can understand what I'm referencing as an example. There was argument that you know, the individuals at St. Elizabeth Hospital violated a standard of care at the time of admission on October 6th. I think we spent more time on that again today. You'll notice that there is not a question relating to that. Now, if the jury were to find that that was a violation, they can still find it and answer yes to number 3 if that gets argued. But in my mind, that issue wasn't a separate question, because I thought there was implied consent by Grace Schara, Scott Schara, verbal consent by Grace Schara according to the exhibit, and then ongoing consent by Mr. Schara after the fact, as he and his daughter stayed in the room for several days. So my thought was, I'm not going to ask that separate. I'm not going to stop the plaintiff from arguing it. They seemed to suggest it throughout the trial, but I just didn't think it was worthy to put it on there for the jurors to answer. The one that I did, just so you have it, Mr. Pinkoliak, is question 3A. So I tried to do it in some order. But the first one in 3A is, we find that the standard of care required the nurses at St. Elizabeth Hospital to inform Grace Schara or her power of attorney of the medical event on October 7, 2021 involving Precedex, and they failed to satisfy that standard of care. That is, I think, a genuine issue that they can answer yes or no. It's been talked about most days of this trial. There have been opinions, expert opinions on it, if they believe those expert opinions and follow it, on both sides. So they can rely on the expert opinions and come up with an answer. I worded it in a way where it wasn't assumed that there was a duty or that I was suggesting a duty. So in order to answer that yes, the jury has to conclude that, number one, there was a standard of care that required the nurses to inform Grace or her power of attorney. And second, that if there was a standard of care, whatever that was, they failed to satisfy that standard of care. So it's like a two-pronged question before they answer that yes. I also drafted it in a way that the burden of proof will remain on the plaintiff in getting that answer yes, because the yes answers require the burden of proof. So that's the reason for drafting them that way. And it wasn't just picking apart and picking wild ones. It was going through the evidence and really trying to think through in an organized way which ones are combined with another one, which one applies to nurses and hospitals, which one applies to Dr. Schara, which ones apply to others that aren't a part of this case, and how do they all interact and relate to one another. So you want to pick apart the words, but before you do that, did you get that issue resolved? Okay, and then is she following up with you? Okay, thanks. Go ahead, Mr. Frankoliak, with wording on number 3.
I guess what I'm trying to do is make it as uncomplicated as possible. I'm not sure exactly what it's telling us to break it down, because really they only have to answer that ultimate question is, were they negligent and was it causal? And as well crafted as these are, I'm just not sure if there's, like, we don't need to know specifically what the answer to A, B, C, and D is in order to get to the damage question. It's there, but we're introducing language, or kind of like we're introducing stuff that the jury now has to consider that's not ultimately necessary. For example, if I were to have a problem with the way one of these things were worded, I wouldn't have that problem if they were gone, and we'd still have that ultimate verdict. We would still be able to get the jury's verdict here. For instance, I'm concerned that some of this stuff might touch upon, like, informed consent. We know doctor or nurses in hospitals don't have informed consent duties, but for example, we find that for 3A, we find the standard of care required the nurses to inform Grace and her power of attorney of the medical event involving Precedex. Well, I think that's arguably a doctor's duty. The doctor who was on duty at that time.
You can argue that. So you can stand up in front of the jury and say, answer 3A no, because the duty was on the doctor.
Well, the informed consent is on the doctor. What would happen is, if an event occurs and the nurse reports it to the doctor, we did this, then the doctor would be the one who would have the conversation with the person. The nurse is he's like the conduit. The nurse reports to the doctor. Like, the nurse doesn't go straight to the patient. Oh, I got to tell you about this. The nurse reports to the doctor, because that's what the testimony was.
Well,
nurses implement the orders and they keep the doctor.
Nurse Haynes testified when you called him yesterday.
I'm sorry?
Nurse Haynes, who was your witness, he testified that it's his normal practice that he would have informed as it was going on. So as the event went on October 7th or October 8th, that, his normal practice would have been to inform the people there. Like, this is what happened, we're going to adjust it down. That was his testimony.
But that is his personal practice, is to try to develop a rapport and talk to people, but that's different than what the standard of care is.
That's why this approach, it's the best approach. It preserves that issue for future litigation or future issues, but in my opinion,
channels to the doctor, because the nurse keeps the doctor involved, and then the doctor goes back and has that conversation. I mean, and these are questions we could completely eliminate, completely, if we just didn't put the superfluous question in there. I also have some concerns about maybe it's hard for me to kind of understand what's, like, for instance, 3C and 3F. It just says, they're both kind of similar. It says, we find the standard of care required the nurses at St. Elizabeth to communicate with Grace Schara and a power of attorney, and they failed to satisfy that standard. That's very broad. To communicate, like, did they not say hi? Did they not say something? I mean, my concern is that's so broad that encompasses everything. Did not communicate to them. Does it mean didn't say hi? Didn't call them? Didn't say I'm fluffing your pillow now? It's so broad. I don't understand that. I don't think the jury's gonna understand it. And I guess my biggest concern is that it's really not necessary to get where we need to go. Because as long as they just have that simple question, were they negligent? Yes. Okay, that's all we need. We don't have to confuse them. We don't have to open any other doors. We don't even have to have me sit here and say I have problems with this, because all those things go poof if we don't have these breakout questions. That's why it will eliminate the possibility for appeal. It'll eliminate the possibility for any concerns. If there's any concerns about the wording of any of these little, A, B, C, D, E, F, those all create potential issues for argument and appeal.
Now's the time to deal with the wordings, and you're saying you don't want to argue about, so it's not going to go poof. I'm not going to take them out. So what's the wording you'd like to have me consider?
Oh, I think it's exactly on the same thing. I think my wording on the version that I sent to you this weekend, I think.
I'm talking the version that I just handed to you, which is the
Oh.
updated draft.
Oh, sure.
We're
The
talking
version you
three-
have, I would say,
3A through 3G.
I would say question 3, was one or more of the nurses at the hospital negligent with regard to the care and treatment provided to Grace between October 6th and October 13th? And then just go right to 4, which is such negligence, was such negligence by one or more of the nurses of the hospital a cause of injury or death? Boom, those 2 questions alone, jury answers them, and they're done with the hosptal.
Okay.
That's
So
what I would
do you have any other questions or issues regarding the wording on 3A through 3G?
No, in fact,
All right, good. But then I think we have a kind of a start to the instruction, or to the verdict form. Yes, Attorney Guzzi.
Since I'm obviously not going to persuade Your Honor to follow my point of the verdict, and all the inherent issues I see with it, in terms of specific wording on 1B, I think there's a problem with the language to slow the breathing with Grace Schara. Because yes, that was his intent, and that was what happened. But that doesn't make it negligent. So I think if we just stop at October 13th, 2021, with that question, aside from my overall objections, I think that's a better way to phrase it.
It was the worst clinical decision he's ever seen in 47 years of practice.
They can argue that in the closing. I think if the battery claim happened, this issue seemed to come up a little bit more in the context.
What I did is I tried to go, well, not
not including that phrase does the job. They can argue why for ordering it. I do think that last phrase also kind of shows that the effect may have been negligent.
I think it's problematic if it's not included, because then you can read this and say, was he negligent in ordering morphine on the 13th? Well, simply by ordering morphine, no, he wasn't. Well, was he negligent by doing it in order to slow the breathing? It's a different question. Yes, he was. And we can argue this in front of the jury. I don't think there's anything incorrect about it, and I think if it's left out, it's more problematic.
Okay, so let's just take 1B and indicate that the word order was put in there because that was the action that 2021 without informed consent. correct, Mr. Boylan?
Yes, Judge.
Okay, so I like the word ordering because that's the act that he did that would be under the standard of care if that's what the jury finds. If we take out to slow the breathing of Grace Schara, I think we'd change it to say, by ordering the use of morphine on October 13, 2021 to Grace Schara. If we did that, you would be able to argue that his testimony was, and that he did it with the purpose of slowing the breathing, and that is, under the standard of care, because slowing the breathing would take away the one thing that was keeping her alive, I think is what Dr. Burdine said.
Yes.
Okay, what else? Mr. Guzzi, is that it?
I would, and before I think ask a question about cause questions, I do think there should be separate cause questions.
Okay. By each one, you mean 1A through 1F? Okay. I don't think that's necessary. Your note, there's noted on the record.
That's my record.
Anything else, Mr. Frankowiak, with the way that the verdict is drafted?
No, I guess my only concern is just, I want just 3 and then jump right to 4. And if that's done, I'm fine with what we've got so far.
Okay. Mr. Boylan, anything else with the verdict form as drafted?
Yes, minor issues, I think. On question 3E, Judge.
Okay.
For example, you use the words, or the verdict form uses the words "to effectively communicate." But in question 3C and 3F, the word "effectively" is not there. I think it should be there in all 3.
And in rejoinder, I guess I would just say that my hope is that those questions are not even asked anyway, so it doesn't matter if we're done.
I would just ask to have the floor to go through this one time.
Say that again?
I would just ask to have the floor to go through this one time.
Sure. So you're asking in 3E.
3E has the word "effectively," but to include it also in 3C and 3F as it is included in 3E. The word "effectively" does not appear in those 2.
Okay, anything else?
Yes, Judge, let me just, 3D, we would agree that 3D could be struck.
Okay, let me take a look at it. So you're asking that we take out the question about the eviction of Scott Schara?
Yes,
Why is that? We spent a lot of time on it at trial.
we did, Judge, but where I think it becomes causal is when Jessica isn't allowed back in for him, and then the verdict has all of those questions. There's a lot of time spent at trial about the alarms and the eviction, and I don't think either of them ultimately were causal. It became causal when Jessica wasn't allowed back in. No issue with alarms of Jessica, no issue with COVID of Jessica, no issue with PPE with Jessica. We would agree to have 3E removed.
Okay. Any issues with that? Oh, yeah, you want?
I just want to make sure, I guess my record, I don't have a problem with it. Again, I want all of those sub-questions gone. If any of those sub-questions are going to stay in, I do have issues with the language, the generality of some of those.
Let's deal with 3D first.
Okay.
You're in agreement that that can be removed?
Yeah, I mean, if they don't want it, that's fine. I don't want any of them, so anyone they want to take out is great.
Okay, so 3D will be taken out, and I'm gonna just. Anything else, Attorney Boylan?
Yes, Judge. Question 8. I know we did this one, but this was pointed out to me. Subsequently, C, where it says past pain, suffering, and disability. Maybe there's an issue there with Grace's having an existing disability that might cause some confusion. Perhaps we could change disability to incapacity.
I like incapacity.
I'm sorry?
I think incapacity is confusing.
Okay. I think
Pat
disability is
C.
confusing too. Just, it didn't occur to me right away, but it is.
What about past pain, suffering, and death?
That's what I had asked for initially.
And there isn't, and I don't want to create one, but you can argue death as part of that. And everybody's in agreement with that, right? Okay.
And restating the objection that we don't believe that Mr. Schara should be on here for the reasons given. And Judge, one other thing is that I do think along the lines of the argument that Mr. Barnhart made about the nursing administration of the final 2 doses of lorazepam and the final dose of morphine, that the court has decided will not come in as a battery against Nurse McGinnis. I do think those questions could be asked as part of, are we in section 3? Section 3, the 3 A, B, C, D, E, F, G. I think it would be appropriate to include questions regarding whether or not the hospital or the nurses were negligent in administering those last 2 doses of lorazepam and the last dose of morphine. Testimony came in today, for example, that about the timing that the morphine would take. The nurse said she wasn't there to observe it during that time frame. Mr. Barnhart could he presented all of that argument earlier as part of battery, but I think it now should fall into the negligence category.
And I would certainly object to that because well, number one, there shouldn't be any of these sub questions anyway, but beyond that, there's no expert testimony that's been critical of the actual administration by the nurses. Dr. Burdine was very clear. He had no criticism of any nurse other than Barkholtz, and Eichinger was very clear. All of her opinions, none of them dealt with medication issues. That's been the case the entire time, that no one was critical of, say, Holly McGinnis for violating the standard of care for following an order and administering medications.
I just thought, I think I agree with you. So the reason I didn't include that was I didn't think that there was any opinion by any expert, including your experts, that by administering either or both of those medications, that Nurse McGinnis had violated some standard of care. She was ordered to do something and she did it.
I believe Nurse Eichinger testified that a nurse has to double check with herself whether that order is appropriate and whether there's contraindications, and alert the doctor that these medications may be contraindicated. I believe the defense expert, Julie Davis, also testified to that.
I remember her testifying to it. I don't remember Nurse Eichinger, but I will go back, double check her testimony.
Yeah. And there was a time also today, Judge, when Dr. Shokar, and there was no objection made about the alt privilege at the time. Dr. Shokar testified that he doesn't think she actually could possibly have given those at that time that's marked in the record. So I think Dr. Shokar's own testimony could be the expert opinions necessary on that. The last one would be the fact that Dr. Shokar testified he told her to turn off the Precedex, and there's conflicting testimony about when it was turned off. So the jury could be asked whether it is a breach of the standard of care for her to have failed to turn off the Precedex when ordered to do so. And that was an order.
What's the conflicting testimony? It seems like everybody who testified about it testified that the turning off of the Precedex was done before the administration of the morphine. It's just the record that was entered later indicates that it would have been done after.
They all testified that they would assume that the Precedex was turned off when ordered to be turned off, but the medical record conflicts with that. So, and the medical record is in evidence. So there's conflicting evidence. In addition to the fact that there's also testimony that she was able, at the time that order was written, I'm sorry, at the time the note was written into the record, she was able to reflect the correct time that it happened. Just because she made the note later on didn't mean she couldn't reflect in that note. I actually did this at 30 minutes ago. And it's important because in order to appropriately titrate that Precedex, you need to know what level it was at and when. And if she didn't know what level it was at and when based on the records, she couldn't be titrating it appropriately.
Okay. I'm going back through Nurse Eichinger's testimony, and I don't have her offering any opinions about Nurse McGinnis doing something beneath the standard of care or something wrong by administering the medications that she was ordered to do as it relates to the, that last hour and a half on October 13th.
Fair enough. I believed that I heard her say that, not Nurse McGinnis specifically, but that the nursing standard of care would be that the nurse would need to check herself if given an order and the medications were contraindicated and the status of the patient at the time, she would need to go to the doctor and say, this might not be the correct thing to do.
Okay. Anything else? And again, you can argue that. So just because it's not on there, and they may answer that in number 3 with a yes if they believe you, and maybe they don't, maybe they answer no to A through F and they find that one. So we're at 10 to 5, and I want to make sure we're moving along. I don't know if the plan is, what are your thoughts? I'll just get input before I give my thoughts, Mr. Boylan.
That was my last note on the verdict, and we submitted our jury instructions back as part of the pretrial. I don't think they're going to change other than that possibility of a 1-sentence emergency instruction. We're ready to continue.
Who wants to go first? Go ahead, Mr. Frankowiak.
Oh, Your Honor, I wasn't sure. I just want to make sure that the record is clear. Obviously, my position on the verdict is fairly clear, but I do want to just put, for purpose of the record, certainly I think question 3A and 3B both implicate improperly informed consent discussions. Question 3C is too broad and vague, and question 3F is too broad and vague. Again, those are the reasons I think it would be best to remove them and just go strictly from question 3 to question 4. But I just wanted to make that record. In terms of what we do from here, I'm willing to do with whatever the court wants to do. If we want to do closings tomorrow, Thursday, whatever we want to do.
Okay, Mr. Guzzi.
I think I've made my record on my general objection to break up the question. I don't have to do that on that. Where we're at is if we could get a packet of questions to go through. I think the primary things that need to be resolved are the instructions surrounding the informed consent and what consent wants to do. I do note the time. We'll probably do for another break. And I get it, this isn't the court's problem, but Amendment Hall has about a 6-hour head start on this, so I was just close. So, I mean, I think we're kind of at that threshold where we have to make the call. Are we going to go into Thursday? Are we going to put through the 6th, 7th, 8th? How late do we go? I was hoping that we would be done by 5. That's sufficient time to start closing.
I'm somewhat torn because I'd like to say we're gonna be ready at 9 o'clock tomorrow when the jurors get here. But I'm a little bit afraid of that without a couple more hours of work. So I was thinking, well, can we do the instructions via email tonight? You know, you submit what you want, I put them together, I get you out a draft, you respond back, you know, we work, just say, by email from, we set a time, 8 o'clock to 10 o'clock or something. Or 7 o'clock to 10 o'clock, whatever it is, to allow you guys to go get something to eat. And that would get it ready for tomorrow. And then we could come in at 8, make a record, but I think then are you ready to make your closing, and is that the fair thing to do?
We'll do whatever your honor asks.
Third thing is we could bring them in at noon, give instructions in closing, and then send them home, tomorrow, and they come back Thursday morning and start deliberating.
Necessarily have a problem with that. I think if it was a Friday, that would be different.
Right.
On a Wednesday afternoon. I mean, I think that, and this is the case that we've sat here for 2.5 weeks, and we've taken our time. I think, objections, arguments aside, I think we have been fairly meticulous in making sure we don't rush. At this point, another solid.
Well, and then if we're gonna do that, what I've been trying to wrestle in my head is, if you're a juror, would you rather just have off tomorrow and come in Thursday? They can go to work if they have work instead of coming in at noon. And I don't know, I haven't talked to the jurors, I don't know what their preference is. And one side of me says, if I'm a juror, I'd like to just be told right now I'm off tomorrow and I can go do life things and then come in Thursday and go full speed.
We'll do whatever your honor asks.
I'm fine if we take tomorrow off and do closings on Thursday. I can handle that. If that's what the consensus is.
Okay.
I just know from past experience with jury instructions, there's constant rounds going around with wordsmithing and editing.
Right.
And so try to prepare a closing while also engage in email conversations. Pretty difficult.
I would concur. That sounds like it might be difficult.
Okay, so why don't we plan on, we'll call the jurors, tell them Thursday morning at 8. We'll meet tomorrow at 9. Or do you want to meet at 8?
Fine.
Meet at 9. Before that time, you'll get the draft instructions from me and an updated verdict form. And we'll be able to think it through.
Doing this the way we're going to do it, we'll use some time to go through those before I pass them on to the court.
Okay.
And I mean, we're really looking at, I think we should keep the regular 1023 on the negligence, 1023 on the appropriate as far as medication, phrase an alternative method, but the key here is it has statutory acceptance. And then the cause question on the 1023 will probably be okay. And then it's just trying to, because I've never had the issue with DNR. That's going to be a question.
Okay, so why don't we plan on that? We'll meet at 9 o'clock tomorrow. Hopefully we'll be done early afternoon and have everything finalized. And then I'm gonna have the bailiff call the jurors to report at 8 o'clock on Thursday morning. So we'll finish everything. We're not gonna come back Thursday morning for more arguments. So whenever we leave here tomorrow, we'll be finished with verdicts and instructions.
And then closings Thursday morning.
Closing Thursday morning, and then they'll deliberate. I send them home at 5, like I told them. If they're not done at 5, if they want to stay for a couple hours, we'll get them dinner. Otherwise, they come back Friday and continue. All right. Yep. Thank you. We're adjourned.
Sorry, Judge. Is there going to be a subsequent? Okay, that'll be our working copy.
And I'll get that to you guys. I'm going to just try to clean things up a little bit. So